Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
Okay, when you're ready. North Central Judicial District is again on the record. The time is 32 minutes after the hour of 8 o'clock. Today's date is March 25th, 2025. My name is Richard L. Haggard, District Court Judge. This is the time and place set for a continuation of the State of North Dakota versus Nichole Rice trial. File is 512022CR421. Ms. Rice is present along with her counsel. State is represented by counsel. The jury is not present. We were in the middle of, I believe, Mr. Coons' testimony. Ms. Sorgan, anything before we bring in the jury?
No, Your Honor.
Mr. Sand?
No, Your Honor.
Is Mr. Coons still here? He is.
Yes, he is, Your Honor.
All right, then we'll bring in the jury, please. All right, thank you very much. Mr. Coons, you want to come on back up here, please? You're still under oath, sir. All right, Mr. Sand, you may continue.
Thank you, Your Honor. Now, Agent Coons, we were in the middle of your testimony yesterday when we broke for the day, so I'd like to resume that. We were going through the suspects that you had laid out in your prior testimony. Do you recall that?
Yes.
Okay. And the last suspect that we had wrapped up with was Michael Van. Do you recall that?
I do.
And prior to that, we had discussed Ms. Rice and Tyler Schmalz. Do you remember that?
I do.
Okay. Now, just a couple things regarding Ms. Rice. You were present in the courtroom for Sergeant Asham's testimony, correct?
Correct.
Okay. And you were present regarding her testimony that had to do with Nichole's interviews?
Yes.
Now, there's an interview from March 12th, 2022. Can you tell me a little bit about your takeaway from that interview?
That was the interview conducted in conjunction with the cold justice investigators.
Okay. Were there any, and we had previously discussed the read tactics, were that used in this interview?
Yes, that's the same one.
Can you explain that again?
So read is a school of thought of interviewing. It's designed in a way that you ask questions to get a specific response, and those responses can
Your Honor, I
indicate.
need to object at this point. There's been no foundation to qualify the witness as an expert in interrogation, specifically the read technique, just in investigations. Those are two very different fields.
A little late, Mr. Nelson. He already talked about it at 4:15 yesterday, so he may continue to answer, but you've already covered it, Mr. Sands, so can you move on?
Sure. Thank you, Your Honor. Now, you had testified previously that Sergeant Asham took the stand and stated that she wasn't familiar with the entire file. Do you remember saying that?
It did not seem to me she was familiar with the file.
Okay. Now, in this particular interview from March 12th, there's some statements regarding a bowl in the sink. Do you recall that?
I do.
In your expert opinion, can you state to the court what your takeaway was from that portion of the interview?
The bowl in the sink with the dirty water was present when Nichole was walked through the apartment.
Okay, and there's been some testimony about withholding. What is withholding?
So withholding is intentionally not releasing information about a case so that it can be used to possibly identify those responsible.
Now, there's been a lot of testimony and things presented by the state about withholding, particularly the body, the knife, the stabbing, the bowl. What's your takeaway after reviewing this interview regarding the withholdings?
Well, the bowl for sure is not something that would have been unknown to her because she saw it there when she was brought in to see if anything was missing from the apartment.
Is this something that Case Agent Asham, do you think, should have known before taking the stand?
I would think so. I mean, when you're the case agent, you got to know your case inside and out. It doesn't matter if you're splitting up responsibilities with another investigator. You know, you may split it up. I'm going to do these 6 interviews. You do these 6 interviews, but you've got to know your whole case. You've got to have a firm grasp of what you have there. If someone lies to you, how are you going to call them out on that if you're not aware of the entirety? And I'll leave it at that.
Well, it's interesting you bring up lying. There's been a lot of testimony about Nichole's inconsistencies. Do you recall hearing about that?
I do.
Especially about the timeline regarding the weekend of the murder.
Yes.
Can you please, in your expert opinion, explain to the court your expert opinion regarding the inconsistencies in that timeline?
So yes, I agree, as I said before, that there are inconsistencies. However, I feel they are irrelevant. So it boils down to she is in pocket by someone all day until about 11:30 after watching a movie with her cousin. Now, at that point, she states she goes home, sleeps on the couch, and the next thing is that she encounters her father early the next morning. So we know from the phone records that Anita was likely killed somewhere around 5 o'clock on Sunday morning the 3rd. Getting my dates mixed up here. Would be Saturday the 3rd, and the screen was found around 7:30 that same morning. So Nichole would have had to have gotten up 4:30 to get from Velva to Minot, undetected by anybody else that's in the house, commit the murder, clean up, get back home, again undetected, get back to sleep on the couch, wake up, spend the rest of the day as if nothing happened, going out on the four-wheelers, checking on the cattle, shooting gophers, whatever they did that day. And I just don't buy that.
And I apologize, in your answer, you said that you got a little confused about the days. I think it was Saturday and Sunday. Could you clear that up for the court just to make sure that we have a clear record?
Yeah, so it's Saturday the 3rd.
Are you sure about that?
I'm sorry, no, I'm not. It's Saturday is the 2nd, Sunday is the 3rd.
Okay,
Sorry.
And so that being said, and Your Honor, I apologize, I don't want it to be asked and answered, but given the fact that now it's Saturday is the 2nd, Sunday is the 3rd. Can you please, this is important, can you please state again your position on any inconsistencies in the timeline?
So again, the inconsistencies are all prior to the time in question. And the Saturday, starting at the home in Velva, going to the family event in Sykeston, going to the bar in Russo, going to the cousin's house to watch a movie, possibly once back and forth to the home in Velva to get cheese dip, and then back to the home. That all occurs Saturday. And so it's after 11:30 up until the point of the murder that's in question.
And in investigating this case, to the best of your personal knowledge, you testified about Nicole's parents' home. You testified about the bar and grill in Russo. You testified about the cousin's house where they watched the movie. How close in proximity are these places to each other?
It seems, from looking at a map, that from Velva to Sykeston is quite a ways. I don't know how long it takes to get there, but
And that's where the party was?
Yes,
on Saturday?
the going away party for the cousin heading off to Iraq. I think it's an hour and a half, 2-hour drive from there, and then back to Russo. That's another long drive, and I believe Russo is pretty close to Velva, is my understanding.
Okay. And as far as where she watched the movie and her parents' house?
My understanding it's about a 5-minute ride.
Now, the state has challenged your credibility quite a few times as an expert. That being said, how many crime scenes in your career as an FBI agent would you say you've processed?
I'm going to take a stab here, 20 to 30.
Okay. Now, there's been some testimony in this case, testimony by Sergeant Asham, when you were here regarding whether or not this break-in included a robbery. Do you recall that?
Yes.
Now, you recall Sergeant Asham testifying about Nichole doing an inventory of her own items, correct?
Correct.
Now, if items were stolen from Anita's room, who would be the best person to tell law enforcement what was missing?
Anita would, if she were available.
And what type of items, in your expert opinion, you just said that you processed, a couple dozen crime scenes. What type of items would you be looking for to be missing?
Money, jewelry, other valuables, anything really. Just anything, obviously. A TV, something that could be resold. Could be anything.
Now, the smaller stuff like cash and jewelry, and I don't mean small in value, I mean small in actual physical size. Is that something that you think Nichole would know?
I don't think so.
One more question regarding Ms. Rice. You had testified earlier that it was not impossible to rule her out as a suspect. Can you please elaborate to the court what you meant by that?
So it's not impossible. So we can't, nobody has eyes on her between 11:30 to, I think, about 8 o'clock the next morning. So her account that she went home, went to sleep, next thing she recalls is encountering her father who was up. So it's during those hours that you don't know for sure where she was at. We don't have the CSLI, the cell site location information that puts her phone anywhere. Now, just because the CSLI puts the phone somewhere doesn't mean the person's with the phone, but it's a good indication. And was it moving? Was it bouncing from tower to tower? But we don't have that. So I can't say where she was for sure, so it's not impossible.
Is it fair to say that, given your testimony regarding the timeline of events that weekend, that it's improbable, if not highly improbable?
Yes.
Now, I'd like to move back to your list. Like I said, we had gone through Nichole Rice, we had gone through Tyler Smalls, we had gone through Michael Van. There were two more names on your list, the next person being Marty Enell. Do you recall that?
I do.
Okay, tell me what you learned about Marty Enell through your investigation in this case.
Marty was the property maintenance man and was in a relationship with the property manager, Laura Knapp. He is the person who found the screen window knocked out of the frame, took it back to his shop for repair, found it while making rounds on a Sunday morning between 7 and 7:30, according to his statement.
What are your thoughts about rounding on Sunday morning?
It seems awfully early on a Sunday morning to be doing rounds, routine work.
As an investigator, what are your thoughts about a maintenance man finding a screen off of the window, curtain rods off of the window, and then throwing the rods back into the apartment?
I find it odd that more wasn't done to find out if something was wrong.
Why is that?
If I see a window broken out of the frame, maybe it's because I'm an investigator, but I'm automatically thinking break-in. And by the account that I read, he tossed the curtain rod and the curtain that was laying there with it through the open window. And I don't recall if he like hollered in or anything, but didn't notice the body that was probably, within arm's reach of him at that point, and just takes it off to a shop to repair. I find that unusual.
Now, you mentioned the screen, and there's been some testimony from in the state's case in chief that there was DNA found on the screen. It's their position that DNA was transferred from the knife. Be that as it may, as far as DNA being on the screen, can you please, in your expert opinion, explain to the court what your thoughts are on that?
So it could have come from the knife post-mortem. Clearly, it got there post-mortem because it was Anita's, but it didn't have to come from the knife. I think whoever did this came in through an unlocked door, turned it behind them, committed the act, cut the window, tried to climb through, maybe got an elbow or a foot caught on it, and pulled it the rest of the way out, and then fled. It doesn't make sense if you're going to stage a crime scene that you will cut it and then proceed to knock it out. Why would you do that?
Now, you testified about the door. Are you 100% certain that somebody came in through the door? Is there a possible other entrance?
No, I'm not 100% certain. They could have come through that window. It is possible to do.
Okay. Now, as far as the door goes, what does entrance through the door tell you about this case?
Entrance through the door tells me that they either had a key or it was unlocked or she let them in.
Any possibility of picking lock or anything like that?
Or it could have been picked, or there could have been a key under the mat, or somebody could have been given a key that we don't know about. We just don't know is the short answer.
And Marty and Enell had a key, correct?
He did.
Okay. And you testified that you reviewed the interviews of Laura Knapp in this case, correct?
Yes.
After reviewing those interviews, did you learn anything about the doorknob?
So when Anita's father came and was trying to get her attention, I have to believe that he checked to see if the door was locked, although that's not clear. He went to get the property manager to help him, who had a key, and she was able to get the door open. But there, in her statement, it's still not clear. She didn't check to see if it was unlocked before she put the key in. Now, it's a deadbolt, which is not integrated with the actual handle, which does not have a lock on it. So you can put the key in and turn it, but it could already be unlocked. Again, I just don't know. My point is it's possible that it was unlocked.
Excuse me.
I think it probably was locked, but again, I can't say for sure.
And during your review of the case, you had an opportunity to review the reenactment that police conducted, correct?
Yes.
What did you notice in that reenactment?
And you're not talking about the Spingola reenactment, right?
No, I'm talking about the reenactment by Minot Police where they went in and out of the court scene, where they went in and out of the screen. There was a couple detectives, and then they had a female staff member help them with it.
Correct. Yeah, it's possible to do. And, you know, there is debris under there, but also as stated and in the pictures, you can see the bed is right there. You don't have to touch the floor to get in there.
And we're going to get into Devon Hall in a little bit, but after reviewing the case, it sounds like Devon Hall's a professional break-in guy. Is this something that would be difficult for somebody like him?
Hard to say. It's hard to say that he's a professional, as the prosecution stated. He's not real good at it. He gets caught. But, you know, he was a young guy at the time. I think it's definitely a possibility.
Now, what did you learn about Marty Enell's personal life after reviewing the case?
He had issues in his personal life, reported to be an alcoholic, had been in and out of jail, some minor drug use, relationship issues. It was reported that he was never the same after Anita died. He had a collection of knives that he kept in a box. And at one point, he told his best friend, Vern Olson, that he had done something really bad, but didn't elaborate on that. And it was the next day that he killed himself.
And it's fair to say, after reviewing the file, that Marty said that he was never the same after Anita's death?
That's what he told Vern Olson in the audio that I listened to.
Now, Sergeant Asham had also testified that Marty had no means to commit this crime. What are your thoughts on that statement?
Can you repeat, please?
Yes, Sergeant Asham had testified earlier that Marty Enell had no means to commit this crime. What are your thoughts on that statement?
I'm not even sure what that means.
Okay. As an investigator, do you think that Marty had the ability and the access to be in that apartment?
Yes.
Now, moving on to the final suspect that you had mentioned, Mr. Hall. What did you learn about Devon Hall in your course of reviewing this case?
So Devon Hall arrived in Minot on June 2nd. There's some dispute on that, but by everything that I've reviewed, it's my assertion that he arrived in Minot on or before June 2nd.
Okay. Now, you testified that there's been testimony about June 2nd. Do you mean that there's been testimony that he arrived the following day?
Yes.
Okay. Why do you think that he arrived on June 2nd or earlier?
Well, he said so in his first interview, and then later changed it to, well, it was the 2nd or 3rd, and then later changed it to, well, it was the 3rd or the 4th. I reviewed documents and listened to testimony that Nova Wetsit, I believe his aunt, said no, it was on the 3rd and provided a video in support of that. However, the time stamp on that video is, I believe, January 1st of 2000. So the date had not been set. There's nothing to indicate on that video what the date was that it was recorded. And the copy that I read is a digital copy of an analog tape. So it was VHS, it's been converted into digital. There's no metadata, there's nothing to authenticate the date of that. Now, I've scoured that video for any kind of clues of when it could have been taken. You know, somebody holding a doc in a newspaper or anything. You know, the print would be awfully fine, but I didn't see anything.
And this video is from the train station?
This is from this train station.
And isn't it true in the video that never shows Devon Hall getting off the train on
Objection on leading.
Overruled.
So the video shows a group of people walking from the train, but I never see him getting off of the train. So I see a group of young men, actually a lot of people, and within that group of a lot of people, this group that she seems to be focused on, and the camera is not very good. It's all over the place. I believe that's him walking away, but I don't know if he got off the train or if he met those people and is now walking to gather with his family.
And you had an opportunity during the case, or during the course of your investigation in this case, to review the train records, correct?
I did.
Do you remember them verbatim, or would it help you if I refresh your recollection?
I'll look at it.
Okay. Your Honor,
That's not the way it works. Ask him the question, Mr.
Sure, Your Honor. Do you recall looking at the train records?
I do.
Do you remember them verbatim?
No.
Still not the way to ask the question. He doesn't remember them verbatim. Do you have a question about the train records?
Sure, Your Honor.
Ask it.
After reviewing the train records, do you recall the dates that are on those train records?
There's a variety of dates, one of which is June 2nd and June 3rd.
Okay, on June 2nd, do you see Devon Hall's name on the train records?
I do not.
Do you see other people's names from his group on those train records?
I do.
Do you recall those names?
Jaron Vivier, Nova Wetsit. I believe there's a couple others, but I don't recall.
Now, that's not 100% what I'm seeing. Would it refresh your recollection if I showed you a copy?
It would.
Your Honor, may I approach?
You may.
Thank you.
Okay. Okay.
Did that refresh your recollection?
It did.
Coons? You had stated that you had seen Jaron Vivier on these records. Isn't it true that he's on these records in May, correct?
Correct.
He's not on the train in June, correct?
Yeah, correct. Yeah, he's at the very top, and that's a different date.
And after looking at this, is it fair to say, or did you see Devon Hall's name on this?
I did not.
Okay. And did you see anybody's name that you recognized?
I did.
And who's that?
There's a couple of Wetsits on there. I believe there's a Romero that I recognized. I feel like he was one of their friends or family, but I can't recall for sure.
And those two individuals were on the June 2nd train,
Correct.
which is Saturday.
Correct.
And there's been testimony that Anita wasn't killed until the early hours of Sunday morning, correct?
Correct.
So that would give that group time to get to Minot.
It would.
Whether or not Devon Hall's name's on this, if he was traveling with that group, he would have been in Minot by the 2nd.
Correct.
There's been some testimony about Mr. Hall's arrest in Minot a number of days after Anita's murder. Do you recall that?
I do.
Did you look into that at all in your review of the case file?
Yes, I did.
And what are your thoughts on that?
So on June 11th, Mr. Hall was arrested. He had broken into an apartment through the window and attempted to sexually assault a woman there. She cried out. Her boyfriend came running in, chased him back out of that window. A fight ensued. He ran away again, entered yet another apartment in the same complex, and was ultimately caught hiding in a closet with a steak knife in his back pocket.
Was he taken to jail after that?
He was.
In your review of the file, did you find anything about jail calls?
I did.
What did you find out about that?
Several jail calls were recorded to family members. I believe there were 2 family members on one call, and then there was a separate call. In both instances, he claimed the knife as his own, and not just any knife. He said that was his knife.
Now, during a review of the file, have you had an opportunity to look at photos of the murder weapon, the knife in this case?
I have.
Your Honor, may I approach?
You may.
Now, Agent Coons, I'm going to put, am I getting picked up here? Thank you. Now, Agent Coons, I'm going to show you a couple photographs that have already been entered into evidence in this case. They're State's Exhibit 7I and 7J. Can you please take a look at those for me and then let me know when you've had a chance to review them?
Yes, I've seen these.
Can you please explain to me what I just put?
This is the murder weapon, the knife that killed Anita.
Okay. And is this the knife that Devon Hall identified as being in his possession?
He did, and it's very identifiable in that it's missing the emblem on the other side. So I know a lot of these knives were made, a lot of them were sold. I don't know how many were sold in the state of North Dakota or Montana, and I don't know how many of them would be missing exactly the same medallion that he agreed was missing from his own knife. So this is the knife that Devon claimed was his.
And I'll keep those up there with you. Is the missing medallion the only thing that's unique about the state of this knife?
No.
What
I mean,
else?
it's pretty, I've never seen one like it until this case. It's a folding pocket knife. It's fairly large. It's got a decorative handle. It's kind of copper colored. There's very many things that are unique about this knife.
Now, Sergeant Asham had testified that this is a very common knife. What, in your experience as an investigator, what is the coincidence of something like this, the missing medallion, knife being used in a murder, and then another person possessing the same type of knife that had a missing medallion in a case like this?
Astronomical.
Can I have those back, please? Agent Coons, can you describe, well, first of all, have you seen photographs of Devon Hall?
I have.
Can you describe him to the court?
He's over 6 foot tall. I think 6'2", 6'3", maybe at most. 6'2", I believe. 200 plus pounds. At the time, well, can you specifically now or then?
At the time.
At the time, he looks fit, about 200 pounds, 6'2", short hair, dark hair. I don't know what color his eyes are. It matches this description given by Becky Ehrman of a person that she saw running away from the scene that night.
Now, I had asked you if you'd seen photographs. Have you also reviewed descriptions of Devon Hall in the case file and reports and such?
I have.
Now, you mentioned Becky Ehrman. There's been testimony about Ms. Ehrman seeing a man running away from the scene with what could have been a bloodied shirt, a dirtied shirt.
Yes.
What are your thoughts on that?
Again, highly coincidental that a person matching the description almost to a T of Devon Hall seen running away from the area of the crime scene with a dirty or bloody shirt is something I, as an investigator, am going to thoroughly pursue.
Now, there's been some testimony presented by the state about the criminal history of Devon Hall. Did you have a chance to look into that?
I have.
What can you tell the court?
Since Anita's death, he has been convicted of 4 counts of similar crimes on 3 separate incidences.
And what types of crimes are those?
Breaking into apartments and sexually assaulting women or attempting to.
Okay. And you mentioned earlier that when he was arrested in Minot, he was found with a knife.
Yes.
And
Different knife, but a knife, yep.
sure. Given everything that you reviewed in this case, well, strike that. I'm going to come back Your Honor. What law enforcement agencies were involved in the investigation in this case?
Multiple. There was the Minot PD, the North Dakota BCI, tribal law enforcement, and federal law enforcement, the FBI.
The FBI?
Correct.
What was the FBI's involvement in this case?
FBI was mostly a consulting role. Materials were provided to the behavioral analysis unit, which are commonly known as profilers. They were looking for assistance in identifying who might be responsible for this.
Did they have any suggestions?
They did.
What was that?
They felt the strongest suspect in this case was Devon Hall.
This is the Federal Bureau of Investigation.
It is.
Now, you might be a little biased towards the FBI, obviously spending 22 years there, but what type of weight did you garner from that when you read that in the case file?
A lot. In addition to their assessment, it was my own assessment as well, independently.
So just to follow up on that, in your expert opinion, what is Devon Hall's connection to this case?
I believe he's the most likely suspect, in my opinion, and if I were investigating this, I would tie down a lot of these loose ends that they've left open.
And you had testified earlier that this was not one of the four suspects that, when the investigation was reopened with Cole Justice and they were assisting Sergeant Asham, he was not on the list.
He was not on the list, and I was dumbfounded as to why isn't the person that appears to me as the strongest suspect not even visited in this show.
How would you rate the overall investigation in this case?
I hate to be critical, but not very good.
Why is that?
There's a lack of attention to detail. There's a lack of thoroughness. They seem to spend a lot of attention running down dead-end rabbit holes while glossing over some very important facts, details.
What, if anything, about this case piques your interest?
I don't think we have the correct person being charged, in my opinion, and being a law enforcement background and a person that investigates for a living, I would like, if given the opportunity, I would like to investigate this further. There's a lot more work to do.
Questions I have, Your Honor. Thank you very much, Agent Coons.
Which one? Mr. Nelson, do you have any cross-examination?
I do, Your Honor.
You may proceed.
Mr. Coons, do you have a Twitter handle?
I do.
Is that at @dcoons?
That sounds right.
Okay. I was looking at it this morning. I saw a tweet that you sent out on December 1st of 23. I'm going to read it to you, and you tell me if you agree with this, because it was your statement.
Okay.
A professional investigator seeks evidence, then forms conclusions. Comer, Jordan et al. Form conclusion, then seek evidence. It's like pounding a square peg into a round hole and saying, see, it fits.
Yes.
That sound accurate?
That sounds accurate.
Okay.
That's also what I see in this case.
Oh, okay. I'm glad you said that, because we're going to go through quite a few things here. Now, you testified right at the beginning yesterday that you have done, or did, approximately 100 total investigations in your time with the FBI.
It's an estimate for sure.
You were an agent for 22 years.
Yes.
That's somewhere between 4 and 5 a year.
That's probably right. It's probably on the low side, putting it that way.
Okay. On the low side, meaning that you weren't a very busy FBI agent?
No, not at all.
Okay.
The first 6 years I worked in Sioux Falls.
Mr. Coons, there wasn't a question before you.
Okay.
You did 15 murder investigations.
Roughly, yes.
With those, now since you were FBI, I'm assuming those probably took place on native reservations?
Most of them did, yes.
Okay. Now, were you the lead on those investigations?
Some of them.
How many were you the lead on?
I'm going to say 6.
6 of those?
Roughly.
Okay. Did you testify in those trials?
Yes.
Were you called the case agent in those trials?
Yes.
Did you have to listen to an expert badmouth your investigation?
Objection, argumentative, Your Honor.
Yeah, but it's a legitimate question.
I believe so. I believe a couple times.
Okay. So you've heard other people Monday morning quarterback your investigation?
Absolutely.
Okay. Now, I was a little confused on something that you testified to yesterday, and I'd like you to clarify. You said that you reviewed the entire file.
Yes.
Okay. But then you also said that some of the pages you felt weren't that important. Is that
Correct.
accurate?
That's accurate.
Some of the pages being more important than others.
Correct.
Okay. So did you personally review the whole file? Or did your team, Veracity IIR, review the whole file?
I personally at least glanced at every document.
Okay. Now you talked about false leads yesterday.
Yes.
Okay. And that there were quite a few false leads in this case.
Yes.
Did you listen to any of the testimony from Detective Goodman?
No.
Okay. So you're not aware that, for example, there was a false lead, and actually it's in the file, about a person who they thought could have done it potentially, but was in jail for 10 days on either side, or 5 days roughly on either side of the murder.
I remember something about that. I don't remember the name of the person. It's one of those things that, you have to glance at it to deem it important or not. It's probably something that I looked at, set over here in this pile.
So the answer to that is yes.
Correct.
Okay. Now, did you listen, as part of your review for this file, or for testimony today, did you watch the Laura Knapp testimony?
No.
Did you review the deposition that she gave?
No.
So you're unaware that her testimony was that the door was locked when she got there and she had to unlock the door?
Correct.
Okay. And that she tried it before and still had to unlock it?
Correct. My testimony was based on the reports that I read in the discovery.
Okay. Again, I'm going to ask you to answer only the questions that were actually asked of you. Okay? Now, Laura Knapp testified.
Your Honor, he has stated that he didn't watch the testimony of Laura Knapp.
Okay, but I'll let him ask the question first.
Let me back up just a little bit. You testified that hardware stores cut keys.
Yes.
Okay. Now, I've worked at a hardware store, so I can agree with that statement. But the testimony from Laura Knapp was that there was only one locksmith in Minot that had that key.
Okay.
So there was only one place you could get that key cut in Minot. Does that make sense?
In my
Your Honor, I'm going to object. He did not watch the testimony of Laura Knapp. I'm not sure how he has personal knowledge of this. The witness has to have personal knowledge.
Overruled. He said specifically, ask him if he knew that, and if his answer is no, then he can't go on. So overruled.
Okay,
Keep going.
Okay.
He's a big guy, Mr. Sand. He can answer his questions,
Thank you, Your Honor.
if he can.
So I take it you're also unaware that she said that, or testified that you could only get that key cut with permission.
I'm not aware of that testimony.
Okay. I'm going to come back to something here because something that popped up at the very end of your testimony was that you felt that the Minot Police Department was, I'm not sure if I'm paraphrasing here, but glossing over important facts.
Yes.
You don't think that you can only get the key cut from one person and it has to be by permission is an important fact in this case?
It is if it could be determined.
That's
Factual.
a yes or no question.
Yes.
Okay, so we agree it's an important fact.
Yes.
And you pretty much glossed over that, didn't you?
Yes.
Okay. Now, you've looked at a map of North Dakota.
I have.
Okay. And you know that Sykeston and Carrington are not the same place.
No, correct. I'm aware of that.
Okay. Just like Grand Forks, Fargo, Minot, Bismarck, they're not the same place.
Correct.
Okay. Do you know how far apart they are?
I don't for sure, but it's my understanding they're nearby.
Is this your first time visiting North Dakota?
Probably.
Okay. So you're not that familiar with our state?
No.
All right. Now, you testified about Nichole's statements, and you pretty much have to believe everything Nichole says for her story to make sense, don't you?
No.
Why not?
I concede that there are inconsistencies in her statement.
Okay, so the story changed.
It did.
Okay. Do you think that a person who is potentially suspected of murder would know the story?
Yes.
Okay. But her story changed.
It did.
Okay. Now you testified about that she never went back to Minot, but by reviewing the case file, you know there's a statement in there that she did return to Minot.
One witness said that, yes.
Okay. So is that the reason why you said you can't rule out Nichole as the murderer?
Well, the reason you can't rule her out is because we really...
Again, that's a yes or no
You
question.
gotta let him answer, Your Honor.
Okay, it is a yes or no answer. We'll do that
Can you
first.
repeat, please?
Sure. Is that the reason you can't rule her out?
No,
Are there other reasons you can't rule her out?
there are.
Okay. Have you been to that farm outside Belleville?
I have not.
Have you driven? So you haven't been to that farm. Would it follow that you haven't driven from that farm to the apartment in North Minot?
I have not.
Okay. Now, you testified about the statement given to William May and the other people at that party. You recall that from yesterday?
I do.
Do you recall the statement that the defendant gave to William May and the other people at that party saying, "I did it"?
Can you repeat that, please?
That the defendant said, "I did it."
Yes.
Okay. And you discount that because there's no record of that phone call being made to the Minot Police Department as testified by William May.
No. I don't discount it.
You don't discount it.
No.
So you believe William May.
No. I just don't discount it.
Okay.
It's a piece of the puzzle.
A piece of the puzzle. Did you watch William May's testimony?
No.
Okay. So don't know that he said when he talked to her the next day, she didn't deny killing Anita. She denied saying that she killed Anita.
All I know about what Willie May said is from the discovery in his prior statement.
Okay. So that's a no, you don't know that.
Correct.
Okay. Are you a proponent of the Reed style technique?
Certain aspects of it, not in
Okay.
its entirety.
Not in its entirety, but certain aspects.
Correct.
So you think it's if you think that certain aspects of it are good, that it has some usefulness in law enforcement.
Yes.
So do you think there was any issue with detectives using the Reed technique?
No,
Okay. So that's not a problem for you.
it is not.
All right. Now you testified about Tyler Schmaltz next. Do you recall that testimony?
Yes.
Okay. And that Anita kept him in the friend zone.
Yes.
And you testified about his Facebook.
Yes.
Now you looked at the Facebook video and talked about the drawing that he made when I believe you testified he would have been about 10.
6th grade, whatever that is.
Okay. And you said, I believe it's in your report as well here, that a person suspected of murder potentially would not do that.
I don't think that's exactly what I put, but
Let me take a look here. Extremely inappropriate considering he knows he is a suspect of a stabbing murder.
yes,
That sounds like you?
that's me.
Okay. You think it's inappropriate to say something about, for him to have a stabbing thing?
For him to say what?
For him to have a stabbing thing that's Friday the 13th or whatever it is?
I think it's unusual, yes.
Okay. So let me ask you something. When you were on direct there a moment ago, let me find my notes. Didn't you say to Mr. Sand over there that you were going to take a stab at something?
In meaning, I guess, yes.
Okay. You think that's appropriate in a case that involves a stabbing murder?
That was a poor choice of words, yes.
Okay. But you're an experienced investigator. 22 years as a law enforcement officer with the not with the Minot Police Department of Old Habits there, with the Federal Bureau of Investigation, and you would let something like that slip in trial?
Apparently.
Okay. You're aware that horror movies are big business.
I don't know anything about that.
You don't drive by movie theaters and see that they have horror movies or see ads on
I
TV?
know they exist. I don't know about their big business.
Okay. They are, could we agree that they're a relatively popular genre, just like an action movie or romantic comedy, thing like that?
I'll agree to that.
Okay. So is it unusual for a person to like that sort of?
No,
Okay. Do you watch those movies?
I have.
Okay. Now, you testified at length about self-site location information.
Yes.
In your time with the FBI, did you procure cell site information?
Yes.
How did you do that? Did you do that in 2007, let's say?
I might have. I don't know for sure.
Okay. 2008?
I don't know the details, no. I've used it many times.
But you can't tell us when.
I can't tell you when.
Did you get that by subpoena or search warrant?
I believe I get those by search warrant.
Since when?
It just depends on the case. I may be incorrect. It may be just a subpoena is necessary for those. It depends on if you're going to get it from the phone and you're going to extract it using a Cellbrite or something similar. You have to have a search warrant for that. If you're going to get it from the phone company, it's a subpoena.
Cell site information comes from the phone carriers. You testified to that.
Yes. But
Okay.
you can also get it extracted from the phone itself.
But that's not what we're talking about. We're
Okay.
talking about the cell site information, which comes from the carriers.
Correct.
Okay. And you testified just now that you can get that by subpoena.
Yes.
Okay. You left the FBI in 2018?
Yes.
Are you aware about the Carpenter decision came down in 2015?
No.
The Carpenter decision was
Your
the
Honor,
U.S.
he
Supreme Court.
testified no.
Yeah, now he's going to tell him what it is, so overruled.
The Carpenter decision was the U.S. Supreme Court saying that that information was very private and can only be received through a search warrant. That was 3 years before you left the FBI, and you're unaware of that.
I'm not aware of that.
So were you violating people's rights in the last 3 years of your FBI career?
No.
Okay. So you already testified you weren't watching the testimony of Detective Goodman. I take it you were also not watching the testimony of Detective Barnard?
No, I was under sequestration at that time.
Okay. So you weren't here or watching to hear that that bowl in the sink was emptied when they processed the crime scene?
No.
That bowl, that they processed the crime scene on the 4th of June.
I wasn't here.
Okay. But you testified that the defendant saw that bowl.
Yes.
that walkthrough with the defendant occurred after they processed the scene. You'd agree with that?
Yes.
Okay. So there's really no way that she could have seen that bowl if they would have emptied it and moved it. Is that accurate?
All I know is what I read in the transcript of Asham's interview with her.
I'm asking you a logical question here. If they dumped that water into a couple of water bottles, as was testified to, and they had that bowl in evidence, would there have been any way for the defendant to see that bowl without knowing that that bowl was there ahead of time?
No.
Okay. You testified that it was quite a way to go from Velva to Sykeston.
A couple hours, I believe.
Okay. But you haven't personally driven that.
I have not.
Just like you said, it was a long drive to Russo.
Depends on from where. If you're coming from Sykeston to Russo, I would
Okay.
consider that a long way.
And you haven't driven that either.
I have not.
Okay. So because you weren't here and didn't watch the testimony, are you unaware that there was money visibly there in Anita's purse?
I don't recall that detail.
Okay. That would have been in the file as well.
I'm scanning my memory banks here. I believe I do remember that nothing appeared to be missing from her purse.
Okay. You don't recall that there was money that was visible in her purse?
I don't recall that, no.
Okay. Are you glossing over an important fact there again?
Yes.
Okay. Now you testified. Now we'll just move on here. Let's talk about Marty here. Your testimony was that Marty found that screen on Sunday morning when he was doing the rounds between 7 and 7:30.
Yes.
Okay. You found that odd.
Yes.
I found that odd too because he found the screen on Monday morning, the 4th.
Okay.
You testified it was the 3rd.
Okay.
So are you getting the facts wrong again?
Apparently I did on that one.
Okay. Let me ask you something. You reviewed Marty's history?
Some of it, yes.
Okay. Now, Marty had some issues with law enforcement, didn't he?
Yes.
As far as being arrested a couple times.
Correct.
Okay. Was he an officer with any law enforcement agency?
Not to my knowledge.
Okay. Now, you're an expert in investigations.
Yes.
That means that you have specialized knowledge that the rest of the world doesn't have.
Correct.
You probably have knowledge that I don't have, and I fully admit that.
Okay.
Okay. Marty wasn't an investigator, was he?
No.
So he wouldn't have the same knowledge or basis for understanding things that you have.
No.
So, based on the fact that Marty clearly doesn't have a law enforcement background, why would you think he should have thought a crime took place here?
A screen broken out of a window that's also been cut. I think it doesn't take an FBI agent to feel that something might be wrong.
You haven't actually seen the screen itself, have you?
Not physically, no.
Okay.
Pictures only.
So you don't know if it's a cheap aluminum screen.
It appears to be, but I don't know.
Okay. Now, the testimony that we've gotten in this trial, and it's in that reenactment video, because you've watched that reenactment video, you said.
Correct.
And you heard Marty's voice in that video?
I don't recall.
Okay. Do you recall someone saying that the screen was in the window?
I think so, yes. That sounds
Okay.
right.
And that was testified earlier that was Marty's voice.
Okay.
Okay. So, Marty told law enforcement that that screen was found inside the window.
Okay.
Okay. Now, do you have any way of knowing how often Marty would have had to replace screens at that apartment complex?
I don't. And can I ask a question?
No.
Okay.
I get to ask the questions here. Let me just back up. You would have no way of knowing how often Marty had to replace screens at that.
No.
Okay. Which means you wouldn't have any way of knowing if that was a common occurrence.
No.
Based on that, do you think it's possible that Marty didn't think anything of having you replace a screen?
Can you repeat that?
Based on the fact that you just testified, you don't know how often that Marty had to replace screens.
Correct.
And you just said it looked like it was a cheap aluminum screen.
Correct.
All right. You've been down to a Home Depot or Menards, Lowe's, what we've got around here.
Yes.
You've seen those screens.
I have.
Okay. And those kind of bend easily, don't they?
They do.
That's why they're cheap.
Yes.
Okay. Now it's a rental unit, right?
Yes.
Landlords typically put the cheapest thing in things that they can.
I think that's correct.
Okay. You've rented apartments in your life?
I have.
Okay. In your experience, did they put pretty cheap stuff in those apartments?
Often, yes.
Mine as well. Now, so you can't testify that it'd be unusual for him to take that screen to his shop. Except you did say that.
In the context of the case, if it's laying there broken, the unusual.
Mr. Coons, it was just
Okay.
we just agreed that it wasn't laying there. It was in the window.
I guess I don't understand your question.
Okay. You agree with me that we just established that Marty's statement was that the screen was inside the window.
Do you mean the screen was inside the frame, or the whole screen unit was inside the window where it should be?
We're talking about the whole unit, bent and all. Marty's statement was that it was in the window.
Okay.
That was in that video.
Okay.
So you agree with me that that's what the evidence says, that when Marty found it, it was in the window.
I guess I'm recalling it differently. I feel like it was found on the ground.
Do you think it's important where that window screen would have been?
It is. I know he picked up.
Mr. Coons, there's no
I'm sorry.
question before you right now. So I guess I'm just going to ask the same question I did before. Are you glossing over an important fact again?
No.
All right, then. You don't think that's an important fact, is that right?
It is an important fact.
I'm sorry, it is or is not?
It is an important fact.
It's an important fact, but the fact that you are discounting the person who found it where they said they found it is not?
No.
Okay. Now you do agree with me, because you testified to it on direct, that DNA had to be put there inside the screen post-mortem,
Correct.
most likely from the knife.
Possibly.
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 You've seen the pictures.
I have.
Was there visible blood stains on that screen?
Yes.
Were those visible blood stains on the whole window, or were those just in the cut?
Near the cut.
Near the cut? Or in
Including
the cut?
in the cut, yes.
Yeah. Now you talked about staging a crime scene. Do you recall that testimony?
I do.
Okay. What does it mean to stage a crime scene?
To give it the appearance of something that it's not.
Okay. So if a person committed this murder and wanted it to look like there was a break-in through the window, which would mean that the person would have to come in and out through that window. Do you agree with that? Or most likely come in and out through the window?
To make it look like they came in and out the window? Yes.
Okay. Would that potentially include wanting police to think that upon leaving they got caught up in the curtains and pulled the curtains out with them as they went through the window?
I don't think so.
You don't think so?
No.
Why?
I think logically in my mind, you would just cut it and leave it at that.
You don't think you would take the extra step to make it look like somebody really had gone through that window?
No.
Okay. Have you thought about what you would do on a murder scene like that before?
In what role?
The murderer.
If I were trying to stage it, I would cut it and just leave it to be found at some point.
Okay.
I don't want anything laying outside the window to draw attention to it sooner than it's going to be found.
Mr. Coons, again,
naturally.
there's
No,
no question for you.
There was. He was answering your question, Mr. Nelson, so let him finish it. You can finish your answer.
So if I'm the murderer and I want it to look like someone came in and out the window, I would cut the window, leave it there, knowing it's eventually going to be found, and not have anything on the ground outside drawing attention to it to be found quicker than it might otherwise be found naturally.
If Marty had staged this, do you think that he would have left the window where it was?
I don't
Screen,
know.
excuse me.
I don't know.
Would it have made more sense than him removing it, taking it to the shop?
Your Honor, he testified he didn't know, and then to follow up on an I don't know question. I don't know how he's going to be able to answer that.
Overruled. He can answer it, if he can.
I don't know, and if I'm wrong on this, I will admit that, but it was my assumption that the frame and all were on the ground.
Okay. That was your assumption, but
If
the
it's-
evidence we have in this case is
If
that
it's
that's
wrong,
not what it was.
I'll own that, yes.
Okay. Been wrong on a few things here, haven't you?
Argumentative, is that a question?
I'll withdraw that, Your Honor.
Thank you.
Okay. Now, you did testify on direct that you believe that Gordon would have checked the door when he was trying to check on Anita.
I would have if it were me, yes.
Okay. Are you a parent?
Yes.
Okay. So if you put yourself in Gordon's shoes, you would have done the same thing.
Yes.
Okay. So does it stand to reason that the door was locked and that's why he had to go find Laura?
I do believe it was locked. I just don't know for sure.
But you believe that it was locked?
Yes.
Okay. Now, the only statement, we're talking about Marty here, the only statement that Marty had a collection of knives came from a statement from a Vern Olson.
Correct.
Okay. Did you talk to Vern Olson?
I did not.
Did anyone with Veracity IIR speak to Mr. Olson?
No.
Did anyone, like an investigator for San Law, talk to Mr. Olson?
Not to my knowledge.
Maybe should have been something that should have been looked into.
If I were investigating, I would have, yes, but I was hired to review the existing investigation and weigh in on that.
So you didn't do your own investigation. You just reviewed somebody else's investigation.
Correct.
Okay. So you're aware that that part about Vern Olson saying that Marty had those knives was never verified by anyone else?
Not to my knowledge.
And you were here with when Carmen Asham testified.
I was.
And you heard Carmen Asham testify that the Minot Police Department was never able to verify that Marty had knives.
I heard her say that, yes.
Okay. Any idea where those knives might have gone?
I have no idea.
Okay. So we don't really know if he did have knives or not, or if Vern was even telling the truth.
Correct.
Okay. And we've already established that you weren't here for Laura's testimony, right?
Correct.
You didn't watch it online?
I did not.
Okay. Which means you're not aware that Laura testified that Marty didn't have knives.
I'm not aware.
Okay. Now, the testimony that Detective Asham gave yesterday, Sergeant Asham, was about Marty not having the motive, means, and opportunity. Do you recall that?
Yes.
But on direct, it was only limited to one of those three things.
Yes.
What was the only thing that was asked of you on direct?
Means.
Okay. Do you think that Marty had a motive?
Possibly.
Possibly.
He might have wanted to sexually assault her. He might have wanted to rob. I have no idea.
But you don't know.
I don't know.
These are assumptions,
Yes.
speculations.
Correct.
Okay. Are you aware of Marty ever sexually assaulting anyone?
No.
And you testified already that you looked through his criminal history.
Correct.
Okay. Now let's talk about Devon Hall. You testified that Devon Hall originally said June 2nd, arrival in Minot, and then changed it.
Correct.
Okay. And you watched that video, you testified to it. I believe you said it was originally VHS and then transmitted into digital, or I'm not exactly how sure that works, but that's how you watched it, was digitally.
Correct.
Of Devon Hall at the train station in Minot.
Yes.
Okay. Have you ever ridden the Empire Builder?
Have I ever ridden what?
The Empire Builder?
No.
Do you know what the Empire Builder is?
I do not.
The Empire Builder is the train that runs from Chicago to Seattle and Portland.
Okay.
That's the train that Devon Hall rode,
Okay.
the Amtrak train. Did you look into the Amtrak?
Some aspects of it, yes.
But you didn't bother to figure out which train it was?
I looked at the records in the discovery.
Okay. So you don't know how long the Empire Builder tends to be, do you? By that I mean how many cars?
I have no idea.
Okay. Now, I've ridden the Empire Builder quite a few times. Would you have any reason to doubt when I tell you that there's approximately 12 to 14 cars behind the locomotives on that train?
No clue about that.
Okay. Have you ever ridden Amtrak?
I have.
When was the last time you rode Amtrak?
It was a fall break. My wife's teacher, we went from Chicago to New Mexico. Southwest Chief, I believe it's called.
Okay. But the question was when?
Oh, I'm sorry. 4 or 5 years ago.
Okay. Do you recall when you bought the tickets for that you were able to choose which car you were going to be in, other than the special cars, the special rooms versus the coach?
I don't recall a lot about that. I did it online on the app, and I just told it what class we wanted, and I don't think I chose exactly what car or seat.
When you got to the train, did the conductor tell you which car you were going to get into?
No.
I'm sorry?
I don't think so, no.
The conductor didn't tell you which car to get on?
I knew which train to get on. I don't recall being told specifically to get on a certain car of that train. I just don't remember.
Now, you saw on that trip, you would have seen people coming and going, because you're talking about from Indianapolis to the southwest, it's a fair distance.
Yes.
Okay. Those people would have had to figure out where they're going to go on the train, right?
I guess.
Okay. Do you recall having a piece of paper stuck above your seat saying where you were exiting the train?
I don't recall, no.
Okay. But it's been 5 years since you were on Amtrak.
Yes.
So you really don't know how Amtrak works that much, do you?
Not very well, no.
Okay. Now, you testified that Devon Hall was not on the Amtrak records from the June 2nd and June 3rd.
Correct.
Okay. But you reviewed the entire file.
Yes.
And in that file, there were statements that he slipped a station agent $20 to get on that train without having to buy a ticket. Is that right?
Yes.
Okay. So if you slipped the station agent $20 to get on that train, would there be any record of him being on that train?
If true, no.
Okay. If true. Now you testified you did watch that video when they, in Minot,
Yes.
and you read the entire file.
I at least looked at it, yes.
Did you review the specific documents about police interviews of other individuals that were in that video?
I believe I saw some, yes.
Okay. And those people confirmed that they got off that train at about 9:30 on the 3rd of June in Minot.
Yes.
Okay. And that's the video that Devon Hall has seen outside the Amtrak station.
Yes.
Now, Devon Hall lived in Wolf Point, right?
Yes.
Do you know how long it takes to take the Amtrak from Wolf Point to Minot?
I don't.
Would you be surprised if, according to Amtrak, it takes 5 hours, 36 minutes?
Nope.
Okay, does that sound about accurate to you?
It would make sense, yes.
Okay. Now, if it takes approximately 5 hours, 36 minutes, and I corrected actually, the time that it arrived in Minot was 9:20 p.m. on the 3rd of June. Does that sound right?
Correct.
Okay. Does that mean that you would have had to leave Wolf Point at approximately 3:30 p.m. if it takes 5 hours and 36 minutes?
Yes.
Okay. You know how long it takes to drive from Wolf Point to Minot?
I don't.
You didn't Google that when you were doing your research for this case?
I don't know how long it takes to drive from Wolf Point to Minot, no.
Now, if I Googled it this morning, and Google told me it was 3 hours, 42 minutes to go from Wolf Point to Minot. Does that sound accurate?
I have no reason not to believe that, no.
Okay. The question is, does it sound accurate?
Yes.
Okay. Now, if we do a round trip there, so you multiply that by 2, 7 hours, 24-minute round trip.
Okay.
The math on that?
Yes.
Okay. So, what time do you think Anita died?
Roughly between 5 a.m. and 7 a.m.
And you think that a person that would have had to drive to Minot, commit the murder, drive back to Wolf Point, and then get on a train and come back to Minot is the most likely person to have done it? Yes?
I never said that that's how it went. No.
No.
So no.
Follow me here.
No, I don't agree with
Follow me here. You think that Devon Hall is the most likely suspect?
that. Yes.
Okay. And that's because your compatriots or former compatriots of the FBI, or part of it was because they thought it was the most likely suspect.
Yes.
Okay. If he was on that train, and multiple people gave statements that he was on that train, right?
Yes.
Okay. Did any of those people have a motive to lie?
Yes.
What was that motive?
Friends and family of his would possibly want to cover for him.
So you think that friends and family of a person accused of murder would cover for them?
It's possible.
It's possible.
It is.
So statements by the defendant's family and friends about where she was, is it possible they lied about where Nichole was?
It is possible.
Okay. Okay. Now, you testified that on that June 11th date when Devon Hall was arrested in Minot, that he had attempted sexual assault.
Yes.
That's not accurate, is it? Yeah, it was a different crime entirely, wasn't it?
Yes.
Okay, so you were wrong on that.
I'm not
It's
gonna,
okay to admit it.
I'm not going to admit to that one, no.
You're
I
not.
I think that was his intention.
You think it was his intention
Yes.
when he drunkenly went into an apartment, right? Do you know where he was staying at that time?
According to the records, he said his homeboys.
Which was at 804 Sioux Street, right?
Now, that's his aunt's, I believe.
Yeah, but that's where he was staying.
But that's not what he told investigators.
Okay. Now you remember that specifically, huh?
I do.
Okay. Is that because you thought it was a really important thing?
It was, yes.
Okay. But there's nothing in the file that indicates that he had attempted sexual assault that night, is there?
No.
Okay. But you think he did?
I think it's his intention. It was his intention.
Based on nothing? If there's nothing in the file, what are you basing that on?
The entirety of the file.
There's nothing in the file. So what are you basing that on?
His subsequent convictions for similar activities in which he broke into homes and sexually assaulted women.
When you went through the FBI Academy, did you learn about criminals escalating their behavior?
I don't recall that specifically. It's been a long time ago.
Sure. Now, do you recall getting trainings over the 22 years that you were with the FBI that might have dealt with that?
Yes.
What is escalation?
As you mature as a criminal, your acts get more and more severe.
Okay. So, is it potentially an escalation from the first break-in to subsequent ones as far as sexually assaulting someone?
Yes.
Okay. Is there anything in the file, then, that indicates he wasn't escalating?
They seem to be all similar, so I would say no, there's no escalation.
Okay. But that's just speculation on your part, isn't it?
It is.
Okay. Yeah. Has Devon Hall killed anyone?
Not to my knowledge.
Okay. Now, you testified about some jail calls regarding Devon Hall. When did those jail calls take place?
I don't remember the exact dates. I would have to refer back to the notes.
Okay. Now, your testimony was that he said it was his knife.
Yes.
Okay. Where did you get that information from?
There's a transcript in the file
Transcript of what?
of Devon's phone call to his family members.
Okay. Do you recall a interview that Detective Goodman did with Devon Hall out in Wolf Point,
Yes.
where he showed Devon Hall the knife?
Yes.
Isn't it true that Devon Hall said it looks like the knife that I had?
Yes.
Okay. But he never said in that interview that it was his knife, did it?
No.
He just said it looked like his knife.
In that interview, yes.
Okay. Now, you were here through Carmen Ashton's testimony.
Yes.
So you heard that that knife that Devon Hall thought looked like his was later turned into law enforcement.
Yes.
Okay. Now, you said that there were unique things about that knife,
Yes.
but then you said it was mass-produced.
Yes.
So exactly, help me understand how something can be both unique and mass-produced.
The missing emblem is the big thing.
Okay. This is a cheap knife, isn't it?
I don't know how much it costs.
Okay. There was testimony to that it was a cheap knife.
There was testimony to that. I don't know how much it costs.
Okay. Do you have any reason to doubt that that was a cheap knife?
Nope.
Does it look like a cheap knife?
I don't know. I haven't seen the actual physical knife. That would be helpful to know if it's cheap or not.
Now, you testified that the odds of similar knives having similar missing medallions would be astronomical.
Yes.
Okay. Now, you're aware in this file that there was a belief that there was a missing pair of blue pajama bottoms with ducks on them.
I remember that.
Okay. And where it was a pair found?
I believe those were found in trash somewhere.
Mm-hmm. So law enforcement went to the dump where the trash from this apartment complex was and found a pair
Yes.
in the same trash that came from this apartment complex.
Yes.
Were those the same pants that had belonged to Anita?
I think it was determined that they were, but I'm not sure.
Would it surprise you if you learned that those were not the same pants, that the ducks were different sizes?
It would not.
Okay. You think it's astronomical for there to be a missing pair of pants and a pair of pants that match that description found that weren't the same pants?
Yeah, it's a pretty big coincidence for sure.
Okay. So big coincidences happen sometimes.
They do.
Okay. Now, you testified on direct about Becky Ehrman talking about this person running, the running man.
Correct.
You said that night. That was your testimony.
Yes.
This murder didn't take place at night, did it?
I'm sorry?
This murder did not take place at night, did it?
It would, if it were between 5 and 7, I believe it would still be dark. So it's in the morning, but night being dark, semantics.
This is June 4 of 2007.
Okay.
When is the summer solstice?
I don't know.
June 21.
Okay.
June 21, 22, somewhere in that range. That would be how many days before this?
13, 14, something like that?
17, 18.
17, 18. Okay.
Do you know how daylight works when it gets closer to the solstice?
Days get longer.
Okay. But my question is, the amount of daylight you gain on a daily basis, are you aware that it gets shorter every day as you get closer to the solstice?
I'm not aware of exactly how it works. I don't know what the lighting conditions were at the time.
Okay. So this is not something that you've had to figure out in your 22 years as a law enforcement officer?
I've done it before on other cases, yes.
Okay. Now, Minot's a fairly northern city, isn't it?
Yes.
So Minot has, in the summertime, Minot would have a longer day than, say, Dallas, Texas.
Correct.
Okay. And you still think it was that night?
I know what time it was.
Okay.
I'm not going to comment on the
Okay.
light.
We'll move along. And you said that that was highly coincidental that somebody would be running in that area around the time of the murder.
Yes.
People go for runs, don't they?
It was described, yes.
Okay.
Sorry.
Now, you thought it was odd, or you testified, that that person that was running must have washed their hands, but they left their bloody shirt on. Explain that to me.
I didn't say anything about anyone washing their hands.
The hands were clean, according to the witness.
Is there a question?
Is
No.
that not accurate?
Now it's a question.
In the statement I read of Becky Ehrman, I don't recall her talking about his hands were clean.
Okay. Now, Nichole was the one talking about the murderer washing their hands in the sink. Do you recall that?
No.
Which would account for the bowl of water in the sink.
Okay.
Okay. Now, you testified earlier that some of the documents, and there's about 6,000 pages, 7,000. It's a lot, isn't it?
It's a lot.
Okay. Some of those pages are more valuable than others.
Correct.
I would imagine, if I was in your shoes, and correct me if I'm wrong, that the statements given by the defendant would be incredibly valuable pieces to go over.
Yes.
Would that mean that you would have spent more time on those than potentially, say, for example, the page involving the false lead about the person who was in jail the whole time?
Yes.
Okay. And you don't recall that? About Nichole saying that the murderer must have washed their hands?
I do not.
Glossed over that one, didn't you?
Answer, Your Honor.
Sustained. He does not recall.
Okay. Now, you testified, based on your knowledge of the case, that the FBI thought that Devon Hall was the most likely suspect.
Strongest suspect, yes.
Okay. Is there a difference between most likely and strongest?
No, not really.
Okay. And that would have been based on the information that the FBI was given?
Correct.
Because the FBI is not an all-knowing agency, are they?
Nope.
Okay. Just like your testimony is only based on the information that you were given.
Exactly.
And you didn't interview any of these people?
I did not.
Okay. Okay. Now, do you recall your investigative report?
Yes.
Okay. Do you recall saying in that report that the break-in that Devon Hall did on June 11 was in the same apartment complex that the murder took place in?
Yes, that's a mistake.
I'm sorry?
Yes, that's a mistake.
Okay. How far apart are they?
I don't know in terms of miles, but they're on the other side of town.
Okay. Completely different quadrants of Minot, aren't they?
Yes.
So the murder is on the North Hill, which is the north end of Minot, and Sioux Street is on the southeast portion of Minot.
That's correct.
Okay. Do you think that's an important detail?
It is.
Okay. Now, you testified, or excuse me, you wrote, let me clarify, because we're talking about the report here. You wrote that you don't think that the defendant would have had a reasonable reason for murder.
No.
What is a reasonable reason for murder?
It could be different things. What I read was petty bickering between roommates.
Okay. Now, do people, you were involved in 15 murder investigations.
Roughly.
About 6, I think you said you were the lead detective, or the lead investigator.
Yes.
Were all of those murders what you would consider reasonable murders?
Some more than others. It just depends. You know, there's infidelity is sometimes a reason. Snitching is often the reason. There's a variety of reasons, but nothing about like your alarm clock wouldn't go off.
Okay. Now, we had a murder in Minot a few years back that the reason for the murder was a TV remote control. Would that strike you as a reasonable or unreasonable murder?
Yes, unreasonable.
I'm sorry?
Unreasonable.
Unreasonable. So people sometimes kill in unreasonable circumstances.
Sometimes.
So a situation that you yourself couldn't see someone pulling the trigger, stabbing someone else could go ahead and do that.
Yes.
Okay. Testimony from Carmen Asham about the holdbacks from law enforcement.
Yes.
And those holdbacks in this case were things like that Anita was wearing a robe. You heard that?
Yes.
That how she was laying.
Yes.
That about the bowl in the sink even was a holdback.
Yes.
Okay. Now, you didn't watch let me ask you this. Did you watch the testimony from Brenda Glintz?
No,
And you weren't in court for that testimony either?
I was not.
Okay. So do you have any explanation, because Brenda testified that her niece, the defendant, told her about how Anita was laying, that she was wearing a robe, and the scene of the crime?
I don't know what she said in here.
That wasn't my question. My question is this. The testimony was that Nichole said, this is how Anita was laid on the bed. That she looked peaceful and wearing her robe, and then talking about the Tupperware in the sink. Do you have any explanation as to how the defendant could have possessed that knowledge at the time of that statement?
Your Honor, that calls for speculation. One, he wasn't here for the testimony. Two, he's asking to get inside the defendant's brain.
Yeah, but we certified him as an expert in investigation so that he can answer the question. Your objection's overruled.
Okay.
If she actually told her that, I can't explain why she would say that.
Now, that's the sort of information that could only come from someone who was in the apartment, correct?
Correct.
So the only logical explanation is that she had to have been, if that statement is true, you're with me so far?
I am.
If that statement is true and it was testified to, the only logical conclusion is that the defendant was in that apartment before she said she was.
Correct.
Was identified, wasn't he? The running man?
A runner was came forward.
And he came forward shortly after the police released the details about that?
Yes.
I believe he had the most unfortunate last name I've ever seen in my life, of Raper.
Wasn't aware of his last name, but yes, that is unfortunate.
Okay. Now you're aware of it because there's a picture of Adam Raper next to the sketch. That would have been in the discovery.
Yes.
Okay. Your report here says that the defendant sent a text message to Anita well after the time of death.
Yes.
You say it is unlikely Rice would text Knutson if she knew she was already deceased.
Correct.
Investigators very briefly considered this, but then dismissed the idea. Is that accurate?
I think he left part of it out.
I can show it to you.
Yes. They considered, can I
Hang on a
elaborate?
second. There's kind of a line here of blank.
Yeah, it didn't, when I
Didn't print
converted
right?
from Word to PDF, it put a line in there.
I think we all have that experience of putting stuff together that doesn't quite line up right.
Right.
So I commiserate with that. Now, you think that it's more likely that the defendant didn't know that Anita was dead.
That's my opinion, yes.
Based on what?
She's sending her a text well after she is deceased. It doesn't look to me as if it were a ruse or a staged text to make it look as if she was not already aware.
So that's speculation, isn't it?
It is.
Okay. You're not giving Nichole a whole lot of credit here, are you?
No, I don't think
Okay.
she's a sophisticated killer.
Okay. Now, the only statements we have from Nichole's family about where Nichole was have quite a gap in there, don't we? As far as time.
Depends on when are you referring to?
I'm talking about the date of the murder.
Okay.
There's a significant gap where it's missing from the alibi because people were sleeping, that sort of thing.
During the hours when she claims to be sleeping, yes, that's a long
Okay.
time.
So there is no actual alibi person who can testify that she never left the farm during those times.
Correct.
That time frame, was that sufficient for her to go back to the apartment and commit the murder?
It is enough time, yes.
Okay. So we don't really have an alibi for that time period, do we?
We do not.
Now you have some information that I don't have regarding a interview done of Brenda Glenn's.
Yes.
Okay. Who interviewed Brenda Glenn's?
The defense has a private investigator that did some legwork.
Okay. What was that legwork?
Interviewing a number of people, including Brenda.
Okay. So their investigator reached out to multiple people, including Brenda.
Yes. 3 that I know of.
3 that you know of.
Yes.
Who else did that investigator reach out to?
Alyssa Lyer, who is the cousin that I talked about, who traveled from the family event to the bar to her house to watch a movie, and Alyssa's mother, Joyce Anderson.
So you have no knowledge of that investigator reaching out to Devon Hall
I don't.
or Vern Olson or anyone else involved in this?
No.
Now, you're an expert in investigations.
Yes.
You certified to that starting this trial.
Yes.
Do you think that they did a decent job investigating this case?
I would say no. I would have interviewed those people.
Okay. Did they ask you who they should be interviewing?
No. My role was consultant to review the discovery.
Okay.
Your Honor, I'm going to object. Is the state implying that the defendant has an obligation to investigate this case?
No,
That's in-
it was a direct question as to whether or not his opinion is that you did a sufficient job. So I don't know if he's implying that or not. He asked the question directly and your expert answered it. So I'm
Thank
not
you,
sure
Honor.
what your objection is.
Withdrawn, Your Honor.
Next. Mr. Nelson, are you close to a stopping point?
Fairly close, Your Honor.
Okay.
Oh, I know. Take a break, we certainly can, Your Honor.
I am aware that I have that power, Mr. Nelson. I was just asking Alfred if you were close or not.
Well, I do think I have a few more questions, but I
All
would
right.
not be opposed to a break.
Then I will exercise my authority. We will take a break. The time is 10:15. We've been at it for almost a couple hours. So we will take a short break till 10:30, 15 minutes. Ladies and gentlemen of the jury, once again, I'm going to give you my admonition. Do not converse with any witnesses, any party, or any attorney in this case concerning any matter. Direct any questions.
Now, you testified that the defendant was interviewed multiple times.
Yes.
I believe it's 5 times?
Sounds right.
Okay. I'm just going to run through the list that I have. Twice on June 4th of 2007.
Okay.
Once on June 11th of 2007.
Yes.
May 6th of 2010.
Okay.
And then not until March 12th of 2022.
Correct.
Okay. Now, the statements regarding that we've heard testified to, that she did it, the details, all that took place after those 2007 interviews, correct?
Correct.
Okay. After she'd been interviewed multiple times by law enforcement. 3
Right.
times already. Correct?
Yes.
Okay. Now, assuming that Nichole is the murderer, when she's interviewed by law enforcement, would you expect her to say that she was in Minot at any of those times? Any of those 5 interviews?
No.
Why?
It does not behoove one to be near the crime scene at the time,
So you would-
especially if they're not.
Especially if they're not?
If they weren't there, yeah.
Okay. But we're assuming that she did commit the murder and for this question. Okay? You follow me?
Objection, Your Honor. The fact that
Sustained.
it's, yeah.
Okay. You wouldn't expect her to say that she had been in Minot because that would implicate her, wouldn't it?
Same objection. We're on the same line of questioning, Your Honor.
Well, the line of questioning is appropriate. The technique may not be appropriate. Can you rephrase your question, please, Mr. Nelson?
If she had stated that she was in or around Minot at the time of the murder, would that have provided law enforcement with evidence potentially connecting her to the murder?
Your Honor, speculation.
We've gotten quite a bit of speculation testimony from this witness as it is, Your Honor.
We have, and again, speculation is sufficient and appropriate with an expert. No, I'm going to overrule the objection. He can answer the question if he can, Mr. Nelson.
Can you repeat it, please?
Sure. If Nichole had told law enforcement that she would have, let me put it this way, if she had told law enforcement that she was in or around Minot at approximately the time of the murder. Follow me so far?
Yep.
Okay. If she had told law enforcement that, would that tend to make her a stronger suspect?
It would.
Okay. Now, Tyler Schmaltz and Michael Van, they were both alibied, correct?
Yes.
And you know that from your reviewing the entirety of the file?
I mean, there's some degree of alibi, yes.
Okay. But they were alibied, correct?
There are alibis, yes.
There are alibis for both of them?
Yes.
Okay. Now, when Devon Hall was arrested on June 11th,
Okay.
2007, this is the break-in in the south end of Minot that we've established was way far from their apartment on the north side.
Right.
Okay. Are you aware if he was drunk and high at that point?
I'm pretty sure he was drunk. I don't know about high.
You don't recall reading that he was high on marijuana in your review of...
I don't think he was, like, blood tested for it. I think he said that he was.
Mr. Coons, we don't blood test for marijuana. We use urine tests for marijuana. It doesn't show up in blood.
Okay. He was not tested for it. So
Are you aware of that, Mr. Coons?
yes.
Then why would you say he wasn't blood tested?
He wasn't blood tested for the alcohol nor drug tested.
The officers noted that, though, didn't they?
Yes.
Okay. Any reason to discount the officers' belief?
No.
Now, I took a look at your professional website, and it is a professional-looking website for Veracity IIR. So you did well with that.
Thank you.
Okay. That was a bit of a compliment. I wasn't trying to trap you with that. Now, on your website, I saw clips of you doing interviews, things of that nature.
Yes.
Okay. Why do you have those on your website?
Your Honor, relevance.
Mr. Nelson, you going somewhere with this?
I have just 1 or 2 questions, and I'll be done.
All right, I'll overrule the objection. Please make it connected somehow.
I will, Your Honor.
I am occasionally contacted by news media to provide my insight into whatever the incident of the day was.
Okay. So you put that up there to show that you know things about certain things, right?
Yes,
It's promoting your own business.
it is.
Okay. After this cross-examination, are you planning on putting the video of your testimony today on your website?
Your Honor, relevance to the case at hand.
It goes to his belief in what he's testifying to, Your Honor.
Asking
his
about something
credibility.
that hasn't happened.
Sustained.
I have no further questions, Your Honor.
All right. Mr. Sand, do you have any redirect?
Yes, I do, Your Honor.
You may proceed.
Thank you. Now, Mr. Coons, on cross, you were asked a lot of yes and no questions, and it sounded like you wanted to get some answers out and a chance to explain yourself regarding those yes or no answers. Does that sound fair?
It does.
Okay, well, hopefully we have an opportunity to do that. I'm going to kind of work chronologically through the state's cross, so I don't mean to be jumping around from topic to topic, but I took notes just trying to follow along with their cross, so if that happens, please excuse me. One of the first things they brought up was how many investigations that you had conducted while you were at the FBI, or how many investigations you had been a part of. Do you recall that?
Yes.
Okay, and it sounded like you were going to testify regarding the timeline of your career at the FBI. Would that be fair to say?
It's fair.
Okay, so can you tell us a little bit more about the timeline regarding investigations during your career at the FBI?
Yes. During my first 6 years in Sioux Falls, the first 4 or 5 of them were mostly crimes on Indian reservations. There was a lot of volume there. After September 11th, my focus became on counterterrorism. Very few cases, but they were long, ongoing cases at that time. In 2006, I was transferred to FBI headquarters, and that was at the time I became a supervisor. I didn't work any cases. I was program oversight for the WMD Chemical Countermeasures Unit. So for 2 years, I worked no cases of my own. And then when I went back to the field after my stint at headquarters, I was the Field Intelligence Group supervisor for I think another couple of years. So there was a 4-year period that I did not work any cases of my own. After that, I was made the team leader of Special Operations Group, which is mostly surveillance. So my team was detailed to typically keep under surveillance high priority targets such as terrorists, spies, public corruption, those kind of things. Those were not my own cases. After that, I became a human intelligence specialist, in which I recruited and developed informants to provide information for other ongoing cases. So none of those were my own. So more than half of my career, I did not have my own caseload.
And so just to be clear, your time, you said in the field, can you elaborate on what that means?
So time in the field, it can mean different things, but as a case agent, a regular special agent works cases. A supervisory special agent does not typically work cases. They supervise those who do. And then in the roles that I was placed after being a supervisor, the nature of them did not lead to me having my own caseload either.
So when you did have your own caseload, when you were in the field,
Yes.
Can you please explain to the court what years that would have been?
So that would have been after the academy. I think I showed up in Sioux Falls in the spring of 2007. I'm sorry, 97, and then so about 11 years I had a caseload.
So 97 till about 2008. Is that fair? Is that the math you gave?
97 to about 2006.
Okay. So when you were when the state attempted to discredit you regarding search warrants and the law changing in 2018, you didn't have your own caseload at that
No,
time.
I
You
was
were
not working
supervising.
my own cases at that time. I was not obtaining CSLI for myself at that time.
And CSLI, can you please explain again what that is?
Cell site location information
And that was used in this case in one particular instance, correct?
on one individual, yes.
And who again was that?
Gio Rodriguez.
But it was not used to determine the whereabouts of the accused, Ms. Rice, correct?
Correct.
What do you think of that?
It would have cleared this whole thing up.
Okay. Now, the next topic the state went on to was Tyler Schmalz and something about horror movies. Do you recall that?
I do.
You were asked about your knowledge of the horror movie industry.
Yes.
Okay. Does the fact that the horror industry is a big money business, as the state would say, affect your or change your opinion regarding Tyler Schmalz's social media posts about horror scenes with knives?
No. My point was that it seems inappropriate for someone who is suspected in a murder involving a stabbing would put that type of material up on their page.
And the next topic had to do with towns involved in this case, and it sounded like the waters got a little muddied here, so I'm going to give you an opportunity to explain yourself, because like we said, you got the yes or no answers, but you didn't get to explain yourself. So do you recall being asked questions about towns like Sykeston, towns like Russo, towns like Velva?
Yes.
Okay. Now, how did you come to learn where these towns are?
I looked at a map on Google.
Okay. And can you give us a proximity, from your best understanding for looking at that map, how close Sykeston is to Velva?
If I'm recalling correctly, it's roughly an hour and a half, 2 hours.
And
South and east, I believe.
And there, from your testimony and the testimony that you heard from Sergeant Asham, there's only one trip from Sykeston back to the Velva Russo area, correct?
Correct.
Okay, so after that trip, all of the moving around happened between Velva, between Russo, between neighbors in the Velva Russo area, correct?
Yes.
How big of an area is that?
Small.
Okay. How small, if you can testify to it, if not?
I believe I read or heard that it's roughly a 5-minute drive from Joyce Anderson's house. That's where the cousin Alyssa Lyer also lives. It's about 5 minutes from that house to the Thomas house in Velva.
You had testified yesterday about people when they go home from college. Home doesn't necessarily mean they're.
Objection, Your Honor, this is beyond the scope.
We're talking about the towns.
Overruled. He can answer it.
Talking about going home for college, and what does you testified what home meant? Can you state that again?
Well, it can mean different things was my point. And home, and I was guilty of it myself when I realized I had made a possibly confusing comment about home. In this case, there are two places she could mean, or that anyone could mean when talking about her home, where she lived in Minot, in the apartment with Anita, and her home where her parents lived and where she was raised.
The next thing that was brought up was Marty Enell. Do you remember that?
Yes.
And the state had asked you if, to the best of your knowledge, if you knew that if Marty had any investigative experience or training. Do you remember that?
Yes.
Okay. Now, regarding the testimony that was brought up by the state and yourself regarding the curtain rods being thrown back into Anita's apartment. Now, does that make any common sense to do that? As just an individual, and let alone a maintenance man?
Objection, Your Honor, as to compound question.
Yeah, Mr. Sand, can you clarify it a little bit for us, please?
Does it make common sense to you for a maintenance man to throw curtain rods and curtains back into an apartment?
I guess it could. I mean, I would assume he's going to go fix the screen, come back, reinstall the frame with the new screen in it, put the rod and the curtain back up. But the rod and the curtain don't need to be repaired, so you also don't want to just leave it on the ground. So I guess it would make sense.
And you testified that you looked at this case file, correct?
Yes.
Did you look at any pictures of the crime scene, specifically
Yes.
Anita's bedroom?
Yes.
About how far away was Anita's body from the window?
Feet. Single digits.
Single digits feet. So would it be fair to say that it wouldn't be difficult for Marty to see her body there?
Yes, especially if it was already light out, as prosecution mentioned.
Do you find it odd to throw curtains and curtain rods into an apartment that contains a dead body?
Yes.
Why is that?
I would think you would stop what you're doing and call 911.
Now, there's been a lot of questions regarding the window, whether the screen or the window was on the building itself or whether it was on the ground. Do you recall that?
I do.
Were you there at the scene?
I was not.
After you review the case file, when law enforcement showed up, it's fair to say that the window had already been, the screen and the window were not on the building, correct?
Correct.
There's been a lot of questions from the state to you regarding your, not investigation into the case file that you were provided, but investigation into this case. Do you remember that?
Yes.
Now, you were hired as an expert witness to testify regarding the contents of the case file, correct?
Correct.
Were you hired as a private investigator, or were you contracted by the state or any government entity to do your own investigation into this case?
No.
You weren't supposed to be contacting witnesses or interviewing witnesses?
No.
Driving from Sykeston to Russo or Velva?
No.
Driving from Wolf Point to Minot?
No.
Riding the train?
Nope.
Your job was to review the case file, review what you think that how their investigation was conducted, correct?
Correct.
How do you think their investigation was conducted?
Not very well. There are many loose ends that could still be.
Objection, Your Honor.
That's fine, Your Honor. I got another question.
Okay.
What would you have done differently if you were the investigator in this case?
In my opinion, there are a lot of loose ends that could still be tied down. I would do everything I could to tighten this up. It seems a little loose to me, and not just a little loose, it's loose. The knife issue, the Marty, all the stuff that we've talked about could be drilled down deeper.
Let's go piece by piece. You mentioned the knife. What about the knife?
The knife, the transcript of him talking to his family is more telling to me than his interview with law enforcement, because he's got more reason to be deceptive to law enforcement than when talking to his family. And I can almost...
Your Honor, I don't know who we're talking about when the witness says he here.
Devon Hall.
Okay, well, thanks for clarifying. Continue.
When Devon Hall speaks to his family, I can almost say this verbatim, but I'm not going to say it's verbatim because I don't have it in front of me. But he tells family members, I had that knife they showed me. I took it from Jaron's house, and I told him I lost it somewhere. That's powerful to me.
You also mentioned Marty, and I don't want to put words in your mouth. If I'm mischaracterizing your testimony, please correct me, but it sounds like you said the knife, and then you said that you would do a somewhat different investigation regarding Marty and Enell. Can you speak to that?
I would have interviewed Vern Olson again. I would have interviewed more of his family members. The interviews are a little superficial, I would say. I know the cold justice people talk to him with the locals. They're giving him the benefit of the doubt, in my opinion. I feel like you could explore that more thoroughly. I wasn't satisfied, and same with some of the other subjects.
The next point or topic that the state went over was Ms. Knapp. Do you recall that?
Yes.
Okay. And you had testified that you weren't here for Ms. Knapp's testimony, but you read her interviews and such?
Right. So I was under sequestration when she testified, but I have reviewed her statements that she gave that were included in the discovery that I was given.
What would you think if you found out that during her testimony she said that after Anita's murder, her and Marty, who were fiancés according to her testimony, never discussed Anita's murder?
Objection or leading?
It was a what question? What would you think?
Yeah, I'm going to sustain the objection. Can you reword it, please?
Sure. What, if any, thoughts would you have if you found out that Marty, Enell, and Ms. Knapp never discussed Anita's murder after the murder?
That's suspicious. That's odd.
Why is that?
Because it's a big deal. You would talk about it with your fiance.
And coworker, is that fair to say?
Yeah, I would think that's big news. I would think there would be a lot of talk amongst everybody that had anything to do with it.
Especially if the murder happened at the apartment complex that you were in charge of?
Yes, absolutely.
What, if any, thoughts would you have if you found out that Ms. Knapp testified that Marty wasn't a big drinker?
That's contrary to what other people have said, but is what it is.
I'd like to move on to the next topic the state brought up was Devon Hall. There's a little jumping around. I'm going to try to keep it at least somewhat of a flow, some type of chronological flow, but I do want to address piece by piece what the state has brought up. They brought up the train records. Now, you had testified earlier that you did not see Devon Hall in the train records, correct?
I did not see him in the actual records, no.
Okay. They tried to clear that up by saying that Devon had slipped a gate agent $20 to get on the train. Do you have any experience that that would be something that could occur?
I have no experience with that.
Okay. And you testified earlier that there's absolutely no evidence of whether physical or otherwise of Devon Hall getting off the train in the video that we're talking about, correct?
Correct.
And this is the Wested video?
Yeah, you can see him walking, but I don't see him. I've watched that several times. I don't see him coming out of a car.
And regardless, you had testified that video couldn't be accurately dated, correct?
Correct.
It said, the video said something about the year 2000?
I believe it's 1/1/2000 or something like that.
Is it fair to say that the state was attempting to prove a negative here?
That's fair.
Can you explain that, please?
I believe they're trying to suggest that he could not be responsible for the murder because they have this video, but there's no evidence that the video was taken on the day that would have precluded him from being in Minot.
So, can't trust the video, not on the train records, can't put Devon on the train on any day, correct?
No, other than the other witnesses that were in his group, or with his friends and family, I should say.
In your review of the case file, did you find any evidence of Devon actually saying that he came to Minot on the 2nd?
Yes.
Okay, can you explain that?
In his very first interview after his arrest on the 11th, he said it was the 2nd, June 2nd, 2007.
So there's been some questions and some testimony regarding when Devon Hall gets to Minot, and if the timing lines up of his ability to be able to kill Anita. If he got to Minot on the 2nd, and Anita wasn't killed until the early hours of the 3rd, he could have killed Anita, right?
Correct.
Now, you were also asked a little bit about his criminal history, and I think something came up about him having murdered anybody before. Are you basing that off of the fact that he doesn't have any murder convictions?
Yes.
Okay, but he's got several other convictions, correct?
He does.
Okay. A lot for breaking and entering, right?
Yes.
A lot of stuff with knives.
Yes.
Speaking of knives, there was, I guess, an example given by the state regarding the statement that you had given regarding how the chances of there being separate knives in this case being astronomical, that it had to be Devon's knife, correct?
Yes.
Okay, and the example that they gave had something to do with some pants that had some ducks on them, right?
Yes.
And that they were looking for these pants. They found a different pair of pants that were similar that were in a trash can, right?
Yes.
Did the example of the pants factor into the equation that the pants had been used in the commission of a murder?
No.
So there's that extra detail there, right?
Yes.
Does that add into the fact you factoring into the case that it's an astronomical coincidence that there are these two knives that are missing, medallions that are used in a murder that are, I mean, is that fair to say?
It's fair.
Now the next topic that the state talked about was the runner or the jogger. We'll call him the jogger, just to be fair. If anybody has an objection to that, I'm happy to change the characterization. You had testified when being questioned by the state that a runner had came forward, but you weren't able to explain your answer. I have no idea what your answer is going to be, but I wanted to give you the opportunity to explain what you're going to say.
Sure. In Becky Ehrman's statement, part of it was that someone was running hard, like running away from something, not just out for a jog. That's paraphrased.
In reviewing Ms. Ehrman's reports, what was that runner wearing or that jogger wearing?
White t-shirt, gym shorts, tennis shoes, clean shaven, short but not too short hair in a state of disarray. 6'2", 6 foot to 6'2", I believe, roughly 200 pounds. That's all I remember.
Anything on the shirt?
The shirt looked like it had blood or dirt on it, on the right side specifically.
How about the ethnicity?
Native American.
Now, aside from the ethnicity, I'm talking about the blood, talking about the attire the person was wearing. Is that typical characterization about somebody out for a morning jog?
No.
Is it more typical about of a characterization of somebody running away from a crime scene?
Yes.
Does that description fit any suspect in this case?
It fits Devon Hall almost exactly.
Next point that the state made was regarding Devon Hall, his location in Minot. From the time of the murder to the time of his subsequent arrest, where he broke into that other apartment. Do you recall that?
Can you repeat, please?
Sure. That was convoluted. I apologize. So the next topic we talked about was Hall's whereabouts in Minot. Do you remember that?
Yes.
Okay. Now, the state asked you some questions about the distance between Anita Knutson's apartment and where Devon was arrested, a week or so later?
Correct.
And you said you had a chance to look at these cities and towns on Google Maps, correct?
Yes.
Would you state that Minot is a vast metropolis?
It is not.
Yeah. Is it fair to say that it's reasonable for a person to get from one end of Minot to the other within a week or week and a half's time?
Yes.
And I don't mean to be funny, but is that reasonable to assume?
Yes.
The next topic that the state brought up was Brenda Glenn's, and I know that you stated you weren't here for her testimony because you were under sequestration, but that you did review her interview with Sergeant Asham and the representative from Cold Justice, correct?
Correct.
And you sat in Sergeant Asham's testimony, correct?
Yes.
And the state had asked you some questions regarding Nichole's statements.
Yes.
And that was regarding some, what they're characterizing as holdback evidence, but evidence in the case, something about the robe, something about other things from the crime scene, right?
Correct.
Now, Sergeant Asham testified that this occurred in 2008, correct?
Yes.
A year after the murder, correct?
A year after, correct.
Now, Brenda had testified that it was 4 to 6 weeks after the murder but that got cleared up by Sergeant Ashram and by the materials you reviewed in the case file, correct? That was 2008.
The materials I reviewed were 2008, yes.
And Sergeant Ashram's testimony was that the New Mexico trip was 2008, correct?
Yes.
And actually that Nichole in 2007 was in a different state. She was in Arizona.
Yes.
So there's no confusing Arizona and New Mexico. So the time frame had to be New Mexico 2008.
That's my understanding, yes.
Thank you. Next topic was statements made by Nichole's family, and the state had brought up some, and asked you some questions regarding alibi witnesses between the hours of that the murder may have occurred, correct?
Yes.
And it's your testimony earlier that Nichole had been at her parents' house somewhere around 11 p.m. on Saturday night to the following Sunday morning, when she was next seen around somewhere around 8 in the morning, around when people wake up.
That sounds right.
And the state had asked you that there was no alibi witness that Ms. Rice could produce during those hours, and you responded in the affirmative. Is that correct?
Correct.
Would it be typical for somebody to have an alibi witness during sleeping hours?
No.
Now, if she left the farm in her car, went to Minot, killed somebody, and came back, do you think there's a high probability that somebody would have saw her, that she might have woken somebody up at the farm?
Yes.
Did that happen in this case?
No.
Is there any evidence whatsoever that you've seen that Nichole went to Minot, killed somebody, and came back to her parents' house, went back to bed on the couch undetected, and went about her day the next day without anybody being the wiser?
No.
Next topic that was brought up were Nichole's interviews. I think that the state had asked you to affirm that there were 5 interviews. Do you remember that?
Yes.
The first interview being June 4th at the crime scene, correct?
Correct.
Now, you testified that you've been around a lot of crime scenes.
Yes.
Can you talk to the court about what goes on at a crime scene?
Crime scenes are it's not like TV. It's not glamorous. It's not exciting. It's a meticulous, painstaking process of first photographing everything, identifying what might be evidence, marking it, photographing it again, collecting it properly, documenting it properly, and then taking it away.
So there's a lot of processing of evidence. Is there a lot of discussion of evidence?
There is.
Okay, and if somebody was brought to the crime scene and they were around that, is it fair to say that they would hear about the circumstances of the crime?
They could, yes.
Now, you're given a lot of hypotheticals by the state, and there are a lot of assumptions made. There was an assumption about if Nichole was in Minot, could she have done this, could she have done that? Is that correct?
Yes.
Now, you reviewed the case, and would you say is it fair to say that there's strong evidence that Devon Hall was in Minot during the time of the murder?
There is.
This may sound like a very basic question. What would you rather rely on if you're an investigator that is recommending charges to law enforcement? Assumptions and hypotheticals, or strong concrete evidence?
Strong concrete evidence, of course.
No further questions, Your Honor. Thank you very much, Agent Coons.
Thank you.
Mr. Nelson, do you have any recross?
I do, Your Honor.
Something we haven't heard, though, right?
Well, stuff that was brought up on redirect here.
Which was exactly the same stuff we heard on direct and cross. So,
I just need to make sure a few things are clarified.
all right.
Help me understand your timeline. Sounds like you were an active agent as far as with the FBI for roughly 10 years or so, where you were the one that was actually doing investigations.
Let's see, so I started in Sioux Falls in the spring of '97 after the academy, and then I was transferred to Bloomington, Indiana in 2002, and then was there until 2006 when I went to headquarters. So 2006 is when I became more of a pencil pusher.
Okay. So 2006 is when you became a pencil pusher.
Correct. And then I did that for a while. Towards the end of my career, I stepped down and was working surveillance and human source development.
Now, that means that by my math, you haven't been the one responsible for investigations, as at least the FBI is concerned, since 2006, which is nearly 20 years ago.
Not as the case agent.
Okay. I was concerned about something you testified to. You said that you were supervising other agents in 2015.
Let's see, from 2006, 7, 8, 9, 10. No, that's incorrect. It's on my CV, whatever the exact years are.
Okay.
That I was
Take
a
a look here.
supervisor.
Well, the problem is that your CV only, at least the CV that I have, just says Federal Bureau of Investigation 1996 through September of 2018. It doesn't include dates.
In 2015, I would have either been working on Special Operations Group, which is mostly surveillance, or developing human sources. So I would have been a field agent at that time again.
Okay. Part of your job being in law enforcement to keep up on changes in case law?
Your Honor, this is beyond the scope of redirect, and it's been addressed.
They asked about what he was doing at the time, and I think it's quite relevant that to his expert opinion on whether or not he kept up with case law.
Your Honor, we didn't bring up case law.
They did not. It's beyond their, it was beyond their redirect.
But it has to do with his job supervising other agents.
You're questioning that he wasn't qualified to supervise other agents? Is that what you're trying to say?
What I'm questioning is experienced law enforcement keep up on case law to make sure that they're doing things the right way and that they don't get things overturned or non-prosecuted, that sort of thing.
Your
What
Honor,
I'm wondering is, if he's supervising other agents in 2015,
Was
why
he not
would
keeping up on case law? I heard the
Yes.
question.
yes?
Oh,
Goes to his
overruled. He can answer the question.
Can you repeat, please?
Sure. So you were supervising other agents around 2015.
Yes. No, I just said that I was either working on Special Operations Group, doing mostly surveillance, or I was working human source development.
Okay. But you weren't keeping up on decisions from the Supreme Court of the United States? As
In
far
those
as
in those roles,
investigations?
I would.
You need to wait till I finish my question.
Go ahead.
You weren't waiting, or excuse me. You weren't keeping up on decisions that came down from the Supreme Court of the United States regarding what you could and could not do in investigations?
Your Honor, I'm going to renew my objection. This is beyond the scope of redirect.
It goes to his training experience, Your Honor.
They had an opportunity
Again,
on cross.
Stop. We've already heard this, Mr. Nelson.
I'll move on, Your Honor.
Thank you.
Now, we've established previously that you were not present or watching online when Detective Barnard testified.
For the fourth time, we've done that.
Yes. So you did not hear Detective Barnard say that he couldn't see the body inside the window either?
No.
Okay. Do you have any reason to doubt that?
Nope.
Based on that, would there be any reason that you would expect that Marty would have seen it either when he threw the curtain and the curtain rod into the window?
I would expect someone to be more curious about why the window is out and look in, yes.
Okay. Detective Barnard was a licensed peace officer, state of North Dakota, an investigator. correct?
I will take your word for it.
All right.
yes.
You have no reason to doubt that.
No.
And Marty Enell was not an investigator.
Correct.
You seem to be putting quite a bit of weight on a layperson's interpretation versus a professional's interpretation.
Barnard should have seen it too.
Now, we've established through the redirect there that you were never at the scene on June 4th of 2007.
Nope.
So it's pure speculation that Barnard should have seen her.
Yes.
Okay. Now, you watched that reenactment video, correct?
Yes.
All right.
I don't believe I brought up the reenactment video on redirect, Your Honor.
He did not, Mr. Nelson.
Your Honor, it's more going towards that the room was dark, so it's hard to see.
I didn't bring up the lighting of the room either, Your Honor.
Sustained.
I'll move on, Your Honor. Now, you were present for Detective Carmen Asham's testimony.
Yes.
So you heard that the murder weapon, which you've got the photographs up there, is currently in evidence at the Minot Police Department.
Yes.
And you also heard testimony that the knife that Devon Hall had that was then given back to Jerome Vivier, is also in evidence at the Minot Police Department.
Your Honor, I didn't bring up physical evidence during redirect.
Sustained.
Your Honor, it was brought up about the knife.
Testimony regarding the knife was, and phone recordings were, the physical evidence of the knife and its location were not brought up, Your Honor.
The testimony on redirect was I took it from Jerome's house.
Sustained, Mr. Nelson.
Last time you took Amtrak was 5 years ago, right?
I'm sorry, I was coughing.
I have been coughing a lot myself. I've got it. Feel free to stop by for a cough drop if you need one when we're done here.
I'm good. Thanks.
All right. Last time you took Amtrak was about 5 years ago.
Yes.
All right.
The only time.
The only time? The only time you've ever ridden Amtrak?
It is.
Your Honor, I did not ask any questions about him riding the Amtrak on redirect.
Your Honor, the question on redirect was about Devon Hall taking Amtrak, and then there was speculation from the witness. That's what I'm getting at.
No, overruled. One more time.
I will try again, Your Honor. The file says that Devon Hall made a statement that he slipped the gate guy $20 to ride the Amtrak without getting a ticket. Correct?
Yes.
Okay. Now you said that you have on redirect that you have no experience doing that.
No.
Slipping 20s? Your Honor, I'd object. That was not brought up on redirect.
That was, Your Honor.
No, that one was. He can answer the question.
So you've never slipped a $20 bill to an Amtrak person to take a ride without getting in the system?
Never.
Okay. Which means, can you testify based on your experience and your knowledge if you could or could not do that?
No.
Okay. So there's no basis for you to know that that's not something you could do?
Nope.
Okay. Defense was asking about proving a negative about the video. Do you recall that?
Yes.
Redirect? But on cross, you admitted that there are statements from the people in the video saying that they were there at that time, 9:20 p.m. on June 3rd.
Yes.
Okay. So there is corroboration for that video.
Yes.
Okay. Now that first interview that Devon Hall did that you just testified on redirect on June 11th, you recall testifying about that?
Yes.
And on my cross, you testified that Hall was, according to the file, drunk and high during that interview.
Yes.
Now, I assume that over the course of 100 or so investigations that you've done as a agent of the Federal Bureau of Investigation, that at a certain point you might have interviewed someone who was drunk and or high or both.
I might have started them. If I determine they're drunk or high, I don't continue the interview.
Why is that?
it's not going to, it's going to have problems and legally later.
You don't think that a person who's drunk or high or both is going to give a solid statement?
They might, but they might not. And if they're not in a state of mind to provide good answers, then I'm going to wait till they're sober if I am aware that they are intoxicated.
So you're aware that Devon Hall was intoxicated on June 11th when he was interviewed?
Yes.
And you're aware that in that interview is when he said that he was in Minot on June 2nd?
Yes.
But you just said that a person in that condition is in no condition to give a statement.
I would not have done it, no.
Okay. So you discount his statement from that day?
I don't discount it. I just would not have done it in the first place.
Okay.
I'm going by by the documents that I was given.
Now, you testified that Devon Hall was a terrible criminal.
I
Or
did
is
not.
a terrible criminal.
I did not say that.
I believe that was brought up on redirect, that he keeps getting caught.
Yeah, he keeps
Okay.
getting, I never said anything about him being a terrible criminal.
That might be just my notes. I
Okay.
apologize. I was trying to take notes fast and I might have shorthanded something. He keeps getting caught, doesn't he?
He does.
Do you think if he'd murdered someone that he likely would have been caught?
Possibly.
Okay. That running man that came forward, did he match the description from Becky's description?
Yes.
Okay. In your experience, when people go out for runs, things like that, do they sometimes wear grubby clothes?
I don't think so. I don't know. I don't know the answer to that. He might wear old clothes. I don't know about grubby. What do you mean by grubby?
Okay, you might wear old clothes. It might be stained.
It's possible.
Okay. You're not dressing up for court, say, when you're out for a run at a certain time in the morning.
Correct.
So you're not trying to look your best, necessarily.
Right.
Is there any evidence in the file that Devon Hall was ever on the north side of Minot?
No.
In fact, he said he wasn't on the north side of Minot, didn't he?
On the 11th?
No. Later on when he's interviewed, during the interview at Wolf Point by Detective Goodman, he said
Okay.
he was never on the north side of Minot, didn't he?
Yes.
Okay. Now, you testified that there was no evidence that the defendant came back to the farm. In other words, that she left and came back.
Depends on what you're talking about.
We're talking about the time of the murder here. You testified that there was no evidence that the defendant left the farm and returned to the farm.
Left the farm and returned to the farm?
Yes.
I mean, she went from the farm to the family gathering, to the bar, to the cousin's house, and then back to the... Do you mean back to Minot and then back to the farm? Okay.
Because this is my understanding of what your testimony was, and correct me if I'm wrong, that your testimony was that there was no evidence the defendant, the morning of the murder, left the farm, went to Minot, and returned to the farm.
Correct.
And the information that there's no evidence from that comes from the defendant's family, correct?
Correct.
Okay. You testified earlier that family has a motive to lie.
Correct.
Your Honor, that's mischaracterization. He testified that families have a motive to lie, not Ms. Rice's family.
The question was, a family has a motive to lie.
Yes, I heard the testimony. Next question, Mr. Nelson.
Those knives that we're talking about here, the knife that actually killed Anita and then the knife that was turned in by Jerome Vivier. You've seen those.
Objection,
Again,
Your Honor.
Mr. Nelson, this goes beyond their redirect.
It does not, Your Honor. During redirect, there was things brought up about the astronomical stuff about the knives.
Not the physical knife, Your Honor.
Not, all right. No, Mr. Nelson. Next question.
No further questions, Your Honor.
All right. Is your expert here by subpoena?
Your Honor, if I may, I have very brief 3 questions.
All right, Mr. Sand, go ahead.
You were asked about family members corroborating the video, but didn't you just state that family members have an inherent bias to lie?
Yes.
Would that be in the case of the video that Nova Westit took regarding the train station?
Yes.
Next question, you testified, or you were asked regarding whether it was likely that Devon Hall would have been caught, correct?
Yes.
Do we know how many crimes Devon Hall has committed that he has not been caught for?
We do not.
Final question regarding the state's question about the farm and the fact that there's no alibi witnesses. Do you recall that?
Yes.
However, you had testified that there is no cell site data regarding Ms. Rice's location, correct?
This is beyond the scope, Your Honor. Objection.
No, keep going. He can answer the question.
There is no cell site data regarding the location of Miss Rice's phone.
Is it fair to say that if she drove to Minot, there might be some cell site data that she went to Minot?
Yes.
No further questions, Your Honor.
All right, Mr. Nelson, one more chance. Anything else?
That cell site information would only be there if she actually had her phone with her. Correct?
You would still have it. It would be stationary for a period of time if she didn't have it with her and was traveling, if that's your point.
So the cell site information only comes from the phone's interaction with the cell towers.
Correct.
So if she left the phone at the farm, the phone would show that the phone was at the farm.
It would, but we'll never know that.
Okay. Now, I do want to clarify something on the video of Devon Hall at the train station on the 3rd of June. That was corroborated by people that are unrelated to Devon Hall, correct? That video took place at that time?
Your Honor, that's not what I brought up. I brought up family members.
That was, Your Honor.
We're deep in
No,
this.
he mentioned specifically the family, so I'll let him clarify it. Go ahead, Mr. Nelson.
If you mean unrelated by blood, yes.
No further questions, Your Honor.
All right.
Thank you, Your Honor.
And he's here by subpoena. Is he free to come and go?
Yes, Your Honor.
Any objections, Mr. Nelson?
No objection, Your Honor.
Thank you, sir.
Thank you.
Come and go as you please. The witness today, Mr. Sand.
Your Honor, may we approach?
You may. All right, just so we're clear on that, we had a little meeting at the bench here. Mr. Sand, is the state calling another witness?
One brief moment, Your Honor. Thank you very much, Your Honor. The defense rests.
All right. Ms. Sorgan, is the state going to be calling any rebuttal witnesses at this time? And if you need time to think about that, that'd be fine. But if you have an idea now, I would like to know.
I will need a few minutes, Your Honor.
All right, I'll wait. You want to talk about it now or not?
If I could speak with Mr. Nelson and Ms. Asham out in the hallway, I'd appreciate that.
Okay.
Maybe about a 5-minute recess.
Yeah, my thought is that I think I would prefer if we just broke for lunch and then came back at 1 o'clock.
Sure, that sounds great, Judge.
So the time is 11:30. Ladies and gentlemen of the jury, again, now. Please do not discuss the case. Do not allow anyone to discuss the case with you, and do not use the internet or other electronic technology in any attempt to learn information about this case or communicate with your family, friends, or anyone else about this case. And please do not form or express any opinion about this case until I have given it to you for your deliberations. I will hope to repeat this instruction at each recess. If I fail to do so, it applies to you throughout the trial. Again, I'm breaking for lunch just because it's fairly close and I'm not sure we want to start into something else. So please come back. We'll start at 1 o'clock precisely. Again, it's my understanding the defense is not going to be calling a particular witness that we had had numerous discussions on, but those discussions were not in front of the jury, as far as I know. So the jury has no inkling of your concern with regard to whether that witness is going to be called or not called. So I just wanted to make it clear on the record that the opportunity to call additional witnesses, you have decided not to do that. Is that correct?
That's correct, Your Honor.
All right. And again, what would happen now would be the rebuttal witnesses, if the state has any, they would like a few moments to do that. My thought is I'd kind of like to know that now because I'd like to go over closing instructions at some point here. We need to do that without the jury being present. So that having been said, I would like to recess us from now 11:33 till 11:45 and then come back and make a decision at that point. So we'll be in recess for 12 minutes. The jury's done till lunch. We're not yet. Okay, thank you.
Thank you, Your Honor.
You ready? All right. All right, we're back on the record. The time is 5 minutes after the hour of 1 o'clock. Today's date continues to be March 25th, 2025. Parties are present along with counsel, and the jury is not present. I'll start with you, Ms. Sorgan. Did you get your new instructions?
We did, Your Honor.
All right. Mr. Sand, did you get your new instructions?
We did, Your Honor.
All right. Anything before we bring in the jury for closing arguments? Ms. Sorgan?
No, Your Honor.
Mr. Sand?
Nothing from us, Your Honor.
Okay. Are both attorneys comfortable with what we're using for closing as far as the well, what they're going to use, the TV, et cetera? I just want to make sure nothing's going to go wacky in front
I was
of the
just going to
jury.
have Bill move. I'm sorry, I'll let them go first.
No, she says no. She's shaking her
Okay.
head.
Fine.
I was going to have Bill move the podium when they're done and I'm up.
Okay. Are you going to try and pick it up like Mr. Nelson? Or just...
No, do you want me to move it now, or?
Yes, please, because it'll just be in the way. It's not light, and we appreciate that, so I understand.
Felt like to me, but.
I am going to ask, however, that you move it out of the way until the jury, just move it to the side till the jury. Yeah, yeah, just move it to you're right there. Yeah, just so they can walk by. That'll be fine.
We want to make a big thing where we move it the whole way when they come out?
Ms. Sorgan, are you going to be using it for your closing?
I don't like podiums, Your Honor.
Okay, then.
Would it be all right if we maybe moved it right here, just so
I think that'll be fine, Mr. Nelson. Just put it there for now.
There's nothing like, there's no cords or anything, so slides are real easy.
Okay. All right, then. Go ahead and bring in the jury. I really got more carried away than I wanted. Sorry. Thank you very much. Please have a seat. Ms. Sorgan, do you waive roll call of the jury?
State waives roll call, Your Honor.
Mr. Sand, do you waive roll call of the jury?
We do as well, Your Honor.
Thank you very much. Ladies and gentlemen of the jury, both parties have rested. We are now going to do closing arguments. Ms. Sorgan, do you wish to make a closing argument?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. You got me, Colette? Okay.
TV on?
Make sure it will be. Good afternoon, ladies and gentlemen of the jury. Thank you very much for your patience. It's been a long 7 days that we've been here together. Make sure that that television's on too. Or not. There we go. Okay. Now we're cooking. You've been here listening to testimony for about a week now. There's a lot of information in this case. As you heard from the witnesses, over 6,000 pages of documents, hundreds of hours of audio and video, photographs too numerous to count. So we've prepared a little bit of a PowerPoint here to help consolidate in putting together the state's closing argument. Mr. Nelson. Okay. You were told an investigation is like a puzzle. You heard that from a couple of different people. It's not solved by one person alone. Everyone's got a little piece, Every witness that we presented to you during the course of this past week has had a little piece of that puzzle. Some pieces are bigger than others. All the pieces are important, though. Some of those pieces give more information than other pieces do. If you're thinking about a jigsaw puzzle and you're looking at that, some of those edge pieces have to be laid out first before you start getting towards the center so that you can start seeing what that bigger picture is. Next. You heard from Sharon Knutson, Anita's mom. You heard that Anita was attending MSU to be an elementary teacher after she graduated from Velva High School. She worked 2 jobs, Vanity in the mall and the Fairfield Inn. Anita had a boyfriend in California that she spoke with on the phone. And Anita and Sharon used to go shopping together every weekend, and they spoke regularly on the phone. But that Anita didn't want Sharon to come to the apartment that she shared with the defendant because of the issues that the girls were having. You heard Sharon tell you that Anita seemed afraid of Nichole. And that Anita had Sharon put a lock, or had Gordon put a lock on her bedroom door so that she could get away from Nichole when things were getting bad between them in that apartment. Sharon told you that she last spoke with Anita the Friday before she died. That Anita had been out with her friend Michelle. You heard Sharon say that she couldn't reach Anita. She couldn't reach her in person. She couldn't reach her through work. And she became very concerned. And so that when Gordon went to Minot on Monday, she wanted him to check on her. You also heard Sharon tell you about the devastating effect that Anita's death has had on this family, including the suicide of her brother Daniel a few years later. You heard Sharon herself tell you what her own mental state was like following Anita's death, and that she had a lot of blank moments in those instances. Next, please. You heard the testimony from Gordon, Anita's father, that he drove to Minot on June 4th, 2007. I'm getting a lot of feedback and echo. And that he checked in on Anita because Sharon asked him to, because Sharon hadn't been able to get a hold of him, get a hold of her. That he found Anita's apartment door locked. And so he went to go find the manager of the apartment building.
I think she's getting feedback.
Yes, we're getting a lot of feedback.
Can you just turn that one off?
Okay, let's see if that works a little bit better.
Thank you. Sorry, Ms. Sorgan.
That's not a problem, Your Honor. Technology. We've got gremlins. Okay. Gordon went to go find the manager of the apartment building because he couldn't get in because the door was locked. That manager was Laura Knapp, who unlocked the door to the apartment. Gordon told you that he found Anita dead, cold to the touch, in her bedroom. You next heard from Laura Knapp, the manager of the Northgate Apartments. Gordon came to her and locked that apartment, and she did. You also heard Laura tell you a lot of information about those locks. That these were specialty locks, had to go through Shook's, the locksmithing company, because these were specialty locks. Heavy duty specialty locks. And that the only people who were issued keys for these apartments were the tenants on the lease, the manager, which was Laura, and maintenance, Marty. And that in order to get a copy made of that key, you couldn't just go to a locksmith. There were no key kiosks. You had to go through management. because you had to go to a special locksmith to get that key copied. And Laura told you that there was never a request received for a copy of apartment number 5. Laura told you that she distinctly remembers hearing the tumblers click in that lock, that she tried the door first to open it, and it was locked, and that she put a key in the lock, turned the key, and heard the tumblers click. And then the door opened. You also heard Laura tell you about Marty, the maintenance man, who was there when Gordon came to find Laura to get the key. And that Marty was there because he and Laura lived together. And they'd lived together for about 10 years. They were in a relationship. Marty was the maintenance man for the location. He lived in the apartment with Laura that she got as a perk of her being the manager at Northgate Apartments. Laura told you that Marty committed suicide New Year's Day 2009. She told you why. He'd had problems at work, hadn't gotten a job that he was looking for, possible diagnosis of Parkinson's, and that he had no health insurance. She told you about the death of his niece a few months prior to Marty's death, that Marty's family was not nearby. They'd all left Minot by that point. New Year's Day 2009. This was right after the holidays of 2008. Thanksgiving, Christmas. You heard Laura tell you that holidays were incredibly important to Marty, that he was usually always with his family. They were a big deal. Would it take much for you to imagine that with all of this coming down on Marty, with the holidays being a depressing time without your family, that there's a question on the timing on his suicide? You also heard Laura, who lived with Marty for 10 years, say that he did not have a knife or a knife collection, that occasionally there would be tools that he would work with. Next. We brought in a slew of officers for you. First officer on the scene. At that point in time, Patrol Officer Plessis, now Captain Plessis. He's been with Minot PD this entire time. He's familiar with the city of Minot. He's familiar with the locations throughout the city. He pointed out to you on the map where Northgate Apartments is, clear in the northwest quadrant of town, near the airport. You heard the captain tell you that he's the acting chief of the Minot PD currently, and that he was involved in the decision to bring cold justice into the investigation, to allow them to assist the investigation. This is an important distinction here. Cold justice provided resources and time that Minot PD could not allot to this cold case. After 15 years, you heard detective after detective and the captain himself tell you how busy Minot PD's caseload was, and that people just could not catch a break to be able to get the time to sit aside to go through this case. So this was a valuable resource that was available to be able to carve out that amount of time. You heard from retired Detective Strandberg. He was the one who was at the scene, taking photographs of the apartment. And through him, we received the exhibits of the exterior of the apartment building. It's exhibits 3A through 3F. And you're going to get all these exhibits. You can go through all of these at your leisure together while you're deliberating. We have photographs 4A through D, which is the ground outside of Anita's window. We have photographs, we've only picked a few, of Anita's body at the scene. States exhibits 5A and 5B. And these are incredibly important. I'm sorry, 6A and 6B. 7A. No, 6A. Yes, 6A, 6B, my typo there. Of Anita's body at the scene. In a light pink robe, face down on a dark blanket. With photographs of Anita's body after it was, or bedroom after her body was removed from the scene. And we have photographs of the screen as it was found located in Marty's shop with the cut that had been described as a backward L. And Lieutenant Strandberg also got the search warrant for Anita's phone bill to show us Anita's contact times. You heard from retired Sergeant Goodman, who's also very active in this investigation. And you learned some very important information from Sergeant Goodman. You learned there was no sign of a struggle or robbery. You learned that Anita's purse was sitting there in the bedroom with visible cash inside it, indicating no sign of a robbery. Because think about it, if someone is going to rob someplace, aren't you grabbing the visible cash out of the purse? He told you about the process of the removal of Anita's body from the scene. And again, this was highly important. He told you about the limited access of anybody to see the body, how Anita was positioned, and what she was wearing. That she was in that pink robe on that bed. Sergeant Goodman conducted a number of interviews. He also accompanied the defendant into that apartment after law enforcement processed the scene to see if anything was missing. And do you remember what he said about her reaction? Immediately, my iPod's missing. My pink iPod is missing. Without even really looking. And that this struck Sergeant Goodman as odd at the time. Sergeant Goodman also provided us with some very important information in the form of photographs that he took of Anita's cell phone. He photographed Anita's incoming and outgoing text messages, including her last outgoing text message and her last incoming text message that went unread. He also photographed the text messages between the defendant, from the defendant to Anita, complaining about that alarm clock and telling her what goes around comes around. Sergeant Goodman conducted an interview of the defendant on June 11th, 2007. And you'll have that transcript, State's Exhibit 13, to review. And he told you during his testimony that he caught the defendant in the lie during that interview about where she was at or around the time of the murder. Even though he had told her, I don't care if what you were doing was not legal. I don't care if you were smoking pot. I want to know. Don't hold anything back. And what did she do? She lied to him about her whereabouts. And she only came clean on it when he called her on it. Sergeant Goodman investigated the knife. He told you it was a cheaply made knife. It was sold in bulk. He also told you, as well as a number of other officers told you, that it was determined that the murder weapon was not the same knife that Devon Hall thought he had. You're going to hear a lot of information about that. Devon Hall thought he had that knife because the medallion was missing on one side. But remember, this was a cheap knife, a cheap folding knife. Would it come as any surprise to anybody, that something that's cheaply made might have more than one of those cheaply made knives, might have a medallion fallen off of it? I don't know if anybody's been keeping up with the news about panels falling off of Cybertrucks, and that there's a mass recall with regards to that. That's certainly not a cheaply made item, but it's happening on more than one item that was produced. Sergeant Goodman followed up on the Devon Hall lead and ruled him out. Went to Wolf Point, interviewed him. Interviewed a number of people who confirmed Devon Hall's statement that he was not in Minot on June 2nd, 2007. That he did not get there until the evening hours of June 3rd, 2007, by which point in time Anita was already dead. Next, please. You heard from Jordan Thompson, who's now with parole and probation after retiring from the Minot Police Department. You got to see the reenactment video, State's Exhibit 14. And again, you'll have access to that. What did we learn from this? That the window would not have been the point of exit. That it was extremely difficult for them to get in and out. You saw that yourselves. That it was difficult for Jordan Thompson, Dave Goodman, and Evelyn Jones, all three of them, getting in and out. The screen would have been ripped or damaged. The items below or in the windowsill would have been disturbed. You saw Evelyn sitting in the window to get in and out. You saw Jordan have to take great pains to hop around so as to try not to rip the screen out of the frame. But one other thing I want you to remember about that reenactment video. Whenever you saw somebody go into that window, they disappeared. You didn't see them. Remember that when there's a question about whether or not Anita could be seen by Marty as he's dealing with that screen, as he's just quickly plucking it out of the window and taking it back to his workshop. You heard from retired Detective Barnard, who went on to become sheriff of Ford County before he retired again, off to Arizona. He was the first detective at the scene. You heard him testify that he had to have Chuck LeBoy point the body out to him because even though he was standing right outside that window, looking in, actively looking for that body, he could not see it. He had to have it pointed out to him by another officer. He told you about the difficulty that law enforcement had in getting the defendant to come to the scene to meet with them. You heard Detective Barnard tell you what was conveyed. There's an emergency at your apartment. We need you to come home. And then you heard him tell you about her behavior when she finally did show up after law enforcement had to threaten to come get her. She had a flat affect during the notification at the scene of Anita being killed. Didn't seem concerned. And most telling to Detective Barnard, she didn't ask any questions. And that normally, when someone is told, there's an emergency at my home. What? What is it? Why are the police at my house? Why do the police need me? What is going on? No questions. Didn't ask who, what, why, What's going on? Nothing. Sergeant Barnard was present for the initial video of the apartment, which you, in conjunction with the photographs, you can see this is a tiny little apartment. Tiny little apartment. He took the first two statements, give the defendant any of the holdback information. And he told you why. We want to know what you know without influence from us. Next, please. You heard from Dale Meixner, the BCI agent, conducted an interview with the defendant on May 6, 2010. That's State's Exhibit 19. You'll have that transcript too. That also was analyzed by Sergeant Asham. Next, please. You heard from Dr. Marianne Sens, the pathologist who performed Anita's autopsy. And you'll get a copy of the autopsy report. You have it in evidence, the anatomical diagram, the photographs. And I will warn you that these are graphic photographs. And we've refrained from showing them to you thus far, but you will have them. Dr. Sens indicated that Anita had been face down shortly after her death, based on the livor mortis, the lividity, the darkening of the body, where the blood pools due to gravity. And that was how she was found. You heard Dr. Sens tell you there were no hesitation marks, and there were no defensive wounds found on Anita's hands. That Anita's cause of death was 2 stab wounds to the chest, and that one of the wounds was fatal within minutes. And she told you that that manner of death was homicide. And I also asked Dr. Sens how much force was needed in order to cause these stab wounds. And she told you not much force. It went through the cartilage, the soft part of the sternum. It didn't require somebody to be very strong or have a lot of upper body strength to do this. Next, please. You heard from Amy Gebhardt in the State Crime Lab, who analyzed the DNA. And she determined for you that the blood on the knife was Anita's blood. That gives us the murder weapon. And that the blood, or the DNA from the cut in the screen, was also Anita's. Now, Amy did mention that there was male DNA under one of Anita's fingernails. One fingernail. But that was a sample that was too small to compare. You have also heard testimony that there is no timestamp on DNA. DNA is everywhere. I could brush past you and my DNA would be on you. Next, please. You heard from Michaela Talbot, now with St. Paul PD. She was part of the new investigation. She was partnered with Sergeant Asham. They interviewed numerous witnesses. They split this investigation up. Detective Talbot handled the part of the case involving Devon Hall. And she was able to rule out Devon Hall by establishing again that he did not arrive in Minot until after Anita was dead. And she did this by talking to collateral sources, by confirming with people who were with him at that time, he was not here in Minot. Not here in Minot. I would normally be saying here in Minot if I were back in Ward County. Next, please. You heard from Matt Hansen. Matt was the defendant's boss at eTelecare. And he told you about what happened the day that they were notified of Anita's death. They didn't even tell you there was notification about Anita's death. The police called saying they needed to get a hold of Nichole. There was an emergency at her apartment. She needed to come home. What was her response? Not, what's going on? Why do the police need me? What's happening? Or, oh my goodness, I need to get there quick. It was, that's just my crackhead roommate. I'm not dealing with it. Matt didn't tell her anything about her roommate. Why'd she leap to that assumption? Then Matt told her again. The police called back. He advised the police, I've already given her the message. And the police told him that if she didn't come, they were going to come get her. Then she finally went to the scene. Matt also told you that the defendant won a sales trip because she was a good salesperson at eTelecare. But she ended up not going to it because she quit shortly thereafter. Please. Then you heard from Donna Bieland. You probably remember sitting up on the stand, wearing her visor and her sunglasses because she's got issues that cause light sensitivity. She worked next to the defendant for several months at eTelecare. At that call center, open spaces, the defendant would constantly come. She'd park herself next to Donna. And Donna remembers crystal clear that first conversation with the defendant. What do you think of a roommate who leaves her alarm clock on and locks her door? First impression. And then from there, it was constant, according to Donna. Constant complaints from Nichole about her roommate. Donna told you about the fish tank incident, that there had been 3 separate occasions, and eventually the fish died. And that the defendant reacted like Anita had crossed a line, that she went from being a bad roommate to being an evil person. Donna also told you about the day after the defendant had an interview with law enforcement, and we know from the timeline when that would have been. We know that Sergeant Goodman interviewed her on June 11th. We know that the defendant had been interviewed on June 4th initially at the scene, but that she didn't go back to work on June 5th. So we know it wasn't the day after that interview. Interview with Goodman, June 11th. Which means that she spoke to Donna on June 12th, because the next interview with law enforcement wasn't until 2010, and she wasn't working at eTelecare at that time. Why would I need to cut a screen? I had a key. I wouldn't need to do that to get at her. Remember the holdbacks. Remember that the defendant never saw that screen on the window. Law enforcement never saw the screen on the window. They were led to it by Marty and Enell. And you will get the transcripts from June 4th and June 11th, her interviews with law enforcement. Not once is that screen mentioned in those interviews. Not once. But she tells Donna, they think I did it. I wouldn't need to cut a screen. I had a key. And she told Donna, I'll be okay as long as I keep my mouth shut. And you heard Donna's impression that she thinks at that point the defendant said too much, because then she said, you do not want to make me mad. Donna didn't realize that she was even talking to her at that point. But the defendant was looking right at Donna. You do not want to make me mad. Next. You heard from April, one of the friends. She told you that following another one of the defendant's interviews with law enforcement, the only thing she seemed concerned about was her missing iPod. My pink iPod better not be missing. Next. You heard from Michelle, another friend. Michelle gave us a timeline. She was with Anita the Friday before she died. Michelle went and got a tattoo. Anita chickened out. She was supposed to get one too. And then the girls went to Schatz Crossroads, the truck stop, for a meal afterward. Why is that important? Because when the officers were interviewing and talking to Tyler, Tyler mentioned that Anita was going to a truck stop. She went with Michelle. Next. William May, the defendant's former boyfriend, was present at a party, a house party that he was having. And the defendant was drunk. She was intoxicated. But she said, I did it. I killed Anita. Mr. May told you about how he went to the police with this information. And we acknowledge there is no record of this interview. We acknowledge that. But he did tell you as well that the next day, he asked the defendant about that statement. She didn't deny killing Anita. She denied saying the statement. There's a big distinction there. Next, please. You heard from Christina Holler, formerly Christina Imhoff. House party, defendant drunk, being picked on about Anita's death. She gave the defendant a ride home, and then they talked in the defendant's apartment, where the defendant told her, I was fighting with my roommate over an alarm clock. She was wearing a white bathrobe. I stabbed my roommate. They had a falling out because the defendant was possessive and angry. Ms. Holler also said she went to the police before. Again, we acknowledge there's no record of that. But this was before the two had a falling out. Now, the defense is probably going to tell you that some of this information from some of these witnesses is largely influenced by cold justice and the airing of the documentary. You saw those pictures of Anita wearing a pink bathrobe. If Christina was trying to comport her information to what was learned through cold justice or to the evidence, wouldn't she have said that bathrobe was pink? She told you what she remembered the defendant telling her, that it was white. That was her memory of what was said to her. Fighting over an alarm clock. My roommate was in a white bathrobe. I stabbed her. Next, please. You heard from Connie Euland. And these were a little disjointed because we had to fly people in from out of town. We couldn't get Connie here until yesterday. Connie's Marty's sister. She also reiterated Marty had no family living nearby in Minot at around the time of his death. Mom had moved away. Connie was living in Minnesota. She confirmed the death of her niece, of Marty's niece, a few months before Marty's death, just like Laura told you about. She confirmed that holidays were very important to Marty, that he was the best gift giver. She told you about their family history of alcoholism and of suicide. But she also gave you some additional information. That Marty was having problems with Laura. That Laura showed up with another man at the funeral, after Marty's funeral. What was Marty losing by that? The love of his life that he'd been with for 10 years. The apartment that he lived in, because that was Laura's through Northgate Apartments. And his job, because Laura was his boss, because she was the manager and he was just the maintenance man. And when Connie was asked what losing Laura would do to Marty, she said it would crush him. It would crush him. Add that to what you already know from Laura of what was going on in Marty's life at around the time of Marty's suicide. All of this compounding itself. Is it any wonder that the man committed suicide? Next, please. You heard from Robin Thompson, another friend that we had to fly in. Friend of both Anita's and the defendant's from high school. After Anita's death, she found that the defendant had one of Anita's stuffed toys in her closet and asked her about it. And she also told you that at the funeral, or after the funeral, the defendant told her that Money Mike was talking about that he had killed Anita at the funeral. Next, please. You heard from Mark and Brenda Glynns. This is the defendant's aunt and uncle. Brenda was the defendant's other mama. You heard her tell that. And you could see how difficult this was for Brenda up on the stand, testifying as to this, talking against her own blood, against the girl that she was incredibly close to for a number of years. She told you about a trip that she took back from New Mexico after rodeo finals with Nichole, in Nichole's car to move her back from New Mexico to North Dakota. And they talked about this case because they were in the car together for a couple days. And they were very close. And that the defendant told Brenda that she would never get the image of Anita out of her head, laying there so peaceful in her robe covered up. She told her aunt about the bowl in the bathroom sink, and that the killer washed their hands and cleaned up the knife afterward. She told her aunt that the killer laid in wait in Nichole's bedroom for Anita to get out of the shower and then attacked her. And she also told her Aunt Brenda that she had gone back to Minot after she went to the 41 Club to get close. And we know from investigation that the defendant went to the 41 Club Saturday night and was there late. And you could tell that this was incredibly difficult for Brenda to express. The defendant would refer to Anita as a fucking bitch, a fucking cunt. You heard Mark corroborate that Brenda took that trip for rodeo and that he was also present at a time when the murder was discussed. And one of the cousins asked Nichole if she was okay. And if the defendant's response was, she was fine. I never really liked Anita anyway. Next, please. Last state's witness, Sergeant Asham. She analyzed the phone records of Anita and of the defendant. Both of these are in evidence. She went through these photographs from Sergeant Goodman, determining when was the last message sent from Anita, when was the last message received that she never opened, confirming that Anita was most definitely still alive as of 2 a.m. on Sunday morning the 3rd, because she'd had a phone call with her boyfriend out in California, and he recognized her voice. She conducted another interview of the defendant on March 12th, 2022. You'll have that transcript as well. And she reviewed the defendant's prior statements to the other detectives over the years, as well as her statements to her Aunt Brenda. Yep. Mr. Nelson switching this over for me, because we have another PowerPoint for you on this one. The timeline of these statements. Timeline 1. The June 4th, 2007 statements to Detective Barnard, where the defendant says she was at that point in time. Timeline number 2, the June 11th, 2007 statements to Sergeant Goodman. Where was she then? Timeline 3, the May 6, 2010 statements to Agent Meixner. Where was she? And timeline number 4, the March 12th, 2022 statement to Sergeant Asham. As you can see, there's a lot of gap here. We're looking at June 1st, 2007. Indicates at about 11:15 p.m. the defendant arrived back at the apartment. On June 4th, 2007, she said she got home, she heard Anita in her room, but didn't see her. June 11th, she returned home from work and heard Anita talking with someone. In 2010, she said she saw Anita at the fridge getting something to eat. And on the 4th, she didn't even remember if Anita was home. 1 a.m. on May 6th, the 2010 interview, she heard Anita open the front door. It's the only time she ever mentions this. Got up at 7 a.m., left for Velva without seeing Anita because her door was closed. Next one on that, please. Okay. We have varying timelines of when she arrived in Velva, when she was in Sykeston. The timeline number 4 from March 12th, the gray one. Unclear of the beginning time when she went to Sykeston. This is when we start getting things a little bit fuzzy here as to where she was and who she was with. We've got all sorts of different stories. As you can see from the May 6th timeline, arrived at the farm, fell asleep on the couch. No specified timeline at the Russo 41 Club. Watching movies with Alyssa, went back to sleep on the couch. Timeline number 4 here. Went to Russo until 11 p.m., never mentions going to Alyssa's house at all. Next, please. Inconsistent across the board of where she was on June 3rd and what she was doing until she went to work to be at work on time on June 4th. If you could back up one more, please, Chris. Oh, could you go back a slide? Sorry. Thank you. Appreciate that. All right. Now, as you heard the defense's own expert testify, no one had eyes on the defendant from about 11:30 p.m. until 8:30 the next morning. You heard officers testify how far of a drive it is from that farm in Velva to Minot, to the apartment. It's about 40 minutes. She had a window of opportunity of 9.5 hours. Go back to the right slide, please. Sorry, I'm making him do all sorts of technical stuff. Okay. Next slide, please. Okay. So bringing it all together for you. First step, we establish means, motive, and opportunity. Means is the ability to have committed the crime. Motive, the reason why a crime was committed. Now, we don't have to prove motive to you. Sometimes it's helpful in determining someone's intent. An opportunity, the time or availability to have committed the crime. Next. Step 2, review of the persons of interest in this case. We look at people's alibis. We look at their means, their motive, and their opportunity. And they are excluded by investigative tools. Please. So person of interest number 1, Tyler Schmaltz. The investigation showed you he hadn't spoken with Anita on the phone or texted with her in over a month. It also showed he moved into the apartment complex at Northgate before Anita did. He was living with his brother, who also alibied him, as well as people that he was playing online games with. He had no opportunity to do this. And he's been an active voice for justice for Anita for over the years. We've heard that testimony as well. Next, please. Next person we look to is Michael Van, Money Mike. He was interested in dating Anita. They're getting to know each other. He didn't have a motive to kill her. The last text message he sent at 4:53 a.m., you don't answer, went unread. It's the last message was sent to Anita that she hadn't opened. That gives us a timeline. Money Mike, through the investigation, was alibied by his friends. He was at a party. No opportunity to have committed this murder. And no means. He didn't know where Anita lived. The investigation concluded he didn't know where she lived. No means, no motive, no opportunity. Michael Van's out. Next, please. Next person of interest is Marty Enell. Marty led law enforcement to the cut screen. As we already established through defense's expert, if you're going to create a scene, if you're going to stage a crime scene, you're going to cut the screen and you're going to leave it to be found, aren't you? Marty didn't leave it in the window. Marty took it to his shop, where he showed it to Laura and then told law enforcement about it. If Marty were going to stage this scene to look like a break-in, don't you think he would have left that screen in that window for law enforcement to find, or somebody other than him? No. Marty went about his rounds, doing his job, saw a cut screen, damaged screen, takes it, puts it in the shop. You heard about the issues in Marty's life. He committed suicide 18 months after Anita died. The death of his niece, right after the holidays, which were important to him and his family. No family support around. Losing the love of his life, possibly losing his job too, and where he lived. And a family history of alcoholism and suicide. Wave after wave after wave crashing in on this man. But most importantly, Marty was alibied by Laura Knapp that entire weekend. She testified that they worked in tandem with each other. He'd be fixing something while she was cleaning an apartment. There was never any significant period of time he wasn't with her. And they lived together. Now, you heard the defense experts say that you wouldn't expect somebody to have an alibi witness during their sleeping hours. Do you think that that's true of your romantic partner who you share a bed with? Marty may have had means, no opportunity, no motive. Next, please. The jogger, the running man, as we've heard talked about. This came about because of a description from Becky Ehrman based on a sketch that was released in the media in October of 2008. And shortly thereafter, Adam Raper came forward and said, I think that was me. I would run in that area. And you heard the testimony. He matches the sketch. Possible opportunity, no means, no motive. Next, please. And a lot's been done about Devon Hall. There's been a lot of talk about Devon Hall. Devon Hall breaks into people's apartments. Not going to sugarcoat it. It's what he does. But he is bad at it because he keeps getting caught. And including, notably caught, for a break-in on June 11th on Sioux Street. Clear on the other side of the city. Opposite quadrants. That he was highly intoxicated when he was arrested. His aunt lived in the apartment building that he was arrested at over on Sioux Street. But most importantly, he was not in Minot when Anita was killed. How do we know this? Because of the investigation that was done. He was in Wolf Point, Montana for a graduation. The investigation showed there had been police contact at that hotel that they were staying at because the boys were breaking into the kitchen on the evening of June 2nd. June 3rd, they took the train back from Wolf Point to Minot, corroborated by other people in that group who traveled with him, not all of whom were family, as it was acknowledged. Next, please. And Jerome Vivier. You alibied Devon Hall, you alibied Jerome Vivier too, because they were together in Wolf Point on the day of Anita's murder. No opportunity, no means. Yeah, Jerome Vivier, he's been convicted of gross sexual imposition. So that's a possible motive. However, if you remember the testimony, and you'll also see this from the autopsy report as well that you have, Anita was not sexually assaulted. There was no sign of sexual assault. The victim in Jerome's GSI case was known to him. And when did that occur? On May 20th of 2007. You heard testimony, you heard some evidence that Jerome was at the 101 Club on May 19th, 2007, the same date Anita was. But you also heard testimony that those two arrived over half an hour apart. There was no indication that they had any interaction whatsoever at the club, or that he wasn't paying attention to anyone in particular in the club. There's no indication that he could have found out where Anita lived, that he'd followed her when she left the club to see where she lived, that he'd interacted with her, that he'd looked at her driver's license to see her address, or anything like that. And then the next night, he's raping someone else in Minot. Not Anita. Next, please. So now our last person of interest, Nichole Thomas Rice. Means she had access to the apartment with a key. The murder weapon was found on Anita's bed. Motive, an extremely toxic living arrangement between these two girls. The text messages from Nichole: I'm not going to live like this. What goes around comes around. An opportunity. Statements from her alibi witnesses and her leave large gaps of time unaccounted for. Even the defense's own expert acknowledges that. She can't be accounted for between 11:30 and 8:30. And that this murder occurred right around 5 a.m., right smack in the middle of that window. And that it is only a 40-minute drive from that apartment back to the farm. You heard the officers tell you she was the only person who could not be eliminated as a suspect. And the defense's own expert confirms that as well. She could not be ruled out. Next, please. So we bring it all together, the final pieces of this puzzle. Next. Suspect, Nichole Thomas Rice. The only person who could not be ruled out. The only person elevated from the level of person of interest to suspect. The only person with means and motive and opportunity. Her rendition of events has changed significantly several times during interviews. No reaction. No questions. No concerns. The only thing that she was concerned about was that pink iPod. Declared it missing before even entering the room, according to Sergeant Goodman. And that struck him as odd. But he wasn't the only one that found her concern over this pink iPod, instead of Anita, distressing. You heard that from Goodman, you heard that from Barnard, and you heard that from April. And then we've got the statements to William May and Christina. I did it. I was arguing with my roommate. She was wearing a bathrobe. We were arguing about the alarm clock, and I stabbed her. Next, please. So we're summing up for you what the evidence shows. That the point of entrance and exit was the front door. The deadbolt was in place. A key was needed to make that entry. And more importantly, a key was needed to lock that door behind you. You could not pull that shut and have it lock behind you. It had to be locked with a key from the outside. Wouldn't that just be muscle memory to do that as you're leaving, if you're the person that lives there? Pull it shut, lock it, keep going. And we know it was locked because Laura Knapp distinctly remembers hearing those tumblers click when she unlocked it. And we know that the killer didn't have Anita's keys because Anita's keys were returned to Gordon by Detective Barnard at a later date. They were in her purse. We know the window was not the point of entry or exit. Anita's blood was in the cut on the screen and nowhere else on that screen. Only in the cut from the evidence that you heard, which means that it was made with the knife that was used to stab Anita, which means that screen wasn't cut before she was stabbed, which means that that screen was not the way into the room. You can't go through a cut that hasn't been made. You heard the testimony that there was dust and cobwebs in and around the window and the windowsill, and that this was not disturbed. That's another way you can tell that no one went in or out of that window. The reenactment video shows you that the items in and around the window would have been disturbed, that those dust and those cobwebs would have been disturbed, and also showed you that that screen would have been stretched and ripped in a manner that it was not. You heard tell about the stuff that was underneath Anita's window, that she had things kind of precariously stacked. And you heard the detectives tell you that when they entered the window through that reenactment, they stepped on the floor. Not on the bed, on the floor. Because that's where you go through where that cut would have been. That backward L would have stepped on the floor. All that stuff would have come cascading down if someone had done that, entering through that window. The evidence showed you there were no signs of a robbery or a sexual assault. Her money, her cash in her purse was still there. The photos show you her television was still there. Her phone. All these little items that could have been stolen and taken, nothing's missing. No sexual assault. The evidence showed you this toxic relationship between them, the fish tank that resulted in dead fish, the alarm clock, the nasty text messages, and the installation of a lock on Anita's door so that she could take herself away from Nichole when things got bad in that apartment and put a locked door between the two of them. Next, please. The evidence further showed the defendant had knowledge about that crime scene that she should not have had. The statements that she made to her Aunt Brenda before any information became public or was disclosed by law enforcement to anyone outside of law enforcement. That bowl of water in the bathroom sink. That had been removed when the crime scene was processed before she was allowed to come in. That wasn't there when she was let in by law enforcement. How'd she know it was even there? They never told her about it. Anita having been in the shower before her death. You heard the testimony. There was no physical evidence at the scene that she'd been in the shower. That was pieced together from the text messages that she had with Michael Vann. That she wasn't feeling well and that she was going to take a shower. Anita had been dead over a day by the time that she was found. There's no indication that her hair was wet. Would have been dry by that point. Anita being in a bathrobe in the position of her body. You heard from Goodman, from Strandberg, and from Barnard the process for removing this body. and that the defendant had not been in that apartment before that body was removed. You heard that they later, in the body bag, a dark body bag, you can't see through it. You heard Barnard tell you in detail about those body bags. And that when the notification was done, the identification, they unzipped it just a little ways so that that person making the identification could see her face. Wasn't unzipped enough to see that she was wearing a bathrobe. And then you have the statement to Donna Bjelland about the cut screen. But before I get into that, the bathrobe again. She mentioned that to Christina, remember. My roommate was wearing a bathrobe when I stabbed her. But on to Donna, talking about the cut screen. Again, remember, we know when she talked to Donna, based on the fact that we know when she talked to Sergeant Goodman. Because it was the day after she talked to Goodman, and the Goodman interview was June 11th, 2007. And once again, law enforcement did not tell the defendant about the cut in the screen during those interviews. And that screen was not in the window for her to have seen it herself, even if she was just milling about. And law enforcement was adamant about what they held back in this case. The bowl of water in the bathroom, Anita's body and what she was wearing, her position on the bed, the cut in the screen. These are important holdbacks. And these are all pieces of information the defendant possessed and conveyed to people at times when she should not have had that information. And as you heard the defense's own expert say, the only logical conclusion is that she was there. Next, please. So again, these inconsistent statements to law enforcement and to others. Next. And the confessions. I did it. I was arguing with her about an alarm clock. She was wearing a white bathrobe, and I stabbed her. Ladies and gentlemen, taking the totality of all of this information, eliminating the other persons of interest through investigation, there is only one conclusion to be drawn. Most importantly, from the defendant's knowledge and her admissions. Admissions to friends, and what she told her Aunt Brenda, whose heart was breaking about this. There's only one conclusion to be drawn, and that is that in the early morning hours of June 3rd, 2007, Nichole Rice took this knife and plunged it into the chest of this girl and killed her. The state asks you to find her guilty once you conclude your deliberations. Thank you.
Thank you, Ms. Sorgan. Mr. Sand, do you wish to make a closing argument?
Oh, yes, I do, sir.
All right.
Yeah? Can you hear me all right? Okay. Can you all hear me? Okay. There's been some issues with that, so thank you. First of all, thank you all for being here. I know this is probably the last thing anybody here wants to do. All the time and energy that you guys have expelled, taking a week out of your life, sitting on a case like this. It's a lot of stress, and I'm sure your family and your work lives have suffered for it, so thank you very much. It's important. As citizens, it's important for Anita, and it's important for Nichole. Now, we just sat through over an hour of slides, trying to go through every piece of this case, every piece of testimony, every witness. And I'll tell you, usually when you're a defense attorney, your job is to try to snake through a hole. You got to make things just work right. This case is totally flipped. They just took you through an hour of slides where they had to go through about 300 elements that have to work perfectly for them. All of them have to be true for their case to work. Devon Hall got on the train at the time some guy in Wolf Point said he got on the train. They don't have evidence for that. She's saying that. The investigation showed. The investigation didn't show that. Otherwise, the FBI wouldn't have said Devon Hall was the most likely suspect. But I'll get back to Devon Hall. They talked to you about Marty Enell. Never left Laura Knapp's side, but she's screwing around on him. They never leave each other's sides. That's not true, and that didn't happen. But it has to be true for their case to work. Their case doesn't work. Their own lead investigator, Detective Asham, told you guys she didn't review the whole file. That's not bad police work. That's insane to bring charges when you haven't reviewed a file. They're trying to say this is a puzzle with many pieces. No, it's a murder case. And everybody in here deserves justice. Anita and Nichole, and this isn't how you get it. And I don't mean to yell at you guys. I'm not yelling at you. I'm blown away by what I'm seeing here. I've been practicing law for quite a while. I've never seen anything like this. So we got a case agent. A case agent who didn't review the file. You heard from our expert. I'm going to call him Agent Coons, not our expert. We had to bring in our own expert. I've never done that before because I've never seen an investigation like this. We had to have the entire case reinvestigated at Nichole's expense to figure out what happened here because they don't know. All of their conclusions that they're bringing to you are just the conclusions that they needed to put her in that chair right now. Devon wasn't there. Devon told you, we read the report. I've been breaking into houses since I was here. Oh, it just perfectly lined up that he wasn't on the train. He was breaking in somewhere else at that point. This is crazy. I had Detective Asham on the stand. I said, you're aware he broke into that apartment? She goes, well, he actually broke into 2 that day. Unreal. A detective who didn't read the case file. I've never seen anything like that. It's insane. We discussed in jury selection and at opening that they're going to tell you that this is a murder case based on an alarm clock and nasty text messages between 2 18-year-old girls. I can walk around this town and find all of those people. 90% of the girls in this town are going to have those same issues that go to UND here. This sophisticated murderer sitting right here, Nichole, was able to scrub the DNA out of that place. They showed you the murder weapon. I'm not even going to dig around. You've seen it 20 times. Her DNA is not on it. In fact, the only DNA they have is from a man. Nichole's not a man. This is 2025. This isn't Perry Mason in 1950. They're trying to use conjecture and hearsay to convince you guys that Nichole got out of bed in the middle of the night, drove to Minot, killed her roommate, scrubbed the scene of DNA. She's this mastermind, mob hit killer. Goes back home, has the intestinal fortitude to just go on with life like it never happened. We're talking about a daughter, a sister, a wife, and a mother. This doesn't happen. This is a load of crap. Now, I talked to you at jury selection. I talked to you on opening arguments. This TV show came to town. What a coincidence. The TV show comes to town, and we're getting charges. They came to town for 7 days. They're telling you in their closing that the Minot Police Department's so busy, they can't get things right. And there's a whole heck of a lot more we heard about the Minot Police Department that I'm not going to get into because we don't need to relive. some of the accusations and the things that have gone on with the Minot Police Department. But they bring in a television show for a week, and they're going to blow this case wide open. You heard from Agent Coons, the show came in, it had an agenda. The agenda was to put Nichole in that chair right there, because that's what gets people watching these things, and that's what they care about. They don't care who did this. They care who's watching that TV. You see all these cameras in here. And when this is over, you'll find out a lot more about what's going on here. This is a media circus. And it's a media circus because they can put her in that chair, and these people helped them do it. And it's garbage. And they should be ashamed of themselves, all three of them.
Objection.
Sustained.
I'll back off.
Thank you.
The show comes in, the charges come out. The week-long investigation commences with two people from Hollywood. We're trying to clear your brother Marty. How can we figure that out? We don't consider Devon Hall a suspect. Why? They don't even have the train records. The guy's breaking into houses all over Minot with knives, women's apartments, saying, I've been doing this since I was here. Not a suspect. Because these cameras wouldn't be in here if he was. If the dead guy was the suspect, these cameras wouldn't be in here. These cameras are in here because we can have a nice North Dakota mom sitting there. That sells. And it's disgusting. And it's not our system of justice. It's greed. And that greed's putting pressure on these people. Now, we sat up here for 6 days. And person after person, officer after officer, we heard inconsistent statements. Oh, I don't remember. It was so long ago. I don't remember. Can you show me the report that I never looked at, that I never read before we brought charges? Sure. I spent half my week up here. Yep, here it is. Here it is. This is what happened. You should have reviewed it before you put her sitting in that chair. But when that happens, oh, it's been a long time. It's an inconsistent statement. When Nichole, who comes in for every interview, talks to law enforcement every time they ask her, when she makes a mistake, when she can't remember something just right, she's guilty. We're putting her in that chair. And here come the cameras. She's the only one who's not allowed to have 10 minutes wrong or get interviewed 18 years after something happens and have one element wrong. She came in every time, no lawyer. Not all the other suspects you can say that about. 18 years. She was 18 years old when this happened. That was 18 years ago. They've been interviewing her over and over and over again. Of course they're going to get interviewed for 18 years. But when other people, for their case, for what they need to put her there, when those other people make inconsistent statements, it's forgiven. When the cops make inconsistent statements, when the cops tell you they didn't review the case, it's forgiven. It's madness. I have never sat through a case where I've had to sit here with 7,000 pages. You probably noticed how slow I was going. I'm going through 7,000 pages in my head to make sure they understand what happened because they didn't do the work. The investigation happened in here. The investigation happened with Agent Coons. They didn't review the file. They said that. That's insane. To put somebody sitting in a chair for murder without reviewing the file. On top of not reviewing the file, I'm going to take myself back up here. Detective Asham, did you have trouble gathering the evidence? No, we got all the evidence. Well, I thought you said you had trouble gathering it. I show her a report where Devon Hall says that he came to Minot on the 2nd. On the bottom of the report, it says, this has been recorded and will be put into evidence. Do you have that? No, we don't. You don't have that. That's bad police work at best. You know what it is at worst. The state brought in a bunch of witnesses. It was a cast of characters. The TV show comes out, the phone starts ringing. You have two people who all of a sudden have an admission, an alleged admission. I did it. Everybody's blackout drunk at a party. I did it. One guy's got drug problems. We're more than grateful for his service in the military, no doubt. He's admitted he was in St. Cloud for rehab. They get in touch with each other prior to talking to police after the show comes out. And they say, yeah, we reported this multiple times back in 2008. This is one of the biggest murder cases in North Dakota history. And the cops just ignored that? No, they didn't call in. This is another load of crap. Donna Bieland can't remember when she worked with Nichole. She can't remember where the office is. She says Nichole's parents forced her to clean up the murder scene and then made her sleep in a shed. I was laughing during the testimony. This is crazy. She's sitting up here with Coke bottle sunglasses on and a banker's hat. Like they went off and found her on the street. And they want to put her in prison with that crap? Are you kidding me? They sit here talking about holdbacks. Aunt Brenda, she proved the holdbacks about that trip. Aunt Brenda said the trip was in 2007, 4 to 5 weeks after Anita died. She was totally wrong. She was a year off. Those holdbacks had most likely been given to the press at that point. Michelle Grubb, when she testified, if you can keep all this straight, had said she knew Nichole was stabbed. This stuff comes out in these towns. They're basing all of these holdbacks on this testimony of Aunt Brenda, good old Aunt Brenda. She's not sitting in here right now, I'll tell you that. Aunt Brenda had it a year off, and she was so sure of it. We were going to my son's rodeo in Farmington. We took my husband's plane. You're a year off, Aunt Brenda, sorry. They're asking you to find this girl guilty on 20-year-old hearsay. It's baloney. Think about this for a second. She leaves her family house in the middle of the night, goes in, kills her roommate, who's got a lock on her door. Like Dexter cleans the scene. No DNA. Scrubbed. Nichole lives in this apartment. There's no DNA. Her DNA is not on the knife. Her DNA is not on Anita. And then she texts her after, long after. The state expects you to believe that she did that and came home and went on with her life. You see her sitting here. That's not James Bond. This didn't happen. Then the state's got the gall to ask Agent Coons why we didn't do more work investigating this case. We did a heck of a lot of work. And we have no obligation. We have no obligation to hire investigators and to hire experts and everything else to do an investigation that they didn't do. They admittedly didn't do. They didn't review the files. It's Nichole's job. That's a terrifying thing if you're an American citizen. You got to hire your own police because they're not doing it. You heard from a few witnesses that were law enforcement from Minot back in the day. You heard from Agent Coons. The FBI fingered Devon Hall. He said, that's who we're going to look into. Who's the one suspect that they didn't look into when they reopened the case, when cold justice showed up? Devon Hall. You know why? Because it would have been a problem for them. They wouldn't have been able to get Nichole in that seat. And these TVs wouldn't have been lit up, and people wouldn't have been making millions of dollars. I can't harp on this enough. It's 2025, and we're taking a cold case with no new physical evidence, no genetic evidence, no DNA. When you guys go back, look at that DNA report. Look who wasn't tested. They got male DNA under a fingernail. Read through those names, see who wasn't tested. You're going to be surprised. In their opening, the state's attorney said, crime loves silence. Nichole went in every time the police asked her to come in for an interview. She wasn't hiding from this. There were people that were. What you're seeing here is a totally unprepared police department and state's attorney's office. You're seeing baseless charges, and they're going after an innocent woman because they're pressured. You have no idea what these TV cameras do to these people. And I'm not blasting police. Police are good people. But what you're seeing in this case is garbage. It's absolute garbage. It's insanity. You heard it from Agent Coons. I can't state it enough. They didn't read the file before they charged her. We read the file before they did. They keep telling you that their big issue is this hunch on Nichole because of her behavior. And then you heard, and you'll see it in the transcripts, top of the transcript, Nichole was crying at the scene when she got there. I can't make these police testify to what they said. I've shown them a lot. But that doesn't sound like what they were saying. She's crying. She's not acting stoic. She's crying. They asked her, they brought her into the apartment. Is anything missing? Yeah, my iPod is. Now all of a sudden they're latching onto that. Cops are asking you a question. What's missing? It looks like my iPod's missing. She should have just said nothing and lawyered up. Instead, she tried to help them out. That was a bad idea with these people. People like Nichole don't kill people over alarm clocks. We know that. Toxic roommate. They're telling you, read the texts. Look at the alarm clock. The fish. We all went to college. I went to college. Everybody's been in plenty of disputes with their siblings and roommates. We talked about this at opening and during jury selection. People like Nichole don't kill people over that. I've told you that before. It's true. This is a case based on hearsay and speculation from 20 years ago. I don't think there's anybody in here that doesn't want justice for Anita. She deserves it. There's no doubt, but there isn't justice for Anita in here. Nichole didn't do this. And on jury selection, we talked about guilty go free or innocent go to prison. Nichole didn't do this. The killer's out there, and this needs to be solved. But it's not going to be solved in here today because the work wasn't done. The work had to be done by Nichole. She had to hire ex-FBI agents, a team of attorneys. She had to do that. That's not her job. That's not your jobs. That's the police's job. It's their job to look into the file, to read the file. Not to have a... I can't link anything more to the fact that cold justice came into town and they charged this case more than the fact that they said they didn't read the whole file. They didn't review the file. I'm showing them things they haven't seen before. I showed Detective Asham that train report. She was shocked. Wolf Point to Minot. End of May through June 10th. No Devon Hall on there. Our case is shot. All of a sudden, he slipped a guy at 20. That's what I'm telling you. They just went through all these slides, hundreds of elements that have to work perfectly for them, for this case to work for them. It's crazy. If one of those falls out of place, this case doesn't work. Crime loves silence. Nichole participated all the way along. This is madness. State's Attorney Sorgan told you DNA is everywhere. DNA is in the air. If I touch this, my DNA is there. Not Nichole's. I don't know what, she's got special DNA, I guess. She lives in the apartment. They don't have her DNA. No DNA on the murder weapon. They're so sure of what went on with this scream. Their detectives never saw it. Their investigators never saw it. The only person here that testified it was Gordon. He said it was out in the yard. Marty's dead. We can't talk to him. And then a couple days later, you got Devon Hall saying, I'm coming in and out of the windows, in and out, twice in one day, with a knife. This is terrifying that this case was brought. It's absolutely terrifying. And I used the term abortion of justice, and I know that's a heavy term. I don't like to use that. But that's what this is. This is madness. This never should have happened. We shouldn't be sitting here today. Nichole didn't do this. Nichole Rice, the sister, the daughter, the mother, and the wife, who's sitting here with her whole family right now. It's a ranch family from Velva, North Dakota. She didn't sneak out of her farmhouse in the middle of the night, get Devon Hall's Indian head knife, and stab someone in the chest. She didn't do that. And go back home like nothing ever happened. Just take a step back. Let's walk away from the slides. Let's walk away from 8,000 things that have to go right for us to be sitting here today. All these other people. This is madness. It's a horror movie. I don't think after any of this there's any option to come back with a not guilty verdict. Nichole didn't do this. Thank you guys so much for your time. I know this has been a lot. I know this is a lot out of your lives. This is incredibly stressful. We appreciate you. Nichole appreciates you. Thank you all.
All right, thank you, Mr. Sand. Ms. Sorgan, last word.
Thank you, Your Honor. Oops. Let's not trip over quotes here. Well, I'm glad that Mr. Sand told us that he's not bashing the police, because could have fooled me. I'd like to remind you all of an instruction that you're going to get. What counsel says isn't evidence. What I say is not evidence. Mr. Sand says isn't evidence. Evidence. It's what's on the table. It's what you heard out of that witness stand right there. So I'd like to go through Mr. Sand's points. You heard him say a lot during the course of this trial. This is important to Nichole. This is important. You know who else it's important to? Anita's family, who have been sitting here throughout this whole thing. This is important to the community of Minot. This is important to my office. This is important to MPD. It wasn't just important to Nichole. Now, I do not discount. It is absolutely important to her. I know it is. Mr. Sand told you about, it's got to be like 300 elements. It's got to all line up just for everything to work. That's life, folks. Think about using your common sense and experience. How do things have to line up in order for something else to happen? Every step we take in life leads to something else. He questioned about Laura saying that she was with Marty the entire weekend. The weekend of the first weekend of June of 2007. 18 months later, when Marty committed suicide and they had his funeral, she was with someone else. There's no indication that she was having an affair or that there was an issue the weekend that Anita died. That's a red herring. Mr. Sand wants to continue to harp on that Sergeant Asham didn't review the file. He kept saying, didn't review the file. He left a word out of there. Entire file. She didn't work the entire file because she had a partner, Detective Talbot. They split up the work. That much evidence to go through? One person Can't do it alone. In fact, you even heard the defense's own expert, Mr. Coons. I glanced at some things. I glanced at it. He didn't do a deep dive on absolutely everything in this file. It was his own testimony. Now, nowhere did you hear that the state's theory of this case is that Nichole went to sleep at the farm, woke up in the middle of the night, made a mad dash to Minot, killed Anita. From the timeline that you saw, and from the statement that she gave to her Aunt Brenda, she left the 41 Club in Russo and went back to the apartment in Minot to get clothes, where she encounters Anita. Anita, who thought she had the apartment all to herself that weekend because Nichole went home every weekend. Anita was not expecting Nichole to show up at home. So her bedroom door was not locked. You heard the testimony from Gordon. Anita's bedroom door was open when they went into that apartment. It wasn't closed. And I'd also like to get back to another point about Gordon's testimony. Mr. Sand told you that Gordon told you the screen was in the yard. Gordon didn't know that because Marty had picked up the screen during his morning rounds and taken it to his shop before Gordon showed up. Gordon wouldn't have seen it in the yard. Now, there has been a lot mentioned about cold justice. That they came to town for 7 days. And in 7 days, cracked the case wide open. That's what we just heard. You heard Sergeant Asham tell you that they had the case file a couple of months ahead of time so that they could review everything. They came to town for 7 to 10 days for filming and for some interviews. But that this was a collaborative effort and that cold justice was not calling the shots. Cold justice does not make charging decisions in Ward County, North Dakota. Minot PD doesn't even make charging decisions in Ward County, North Dakota. Mr. Sand kept saying MPD can't get things right because the time couldn't be spared. Yeah, cold justice. Kelly Siegler and Steve Spingola came to town. And you heard the testimony from their own expert. Kelly Siegler, seasoned prosecutor. Steve Spingola was a lieutenant with Milwaukee Homicide. These are people with experience who assisted the MPD in this investigation. These weren't just two random people from Hollywood, not two Hollywood people or Hollywood personas that came in. These are people who actually have worked cases before. Mr. Sand tells you that greed is putting pressure on these people, that there's millions of dollars to be made. Not in my paycheck. Not in Mr. Nelson's paycheck, certainly not in Sergeant Asham's paycheck. The only person that you've heard has any financial benefit from this case so far is Mr. Coons. Got his $10,000 expert fee. It's the only person that you heard has made any money off of this. And you heard Mr. Sand saying, I spent half my week up here going through with witnesses. You're right. On cross-examination, when you were asking them about things that were extraneous to the case. It is not improper to prep witnesses. In fact, that's trial tactics 101. They teach you that in law school. You don't ever ask a question to which you don't already know the answer. So you prep your witnesses, you meet with them. This trial could have been a whole lot longer if we'd have had the witnesses testify to absolutely everything that was in this case file. But we didn't. We had to boil it down to what was relevant and what was important. You've already been here long enough without having to get through that. So he's refreshing witnesses' recollection for investigations that they did 18 years ago. Are you surprised And then he asks you, oh, but they get forgiven for that, for not remembering something 18 years ago when they've worked how many other investigations since then? But Nichole, not remembering something is a bad thing. Okay, let's explore that. If you're the suspect in a murder and you know that your alibi is important, that your whereabouts are important, wouldn't you know that information cold, no matter how many times you're asked about it? And again, let's look at the timing of these interviews. June 4th, 2007, the date that Anita's body was discovered. June 11th, 2007, a week later. Not enough time for a loss of memory. And remember, in that interview, that's the one that Sergeant Goodman said she was not telling him the truth, and he had to confront her on it. May 6th, 2010. Not even 3 years later. And then the last interview, March 12th, 2022. 15 years after the original interview. So the main interviews, when it was fresh and it was new and there was no time to forget. And you would expect her, wouldn't you, to know where she was if she knows that she's a suspect for a murder. Are you going to expect Detective Barnard to remember something 18 years later when he's retired twice and worked how many cases in the interim? Same thing for Sergeant Goodman. Interim. Same thing for Sergeant Goodman. Detective Thompson. A cast of characters. I would like to correct something that Mr. Sand told you. 2 people coming in after, one of whom having drug problems. If you remember the testimony, William May went to St. Cloud for PTSD treatment, not for drug treatment. He tried to make Brenda Glynns out to be a drug addict. She went to a rehab facility to be weaned off of pain medication after she broke her back because she was having seizure activity. And nobody said that Christina or William they went in multiple times to report this. Nobody said that. They didn't testify to that. They went in once. Nothing came of it. What are they to think? Donna can't remember when she worked at eTelecare. I couldn't begin to tell you the start and end dates of a couple of my past jobs. But Donna remembered those conversations with Nichole because they stuck in her memory. Remember what she told you. The level of concern that she had is what ingrained this into her memory. That she was concerned about how this is escalating between these 2 girls. Brenda was wrong about the year on the trip. She thought it was 2007. It was 2008. What's important is that trip happened. And then Nichole confessed information to her during that. And also, Brenda didn't say that she flew to New Mexico. She said she rode with her ex-husband and then rode back with Nichole. So if we're going to nitpick testimony, let's remember it right. Mr. Sand told you this stuff comes out in these towns about the holdbacks, about the information. Yeah, because Nichole talked about it. She told people. That's how they knew. You heard people tell you that she told them these holdbacks. Mr. Sand is correct. The defense has absolutely no obligation to investigate. But they did. And their own expert didn't even really review the file particularly well, did he? He acknowledged several mistakes that he made in that, such as Devon Hall broke into the apartment complex that's the same building as Anita. You heard him admit, nope, I screwed up. I made a mistake on that. I was wrong. Wasn't the same building. You also heard him say he didn't hear the testimony of these witnesses. And he also didn't review prior deposition testimony from them. Mr. Sand told you, look at the DNA report and look who wasn't tested. You're going to have one heck of a time figuring out who wasn't tested. This lab report is 35 pages long. And you will see that Devon Hall's name is in it. He was tested. They got in a sample from him to review against. You also heard that Nichole was crying at the scene in that very first statement. Yep, she was crying. After she'd been told that if she didn't get there, they were going to come get her. After, that's just my crackhead roommate. I'm not dealing with it. Without any information of what was going on at that apartment, not why are the police trying to get a hold of me? Not what is happening at my apartment. Was there a break-in? Is something missing? No questions whatsoever. And that struck investigators as odd. No concern over Anita whatsoever. You've been told this is a nice North Dakota woman who referred to her roommate as a fucking bitch, fucking cunt. Told her family, I'm fine because I didn't really like Anita anyway. And was more concerned about what happened to that pink iPod of hers than about her deceased roommate, who at one point in an interview, she said, she was my best friend. I looked up to her. I wanted to be like her. Mr. Sand told you that Sergeant Asham was shocked by the train report. No, she wasn't. But in any event, you can judge for yourself what Sergeant Asham's reaction to that was. But I would like to remind you, she had a partner. That would be Detective Talbot. She worked the Devon Hall angle. She's the one who reviewed the train reports. She's the one who reviewed that video, spoke with those witnesses who confirmed that Devon Hall was in Montana and didn't leave Montana until that train departed to head to Minot, which did not arrive until 9:20 p.m. on June 3rd, 2007, at which point in time Anita had been dead since 5 a.m. that morning. And again, this was not Devon Hall's knife. Lastly, that was one of the last points that Mr. Sand brought up. Devon Hall, in an interview, said it looked like a knife that he had taken from Jerome Vivier's, but that he had returned to Jerome's house after having it about a day. And Nova Wetsit brought that knife to the police. You heard testimony that that knife, Jerome's knife, that Devon supposedly had, was turned into MPD and placed into their evidence. So it could not possibly be the murder weapon that had been left on Anita's bed, because it was in Nova Wetsit's possession to turn into Minot PD later. So once again, ladies and gentlemen, after reviewing the totality of everything, once again, we urge you to find the defendant guilty. Thank you.
All right, thank you, Ms. Sorgan. Members of the jury, Mr. Nelson, can I have you move the podium for me, please?
Yes, sir.
Just slide it underneath the pole there.
Sure.
Thank you. Perfect. Thank you very much. You will recall at the beginning of this trial, several instructions were read to you on trial procedure, on your duties, and on some of the law to be applied to this case. Those instructions should be considered by you as part of the remaining instructions that I now give. Officer, please don't let anybody in that door while I'm reading these. Thank you. While you are the sole judges of questions of fact in this case, it is your duty to accept the law as is given to you by the court in these instructions, and to apply the law to the facts as you find them to have been proved. You have no right to disregard the law and look for any theory unsupported by credible evidence upon which to build a verdict based upon your notions of what the law is or ought to be. A person who knowingly or intentionally causes the death of another human being, or who willfully causes the death of another human being under circumstances manifesting extreme indifference to the value of human life, is guilty of murder. The state's burden of proof is satisfied if the evidence shows beyond a reasonable doubt the following essential elements. On or about June 3rd, 2007 in Ward County, North Dakota, the defendant, Nichole Rice, intentionally or knowingly caused the death of Anita Knutson, a human being. Or the defendant, Nichole Rice, willfully caused the death of Anita Knutson, and the death of Anita Knutson was caused under circumstances manifesting extreme indifference to the value of human life. A person engages in conduct intentionally if, when he engages in the conduct, it is purpose to do so. Knowingly, if, when he engages in the conduct, he knows or has a firm belief, unaccompanied by substantial doubt, that he is doing so whether or not it is his purpose to do so. Recklessly, if they engage in conduct in conscious and clearly unjustifiable disregard of a substantial likelihood of the existence of the relevant facts or risks, such disregard involving a gross deviation from acceptable standards of conduct, except that awareness of risk is not required when its absence is due to self-induced intoxication. Willfully, if he engages in the conduct intentionally, knowingly, or recklessly. When a person is charged with having been present and with having committed or aided in committing a crime, absence from the scene of the crime is a complete defense called an alibi. Intent may be proved by circumstantial evidence. Indeed, it can rarely be established by any other means. We simply cannot look into the head or mind of another person, but you may infer the defendant's intent from all of the surrounding circumstances. You may consider any statement made or act done or omitted by the defendant and all the facts and circumstances in evidence which indicate the defendant's state of mind. In this case, you have observed video evidence. When considering video evidence, you should evaluate it like any other piece of evidence, and you may consider any facts or circumstances in the case which tend to strengthen, weaken, or contradict the video evidence. You should consider the video evidence using your common sense and experience. The opinion of an expert is based upon certain underlying facts or data. While you need not accept that opinion, you should consider it and give it such weight and credibility as you think it deserves in the light of all the circumstances. If you conclude that the opinion is not based on sufficient education or experience, or the reasons given in support of the opinion are unsound, or the opinion is outweighed by other evidence, you may disregard the opinion. Witnesses who were not testifying as experts gave testimony in the form of an opinion or inference based on having perceived a matter. In deciding the weight and credibility, if any, to be given a witness's opinion or inference based on having perceived a matter, you may consider the witness's opportunity to have perceived the matter, the witness's reasons for the opinion or inference, and all other evidence related to the issue. The weight of the evidence is not determined by the number of witnesses testifying on either side. You should consider all the facts and circumstances in evidence to determine which of the witnesses, if any, are worthy of belief. You may find that the testimony of a smaller number of witnesses on one side is more believable than the testimony of a greater number of witnesses on the other side. Any fact in dispute may be proved by the credible testimony of a single witness. However, before finding any fact to have been proved solely by the testimony of a single witness, you should carefully consider all of that witness's testimony upon which proof of fact depends. A witness, including a party, may be impeached, meaning that the witness's testimony is discredited by contradictory evidence you find to be true, or by evidence that on a former occasion the witness made a statement or acted in a manner inconsistent with the present testimony, or by evidence of conviction of a crime, or by evidence of character for untruthfulness. If you conclude that a witness has been impeached, you may give the testimony of that witness such weight and credibility, if any, as you think it deserves. If you conclude that a witness has been impeached by an earlier contradictory statement, the statement may be considered by you as evidence only if the statement was given under oath, in which event you may determine which is the truth, the present testimony or the earlier statement. If you conclude that a witness has willfully, knowingly, or intentionally testified falsely concerning a material fact in this case, you may wholly disregard the witness's testimony unless it is corroborated by other credible evidence. A defendant has a constitutional right not to testify. You must not draw any inference of guilt from a defendant's silence. The prosecutor cannot mention a defendant's silence, and you must not discuss or consider it. If you find from all the evidence in this case, beyond a reasonable doubt, that all of the foregoing essential elements of the crime charged in the information viewed in the light of the law have been proven, then it is your duty to find the defendant guilty. If the state has failed to establish any of those essential elements beyond a reasonable doubt, it is your duty to find the defendant not guilty. In reaching your verdict, you must not discuss or consider any possible penalty or punishment, as that matter lies with the court and other government agencies. When you go to the jury room, you will select a jury leader. The jury leader will lead your deliberations, communicate with the bailiffs for you, and speak for you in court. The jury leader does not have more authority than the other jurors, and the jury leader's opinion does not carry more weight than the opinions of the other jurors. In order to return verdict, each juror must agree to the verdict. Your verdict must be unanimous. It is your duty to work with each other in an effort to reach an agreement, if you are able to do so without giving up your individual judgment. Each of you must decide the case for yourself, but you should consider the evidence impartially with the other jurors. You should not hesitate to change your opinion if you are convinced it was wrong. But you should not change your opinion about the weight or effect of the evidence just because of the opinion of other jurors or in order to return the verdict. If it becomes necessary for you to communicate with me during your deliberations, the jury leader should send a note to the bailiffs. All questions to the judge must be reviewed by the attorneys. This may take a period of time, and some questions may not be answered. After you have agreed on your verdict, the jury leader should fill in, date, and sign the formal verdict using the appropriate form which accompanies these instructions. The jury leader should then notify the bailiffs that you have reached your verdict. You will be brought to the courtroom for reception of the verdict. You must not disclose your verdict to anyone until it is returned in open court. One form of verdict is submitted to you for finding the defendant Nichole Rice not guilty or guilty of the offense of murder. You will now take this case, try it fairly and impartially between the state of North Dakota and the defendant, and return such verdict as is warranted under all of the evidence and these instructions. Dated the 25th day of March, 2025 by the court, Richard L. Hagar, District Court Judge. Ladies and gentlemen of the jury, I was in charge of your life. Now you are in charge of mine. Can I have the bailiffs come forward, please? Thank you. Can I have you raise your right hands, please? Do you solemnly swear to keep the jury together until they are returned to the court and not permit anyone to communicate with them unless you are directed to do so by the court, so help you God? Thank you very much. You may lead them out now.
All right, everybody. So I thought I had to come in to discuss this case with you guys. I'm speechless at the end of this thing that the state actually proceeded with this case. The parallels. I'll take my jacket off here. The parallels between this case and the Ty Tucker case down in Florida, in terms of the prosecution proceeding with literally no evidence, is startling. But we got to see what happens when you have an attorney who comes in and makes an argument. Now, I would have liked to have seen more focus on. I would like to have seen more focus on the lack of, or more focus on the fact that the state had a burden to prove here, and that the presumption of innocence always lies. First of all, the case begins from that point. And this is the type of case that when you have rumor, innuendo, speculation, hearsay, it's it, and you put that up against the presumption of innocence, and you have the conflicts you have with evidence, the problems you have with evidence, the problems and issues that are present in this case. The presumption of innocence is where we turn to settle those things. And that's what I would have loved to have seen more of a discussion of. Now, I understand the passion from the defense's side is like, this is a case that should have never been brought. This is a garbage case. But it's very important that these jurors, the thing that happens when you have defense attorneys and people that are really involved closely with the case is they forget that these people were not involved that way. These people are not familiar with the justice system. These people don't know how it's supposed to work. And you've got to make sure you educate them on that. Now, I don't know what happened during jury instructions jury selection, and I don't know what the discussions were then. But I felt like, to me, they needed to discuss that, because when you put that up and you say she walked in this courtroom, like in order for this case to work, in my opinion, you have to walk into the courtroom and you have to presume her guilty. And then you have to say she's got the burden to disprove that. So then you put all this speculation and all this innuendo and all these things that have to happen. And that's why when the prosecutor stands up and says, that's just life. No, it's not. When you have buffalo heads that are falling apart, that's not life. That's that's a doubt. That means that when there's a problem there, you don't just say, well, Cybertrucks are falling apart. No, you look at it and you say, is that reasonable? Is that reasonable that we have a witness who says a man meeting the description of Dylan is running from the scene? We have a knife similar to one that he says he had. We have a characteristic about that knife that's present, things that he couldn't have known, things that he acknowledges were true. We have a male DNA on the knife. Now, we can't answer those questions, and the defense isn't there to do that. But because we can't answer those questions, you can't convict her of anything, regardless of the justice you want. Which justice is, again, I think it's always funny how we always talk about this thing called justice. There's no such thing as justice. I saw that discussion, and that's the whole point of this, of why this channel's named what it was. It was my dad's point, because my dad would get asked, how can you represent people that kill people, that do things to children? And isn't that, and he says, no, because they're entitled to a fair process. They're not entitled to get off. They're not entitled to not serve prison time, but they're entitled to a process, a fair process. They're entitled to ensure their due process rights are respected. They're entitled to ensure that the rules of evidence are respected. They're entitled to say that even the most heinous of crimes means the detectives still need to make sure they're following the rules of evidence. They need to make sure that they're respecting your Bill of Rights. They need to be respecting the whole process, and that's what it's all about. So justice isn't the outcome, because it is not justice to have someone convicted under these circumstances. Even if she did it, that's not justice, because this case does not meet the standard needed to reach a conviction. And the injustice of it is that the prosecutors, and time again, we're seeing this in many cases that are out right now, the prosecutors are forgetting that they're not there to win in the sense of a guilty verdict. They are there. A win, it is as much a win for them if they either choose not to charge or they dismiss the charges, because in that sense, they're acknowledging that the case isn't ready for it doesn't reach the level needed to convict someone, and then essentially take away their rights, take away their freedoms, warehouse them in a state prison. Um, well, Kate, we don't know why they did, and that's the problem. Nothing was said about that. But the way it should have been framed by the defense is we don't have to answer that. I didn't like the way the defense attorney handled that DNA by saying you'd be surprised who it was. To me, he should have been talking about whoever it wasn't, who wasn't tested, because that's the question. I mean, this defense team, he can put it off on whatever he wants, 7,000 pages or whatever, and maybe he was trying to look like there's so much here, I have to go through these reports. But to me, this was a case. Look, let's take one of the most high profile cases that we've had, right? And I guarantee you, if this particular attorney was involved in this case, not guilty would be assured 100%. That's the ASAP Rocky case with Joe Tacopina's famous 10 questions for the prosecution. 10 questions for the prosecution. This defense team should have had 10 questions ready to go. They should have had 20 questions ready to go. And they should have said, if you can't answer these questions, every one of these represents reasonable doubt. You need one, not 20. And if you got more than one, it's game over, acquittal, walk out of that room. Because there are so many questions, but they should have had that visual aid for the jury, had that up on a board, and said, and had their slideshows and went through 10 questions to throw back at the prosecutor. They can't possibly answer because they can't. And one of the questions is, whose DNA is under there? And well, yes, DNA isn't dated, but how many prosecutors, can you imagine if it would have been a male defendant sitting over there? They would have argued just like they did you have prosecutors in the Ty Tucker case arguing that inconclusive means something. This case is such a bad case. I mean, it's a wealth of things of how bad it is. Number one, I mean, you've got prosecutors endorsing witnesses that don't even have it right. The Glyns, let's talk about them for a second, right? Because a lot of people are putting a lot of credibility on the aunt, right, and the uncle, and that's what the state is kind of wanting to do, because they're like, oh, why would the aunt and uncle come against her? Well, here's the problem: the aunt doesn't know the color of the robe. It's misses the ball, but misses the ball by a year. A year. We're not talking about a month. We're not talking about a day. We're talking about an entire year. Yet she is so certain. I did like that. He did pound the hell out of her on that. A year, right? A year. So she's completely. And then you go, well, does she have memory issues? Yes, she had medical problems. She went through, and again, the state wants to, oh, you're calling her a drug addict. No, what we're saying is she was involved in something that absolutely affects your memory, whether the addiction, the painkillers that got a hold of her. Luckily, I'm glad to hear she took steps on that. That's exactly what should be happening. It just makes no sense. Well, Babs, it doesn't mean she did it, right? That's the problem. So it's it's just unbelievable. And then on top of that, you've got the aunt, right? And she is remembering things and testifying to things that she never even told the police. Look, this is exactly what's happening with the aunt. So y'all can kind of understand what's happening with the aunt right now. Okay. And again, memory is a very, very, very delicate thing, right? Because memories change, memories can be influenced. There's a wealth, and I mean a wealth of research done on how bad memories are. I remember I took a criminal justice course, and one of the things they did for us, and it was taught by a police officer, and he had us all sit down, and he had someone run into the classroom, right. We weren't expecting it. And then we had to write down what we saw. And it was amazing how, I think I had like 40 or 50 people in my class, how different everyone's eyewitness statements were. We all saw the same thing, but we know that because we were all in the same class at the same moment it happened. But our statements, what happened, what we remembered about it, what he did, what he said, it was so different. And that's just, like I said, when you're talking about memories being remembered or thought of right after something happens. This lady didn't do that. She didn't call the police right away. She's remembering things based on what she sees after she's approached by a documentary who's telling her that they're investigating her niece. We don't know, again, we don't know a lot of background because I'm sure some of that was kept out. But we don't know all the ins and outs of their relationship and what colored it. But what we do know is that whatever she said maybe made her feel uncomfortable, but it wasn't accurate. We don't know what it was, and we can't trust it. It was a year off. The robe was wrong, and the water in the bathroom, as was came out by the defense expert and was brought out by Miss Ash on investigator Asham's testimony. She was given a walkthrough 15 minutes afterwards. That water would have been in the bathroom. Not to mention that I'm surprised, of course, the defense doesn't necessarily need to, but what also could be suggested is what we don't know because Marty's not here. She lived in that apartment. She went back to that apartment. She moved out of that apartment. Are you going to tell me it's not possible that Marty Enell didn't come up to her and tell her what was going on, or that residents or people or Knapp wasn't talking about things? Didn't mention the screen, didn't mention various different things. There were people that knew things and rumors that were circulating. So there was nothing that was truly held back. And you know, it's none of that. All of that is evidence that, yes, if you attach it to something else, physical evidence, DNA, where's the DNA? She leaves the knife behind, right? She's in such a rush, she's going to leave the knife behind, yet she's supposedly leaving, going up to her parents' farm. She clearly would have gotten rid of all the clothes she was wearing. She clearly would have gotten rid of the shoes she was wearing, but the knife, she leaves it behind, right? And then what? There's no DNA of her on that knife at all, of her handling it on a flip knife. Nothing. But there's male DNA on the knife. How does that? I mean, you know, how does that happen? Let me see what some people are saying here. Let's take a look. So what we have here. So Bab says she called Anita B and C after she was murdered. Now, well, and, you know, and look, just because someone dies doesn't mean that the problems they had or the feelings they had. I mean, listen, no one is advocating and saying that this lady is a good person, right? Or a nice person. What we're saying is that the evidence doesn't amount at this particular moment. That does not mean she killed the woman. That's a pretty huge jump to say, okay, well, she went and killed her. I mean, it just doesn't make sense. Even that in and of itself does not make sense that she would, under those circumstances, decide, okay, I'm going to kill her. The other thing that bothers me is they didn't tie in the knife. Where's the proof she ever had a folding knife like that? The only person that admitted that they had a folding knife that was similar was a guy who's breaking into houses all over her community, who is R-ing women all over the community. And the prosecutors are sitting here like, oh, yeah, it doesn't matter. Yeah, on that particular one. And he said he's not good at it. Yeah, he's not good at it. He gets caught. Well, guess what? If he got caught by her in the process of whatever he was doing, that's what resulted in him having to kill her. Right? That means he's not very good. We know that. Dude's not very good. He left his DNA behind. He was just doing what he does. He's not very good at it. Right? And I mean, I don't understand how a jury could even think of convicting her with those type of questions sitting around. Raunchy Dog says she remembered their shocking statements. Yes, she did, but she remembered statements, right? But the veracity of her memory, the ability for her to remember those statements is definitely in question. She forgot. She didn't get key things right. The road color was wrong. The year it happened was wrong. And she was damn sure about it on the stand when she testified, yet it was wrong. And her testimony can't be trusted. You can't rely on that. That's not proof beyond a reasonable doubt. That's a woman who who thinks she remembered something, who thinks something was said, who got bad feelings because, well, she, again, remember, none of this stuff was said, or some of this stuff was not even said until years later, after she realizes that her niece is suspected, or that people are now believing that her niece did this. So she's coming back, and everyone's re-remembering things. Everybody's re-remembering what was said at the party in a drunken state, where she's allegedly, again, what I thought was really solid in a solid point that I hope the jury remembers is why would you go around confessing to all these people allegedly, Yet she's sitting in 5 police interviews, interrogated by the police, and she withstands that. She never once makes a slip up to them. Now, she doesn't keep her story straight because, that's difficult to do, I guess, sometimes. And again, that's a concerning thing. But she doesn't confess. She keeps it together. And then she just goes to parties and just starts talking to everybody and starts allegedly just really freely talking about how she did this. And, just absolutely collapses to the lady who takes her home. She's upset at the party that everyone's accusing her of doing this. And then she goes home and she says, "Oh, yeah, I did it." Why would you say that? This is just stuff that people are remembering and they're hearing and they're wanting to hear these things, but they never heard it. And then over time, as things went, they just decided they heard it. And the fact that if they actually heard it, just thought that they wouldn't have called the police. Now they're claiming they called the police, but where's the report? I mean, is Minot Police Department so incompetent that if they would have got a report on this lady or from these people that said, "Hey, she did this," that they just misplaced these reports? I don't think so. And then you've got, on top of that, you've got all these police officers who are so concerned about the behavior of Nichole Rice at the time of this happening that they let it sit for 15 years. That they didn't have time to investigate a stabbing of an 18-year-old girl in an apartment complex. It reminds me a lot of the Amanda Knox case and the way the prosecutors acted in that case. And they had Rudy Guade, right, who was a known thief, who's going around, who's breaking into houses. But the prosecutor said, no, it was the girl. It was the roommate. They were fighting. They were angry. They were mad. It didn't go quite as far as that case. But that's what this reminds me of. And it all happened at the same time. It's kind of funny. It's kind of chilling because it all happened around the same time that case happened. A few months before she had her situation occur, I believe, if I'm not mistaken. I believe it was 2007. But it's just shocking to me that the prosecutors are going to sit here and ignore the fact that they have a guy who's running around doing these things in their community, and they're not going to think that, oh, this isn't the person who did it. And we're going to think that she goes, and again, the prosecutor wants to say it happened at 1. Their own medical examiner said it happened at 5 a.m. That's when they're saying it occurred. That's when her text messages stopped. And her people, or they accept the fact that she goes back to the farmhouse and ends up at the farmhouse in the morning. But we're to believe that she makes it back to this farmhouse, shows up there after she's committed this crime. No one's suspicious of it. She gets rid of all the clothes. She gets rid of all the evidence. There's nothing in her car. There's no blood in her car. There's nothing. There's no cuts on her fingers. She just goes in and boom, stabs her roommate twice because they're fighting over roommate stuff. It's ridiculous. And then there's no DNA. And there's nothing linking her. There's nothing linking her to the knife or the weapon that was used. And then let's not even get into Marty and Enell. Can they decide where the screen was at? Was it in the window or was it outside of the window? Because one of the things that I recall hearing, and I have to go back and re-listen to the openings, was I remember them trying to dispel the idea that he could have looked into the window and seen this, was because the screen was found 100 feet from the window, and that's where he found it. And that's what the defense expert was remembering. And then the prosecution comes along and says, no, it was in the window. It was in the window. Should they cut it? That's why. Or was it out of the window? Now, what makes sense to me, okay, is I don't think Marty and Enell did this. Here's what I believe actually happened. I think Devon or Dylan, I can't remember, man, I might be getting the name wrong. But I believe the guy who fits the description of the man running away with blood on his shirt, who had the buffalo head knife, etc. I believe that he did this, okay? And I believe that screen was on the ground. I believe that makes sense to why Marty didn't go and knock on the door like you would expect the maintenance man to. He didn't do the things you would expect the maintenance man to do if he observes this screen cut and goes and removes it and doesn't yell. It doesn't say something into the window that's open that he would have seen. and say, hey, ma'am, I'm sorry, I'm taking your screen. I'm not going to say a word about it. I remember when I lived in an apartment, they would put a little thing on your door and say, we did this. Maintenance arrived. They had to. It was in our lease. Don't know what was in their lease. But what makes more sense is that screen was busted out because that guy comes out of the window, busted out. Marty walks over and sees it. Now, Marty, hey, Marty's lazy. He sees this screen. Instead of doing his due diligence and investigating, he takes it, he goes to Laura Knapp, and they go and repair it. Now, what's weighing heavy on Marty's heart? He's thinking to himself, if I would have investigated that more, if I would have found out where the screen came from and looked a little deeper into this, could I have saved that young lady's life? That's what weighed on Marty, in my opinion. That's what weighed on his soul. And he did what he did 18 months later with that memory. And this young man who was going around doing exactly what happened in this case, was seen by an eyewitness. Police have it right there. And look, there's bad blood between two roommates, okay? But there's nothing to indicate that this roommate had access to a knife, carried a knife. Why would she be carrying a buffalo head knife? I love the whole Cybertruck. Oh, yeah, they all fall apart. Oh, they all fall apart, except the one knife that matches the knife that was in this man's hand, who he says he's breaking into all sorts of places and have been in a bunch of places, who was high on drugs, who probably doesn't have a memory of what the hell happened, who gets caught and incarcerated for several, similar things or similar crimes that would fit the bill of what happened here. We just ignore that. Instead, we go after the roommate. It makes no sense. And then on top of that, we have male DNA at the scene, present at the scene, unaccounted for, underneath their fingernails, which is exactly what would account for because she would have been struggling with this individual. Now, what we don't know and what we are unsure of is how did he get in the house? What we don't know is did he lock the door himself and run out? Did he come in and follow her behind her? We don't know. What we do know is that he may have, after this happened, in my opinion, what occurs is he's trying to get out and he doesn't want to go through the front door because he doesn't want to track stuff through the house potentially. And he panics and he cuts the screen and he goes out through it. And he tries to get out through it and he bursts through it. And that would explain potentially why some of these cobwebs and things weren't, because he's going out. He's not going in. So he's not disturbing anything. And he goes out. I mean, he could have we don't know exactly what was going on. We don't know how he would have gained access to her. But what to me is pretty clear is that makes a lot more sense than the idea that for some unforeseen reason she buys a buffalo head knife that matches the guy who's on a crime spree across their community, takes that into the crime scene, and then decides, okay, I'm going to stab her, and that's what I'm going to do. It makes no sense. You don't go stabbing people over roommate stuff. I mean, it's really crazy. So Kate says, if Nichole had said that to the aunt, then why didn't the aunt report it immediately? I would be running to the police. Absolutely. Kelly Stevens says, not guilty, not enough evidence to connect Nichole. More on Devon Hall. Exactly. And Devon is the name. There it is. Kate, probably because NR also told her she had already been cleared. Well, Georgia Jasper says, I'm back and forth with this and that. I wouldn't be able to seal someone's face. Listen, that's the point, Georgia. That's the point, everyone. The whole point is this, is you have to believe beyond a reasonable doubt. One doubt exists in your mind. If you're debating it still, if there's a doubt in your mind, and there is no way in the world that a jury or a juror could go, in my opinion, and say that they don't have a doubt. The state has failed by a country mile to even come close to beyond a reasonable doubt. There's just no way. I mean, and again, I think this is going to be a rather quick verdict. I think we're going to have a verdict tonight. I think we'll have a verdict by 6:30, 7 o'clock. I think it's going to be not guilty because that's what needs to happen. Now, if this jury convicts her, it will be the biggest miscarriage of justice that we've seen in a long, long time, because this is a case that is unfit for conviction. And I know there will be some that think she's deserving of it, and that, due to her comments and her distasteful things that she said. And you know what? Look, That's not why we convict people. We convict people because the evidence is there, and the evidence is not there in this case. Okay, and listen, I think it's sad that the Knutson family has had to live with this being unsolved. I think it's sad that they had to hear that the Minot, however you say it, the Minot Police Department was too busy to take care of their daughter's case. Again, what is utterly shocking to me is that you have these police officers who are talking about how concerned they were with the way this lady was acting. Okay, they have, and that they said, "Oh, we're so concerned that we're going to sit on it for 15 years." That there were all these other cases. I mean, I would love, if I was them, I would be filing a lawsuit and I would be demanding to see what the cases were that were more important than solving a stabbing of an 18-year-old college student in an apartment. What could possibly be more? And that you would allow her roommate, who you believe was so callous and so devious in her actions and behavior, that you allowed her to walk free in your community for 15 years, ready to do this again. What are those cases? I want to see those cases. I want to know what case could possibly be there, because there's no possible way that there's a case that's more important than this case and solving this case. They didn't believe that they had the evidence to solve this case, and they were clearly lazy, and they were probably not fit to do the investigation. And clearly, by the first scene that we saw of this case, which was Attorney Sands talking about what was contained in this report that he received that none of the public has really seen, this 700 or whatever page report that they got from a company that did an audit on this, whatever was going on with this investigator that worked for this police department, an investigator on this case who was doing things to children that were not allowed. I mean, I think we've got our answers here, what the problem was with this case. And it was not, and it's absolutely not because they were busy. It's because this police department was incompetent and corrupt. Kelly Stevens says maybe she had animosity towards Anita. Doesn't mean Nichole left her parents at 4 a.m. to kill Anita. Maybe he was high and drunk. That's what I'm saying. I mean, this guy was out and about. He was prowling houses. He was breaking into houses. What would the motive be of Nichole Rice's ex-boyfriend? Okay, Katrina, let me explain something to you right here. And just to kind of give you a little perspective on what's going on with them. It's not what this is that they, at the time, clearly whatever they heard at the time did not make them move. They did not go to the police. They did not go through hell or high water. They did not tell a bunch of people. They didn't go out and say, "Oh my God, she said this." They didn't even end their relationship with her. Remember, the one friend lived with her for a little while. The boyfriend got back together with her in 2017. Okay, what happens is they go back and they start looking at things, and they're remembering things in a different light. They're remembering things differently now because they're, oh my God, what did she say that? What did she say? She said something about this. And then it becomes, well, and then you get somebody like this outfit that comes in, these two, and again, these are not people without their own scruples in their past as investigators. So we're not getting investigators who have a reputation. Well, the one guy, I don't think there's anything on, but there was one that was a prosecutor that had problems in Texas. So she comes in, they come in, and they got their own motives. So what they're doing is they're like, okay, she's not proven. There's a lot of things being said behind the scenes in these productions that's swaying these people. That's going after the memories. And the problem that you're having here is that when you have a memory like that, you need corroboration, and they don't have it. Just like the aunt who's on the stand making stuff up, on the stand discussing memories. And here's the problem with that. Any memory she's talking about on the stand that's never been spoken before should be completely disregarded because she's got memory problems. She had medical problems. She had a drug addiction. Her memories aren't better today. What she's doing is, with all of this, with the excitement of a trial, with her niece now being in jail, or not in jail, but now charged and sitting in front of the jury, her mind's going crazy. She's remembering all this stuff. Everything looks suspicious to her now. So it's not that they're like, "Oh, I'm out to get her." It's they probably genuinely believe the memories are real at this point. They probably genuinely do, but it doesn't mean they're real. And it doesn't mean they're accurate. And in fact, when you test the memory, which is important, when you test the memory and you test the facts within the memory, you don't just ignore the fact that she got it off with a year. You don't ignore the fact that the friend and her and everybody's saying white robe, it's a pink robe. Well, why is that? Because that's the story that's running. That means these people are watching each other's stuff. That means they're watching the documentaries. They all admitted to watching it. That means they're regurgitating. That means things are going on in their mind. They're hearing things. They're thinking things. That also means that whatever they heard Nichole say, Nichole could have been repeating rumor and innuendo, which is probably what was being said, what Nichole heard, because there was lots of rumors going on around this. Remember, these are the people that are at the heart. They might be talking to a Marty Enell when she's moving out of her apartment. They're talking to people around town. People know she's involved in it. People are giving her information. So everything she's talking about doesn't mean it came because she's there. And clearly it wasn't accurate. At least the robe color wasn't. And then you've got the water by the sink. It sounds to me like she's regurgitating her own thoughts and her own theories based on what she saw. And these people at the time are looking to her like she's an expert and an insider because she was the roommate. But then when they start to think, oh my God, wait a minute. Oh, she knew that. Oh, she knew that. Oh my God, I thought it was just because holy cow. Oh, you mean, and then it all starts to evolve. But the problem is you don't base a whole case on that. And then when there's no DNA evidence, when there's no GPS evidence, there's nothing. You'd think that they would have gone back and tried to maybe get the phone evidence. Hey, was she there? Was she in the range? What time was it? What happened? But the problem is the text messaging and everything. I believe they said, if I'm not mistaken, it was 3 a.m. when those text messages stopped. And I believe they said she would have gone back to the apartment possibly around 1 a.m., which means she wouldn't have stayed there for long, which would mean potentially if Anita is in the bedroom, maybe the point of entry for Devon or Dylan, God, I keep butchering this poor guy's name. Let me get back and look here. But maybe that's the point of entry. Maybe she leaves the front door open. Maybe he slips in behind her. I mean, we don't know. But what we do know is that we don't know, right? The state is not allowed to convict somebody when there's questions, right? The only person in the room, like that's the funny part, right? The only people in the room that have to be sure are the prosecutors in a courtroom. It's the only place. Everywhere else we can speculate, we can argue, but when you go to the courtroom, that's what makes it special. And you swear in a jury, and you're a prosecutor, you have to know. There isn't no, I think I know. There isn't no, I think it's this. It is this. And we have evidence to prove it. And that any reasonable person that walks into this courtroom and views this evidence will not have a doubt. And if there is a doubt, if there is a question, if it still exists when we're done presenting this to you, then it's not guilty. And it's not guilty because you think she didn't do it. It's not guilty because you think she's innocent. It's not guilty because because the defense had to answer who actually did it. No, it's not guilty because there's one question. There's one question still remaining in your mind. That is the standard. And that is what this jury must evaluate this case against. And there is no way, if the jury does that, if the jury actually looks at this evidence in the correct frame of mind that they're supposed to be, that any juror could walk away and say there isn't a question still remaining. This is a case that just is far away from that. And there are a lot of cases that come to, and it's like, hey, there might be that one question or one doubt, and you're thinking to yourself, and it's all about how the jury interprets the evidence. If the jury decides to make a finding of fact. Now, on the other side of this, and this is what the state is depending on, at the end of the day, right, we talk about what it's supposed to be, right? And then we talk about what the state's actually asking the jury to do here. They're asking them to be deciders and finders of fact, and they're asking them to adopt the complete scenario that they have and to say, this is fact, this is fact, this is fact, this is fact. And of course, the judge tells them, you don't necessarily have to disregard a witness like I am and say, well, this witness was wrong about this, so everything's taken out. They're allowed to take a piece of this witness and a piece of this witness and a piece of this witness and say, these are the facts we find to be true. And all of this together is proof beyond a reasonable doubt. It's how innocent people get convicted. But in this case, that's exactly, I don't think we can say that. And I'm not saying that, but I really don't think she did this. And I certainly don't think there's any proof that exists beyond a reasonable doubt that she did this. And this is a case that most definitely should be being sent back out and should be reinvestigated. And maybe, maybe they blew their shot. But Kelly Stevens says too many unknowns, too many persons or interests, and not enough evidence on any of them. And definitely not Nichole. Anita definitely needs justice, but not by convicting someone with little to no evidence. I agree. I think that's wrong. That's wrong. Devon Hall is a most likely suspect than Nichole. Absolutely. And that's the problem. When you have two people that are when you have someone who is still a possibility, and he is still a possibility, that is the definition of a reasonable doubt. And that's why this case should be a not guilty verdict, without a doubt. Hopefully the next hour, maybe 2 hours, that they should be returning with a not guilty verdict and sending her home, and that's it. And I mean, if they need any evidence that she's not going to do anything, she hasn't done anything for 17 years. So there's not a fear that she's going to reoffend. It's not like, she thought she was cleared all the way up till, the TV show comes to town. So, I mean, nobody should be concerned she's going to go out and do this again, because she hasn't. I mean, and the fact that she's not some violent killer going out killing everyone. I mean, you didn't have witnesses that said, "Oh yeah, this lady's been a menace to society." No, we're going to believe that out of nowhere, over whatever the hell's going on in their house, that, oh yeah, she goes out, I guess, to a gas station somewhere, what the state wants you to believe, buys a folding knife, and says, "I'm going to kill her. That's what I'm going to do. We'll kill her." Makes no sense. It makes no sense whatsoever. And there's not one person that puts that knife in her hand. There's not one person that says she carried a folding knife. There's not one person that says, "Oh yeah, I saw her up at the farm, man. She was cutting the chicken wire with it." Nothing. Nothing. Nada. But there is witnesses that put that knife in the hand of a man who's going around doing the big R to multiple women, breaking into houses, burglarizing houses, who's arrested drunk next to a woman, who's a menace. Oh yeah. But the prosecution says, hey, ignore that, right? Cyber trucks have stuff falling off of it, right? It's just a coincidence. No. Coincidences don't amount to proof beyond a reasonable doubt. And it is offensive that the prosecution in this case, and I agree with the defense on that. Listen, I thought the defense did a pretty good job. I felt like there were times they were a little unprepared. I did not like when they got up there with the process, and perhaps it was by design, but I really was disturbed and bothered when they got that lead investigator on, and they should have had everything ready to go to just hit her with cross-examination questions. And they should have had every document they needed, every document to refresh her memory with, everything lined up. I mean, they're sitting in a hotel, for Christ's sake. They knew she was coming on the witness stand. They've been waiting for her for days. They've had this report, and the fact that he didn't have his associates there who should have had a binder that was ready to go. They should have had this outlined and stepped through and known exactly. If she says X, we pull Y. If she does this, they go this. And they could have absolutely done that. And why that wasn't the case, I did not like that presentation at all. Now, maybe, like I said, as he alluded to in his closing, either it was truly by design to reflect to the jury, hey, look at all of this evidence. We're going through this. I'm painstakingly reviewing this report like you didn't do, detective. And maybe that's what he was trying to send the signal to, although I felt like that was missed and it did not reflect that way. Or he was covering up the fact that he knew he looked unprepared and he knew cameras were in the courtroom and he wanted to just give himself an excuse that he could then later say if he wins the case, or even if he loses the case, he could say, well, no, that was all part of the presentation. That was drama. That was what we were trying to make the jury believe here. Georgia Jasper says, why do you all keep asking what their motive to lie is? That's concerning. Your evidence is because somebody said so and they have no motive to lie. That is disturbing because it doesn't matter. Like if they lied, right? And you don't believe people because, oh, they said this or said that. You believe people based on the credibility of what they're saying and how it matches up against evidence and how things corroborate what they said. And when you have old statements, years of old, and again, these are statements that were brought in under hearsay exceptions, under the exception being that these were said against. In other words, these shouldn't have technically come in, but the way they got in was because they were set against. If there's a hearsay exception, it's basically when you say something against your own interest. the court says that's allowed to come in. And that's because the idea is that why else would you be saying this? Nobody in their right mind would say something like this unless it's true. Now, the problem with that is the court's also very specific in saying you're allowed to challenge that, and the jury needs to look at that, and they need to really examine those statements and say, do they match up to the evidence? Is there other evidence? Standing on those statements alone, even the courts say, is concerning, because you should not make a case on those alone. So those statements alone are not going to cut it. They're just not. They were brought in as an exception to the hearsay rules, and they should not be relied upon solely. Now they can enhance other evidence. Now the other evidence they would say in this case was, of course, the one thing is the L cut, which they're saying is significant because it means the killer had to approach this from inside. Now, here's the problem they have. They don't have definitive evidence that she was inside. They do have her saying in her ever-changing statements, where she was pressured to say at one point, well, I might have been inside. But again, there's no definitive evidence she was there. There's no text messages that show she was there. There's nothing, there's no witness that puts her in there. There's not Anita saying, oh yeah, my roommate's in the other room and she just came in and what a bee she is. God, she's really bothering me. There's nothing there to say for certain. So that alone isn't enough even to say, okay, well, yeah, just because that V's there, she wasn't even there. In fact, the evidence suggests she was at a farm. So elsewhere. She woke up elsewhere. She has witnesses that place her there elsewhere the next morning. Not there, not at the apartment. She didn't walk past there, which I was thinking at one point. I was like, oh man, I hope they don't, that could be really bad for the defense if she's going to have to say she went to work in the morning. But then it came out, no, that's not what was going on. She's not a farm. She's elsewhere. She's down the road. She's got witnesses who are, backing that up. And so again, this evidence, these statements that everyone is placing so much on, these statements have to be tested, and they failed the test. They failed the test. Almost every single one of them failed the test in one way or another. The friends, they failed the test of reporting a statement like that. There was no report. There was no corroboration. In fact, there's a body of evidence to suggest, and I'm sure it'll be taken up on appellate court, that the very fact that there wasn't other people, most of the time, one of the tests in bringing in an old statement like that is you've got to suggest that these people told people about it. They don't even have people. There wasn't even people saying they heard it. There wasn't other people. There wasn't. Normally there's a police report or there's someone that says, yeah, this statement came in and she told me that Nichole said this and she was so devastated and upset over it and she couldn't believe it. That's the stuff normally that would come along with this. The judge let it in because there was nothing else. If the judge didn't let those statements in, if the hearsay doesn't come in, this case never makes it to a jury. It wouldn't make it. So Linda Tidwell says, no one has brought up the fact that the victim locked her bedroom door. So according to the prosecutor, Nichole drove from her parents to kill the victim. She knows her bedroom door will be locked. That's exactly right. So why? Well, first of all, no one brings up the fact that what is the moment that drives her to drive to kill her? Where is the text message stream, right? Let's take the Tim Harrington case, right? Which he ends up with a mistrial because one juror said they didn't have a body, right? And in my opinion, I thought that was going to be conviction, right? I mean, I was shocked when I came in because they have text messages on Snapchat leading all the way up to the moment that this guy walks up to his front door. They're fighting, they're arguing, and then the guy disappears. Never hear from him again. And then Tim Harrington's out with a box truck driving all around doing all these things, right? And it's all there, right? Because when it's all happening, and in crimes like this, it's not a premeditated thing that everyone's covering up your communication. This is something that came out of an argument. It came out of, we'd almost say, in a way, a heat of passion, But then this violent act occurs, and then things happen within that violent act, and then you got to classify it, right? But it all comes out of anger. It all comes out of an argument. So there's normally evidence leading up to it that is present that suggests why the person walks up to why she goes back to the house and says, tonight's the night, I'm killing you. Or why she would just stop at a gas station and say, tonight's the night, I'm grabbing that knife. But we're to believe that she's going to do this that night of all nights when she's at home for the weekend and she comes back and she drives back home knowing her door's locked. I guess, comes into the house and just says, "Hey, you know what? I'm gonna stab you. I'm gonna take you out." I mean, what? It'd be more believable if this was the night they were both at home, right? Nobody could come through the door's locked, and they confirm all of that. It's a Thursday night, and then Nichole went to work, and then she had to walk past the window. I mean, that would be definitive evidence that would say, okay, Nichole, how do you explain it? She says, well, it had to be someone else. How did you not hear? How were you not aware of these things, right? That's not what happened here, right? She wasn't even supposed to be home. She wasn't home by all means. Allegedly, she came back and picked up some clothes and then went to her farm. But we know she woke up that next day at her farm where she said she was. We know because her parents said she was there. And, where is it? I mean, like I said, this is just crazy. So Kate says the DNA is the part that got me. That's a huge piece of evidence. Well, it's not really that huge. Well, actually, hold on. Let me ask you this. What, Kate, and again, I know this is late because this was like 22 minutes ago. I'm way behind on the comments. What part of the DNA are you talking about? Are you talking about the DNA in the L of the screen, or are you talking about the male DNA? Let me know. Kelly Stevens, I don't believe Nichole did this. She's being blamed for some teenage arguments that they're using as a motive. What about Devon, who has B&E homes, maybe high? Exactly. Listen, this is eerily similar to the Amanda Knox case. In fact, Amanda Knox, I believe she was into some activism work. If there was a case that she should be commenting on, getting involved in, and adding her opinion to, this would be one, because she has experience in this. And in fact, what would have been just an absolute checkmate move, in my opinion, would have been to have her come in and testify as an expert in wrongful convictions, and she at least had the defense attempt to get her certified as an expert because she went through this. She knows. She's in almost similar circumstances. She had a roommate she didn't get along with. She was having problems with that roommate. She gets accused. There's, DNA being used to allegedly, in a weird way. In this case, it's the DNA in the L of the screen, even though it's a screen that we're not even certain was in the window completely. Because in order to explain why Marty Enell doesn't see the body in the room, the screen has to be out of the window. But if you put the screen in the window, then it becomes, well, why the hell did he not look at the body? Why would you not be knocking on the door? You're going to be sitting there maneuvering your screen out of a young girl's bedroom window while it's open, and you're not going to think to be like, hey, ma'am, are you in there? Hello? Why is there blood on your screen? What's going on? No, he doesn't do that. He doesn't leave a notice. He doesn't put something on the door. He doesn't go get the property manager and say, hey, hon, I found a bloody screen here and the window's open over here and she's not answering. Maybe we should look into this. No. What does he do? He takes the screen and puts it in there. The only way you explain that is that screen is not in that window. That screen is on the ground. He picks it up, he takes it, and that explains what has weighed heavily on Marty's mind, and that is the lack of action at that moment. That he feels like if he would have walked over and investigated where that screen came from and not just have been a lazy ass and taken it into the shop and put it over there and then mentioned it, that he might have been able to save that young girl's life. That makes more sense than Marty being a suspect. I don't think Marty did this. I don't think he did. Even though I think they're, the screen thing, but again, it makes no sense. And it certainly would make no sense that Nichole would even think to be like, let me pull the screen out, right? You're not going to do that. Like that just doesn't make any sense. And what we know is somebody messed with that screen and the police are trying to say whatever cobwebs and there was this. Listen, it happens. He kicks through the screen to get out the window. This is a dude who's all drugged up. He's just killed this girl and he just wants to get the hell away. So he knocks the screen out of the window and goes running down the street, which a witness saw. And there you have it. I mean, the case is wrapped up. The case is wrapped up. And then we said, Georgia Jasper says, what about? Because her DNA was on the murder weapon. Her cell phone places her there. She had a cut on her hand. Her fingerprint was on the window. Which case are we talking about? Are we talking about the Amanda Knox case? Because I don't, that is not this case. Or her hair was on the bathtub. Roughneck 8403. Minot. Oh, that's how you say it. Okay, I got you. And Alex Machado says there are rumors her dad paid people off. Minot PD was corrupt as hell. Her dad should have been on the stand. Okay, all right. Well, I mean, all those things were not presented at trial. Obviously, we can't comment on that. If that's stuff that was going on, you'd think the prosecutors would have put them on the stand. If they could prove that somebody was paying someone off, you'd think they would put them on the stand. I've said a lot of unsavory things about my ex-mother-in-law. She's still alive, and I will still be saying unsavory things about her after she dies. Well, exactly. That's what I'm saying. Those are not things that prove anything beyond prove that she did anything. Stephanie Fisher says, I'm convinced Nichole is responsible. However, the defense attorney is charismatic in a way that will help them believe that there is doubt. His aggressive and naturally defensive style. Stephanie Fisher, the doubts raised in this case go far beyond the charismatic personality of the defense attorney. While I do agree with you, he was very charismatic, but he actually was charismatic and had some reasonable doubt to argue to the jury. The state just did not meet the burden in this case. And Stephanie, please explain to me, what is it about, what evidence in this case do you believe proves beyond a reasonable doubt? I'm not saying that that it would be wrong to consider her a suspect, or even to say she's an uncleared suspect at this point. But to say that she did this beyond a reasonable doubt over Hall, how would you say that? There's just no way. Nichole had DNA on a knife. I know very little about this case. I'm deep in the Cementilli one, but I thought unknown. No, yeah, that's correct. Nichole did not have Nichole's DNA was not found anywhere near that scene. So I believe that might have been civil psych. I think that might have been being talked about when I brought up the Amanda Knox case, potentially, because that is not this case. She had no DNA on anywhere. The only DNA found on the knife was Anita's. The only DNA that was conclusively found anywhere was Anita's. There was a male DNA characteristic that was found, but it was unfortunately unable to be, it was not a large enough sample size to be able to be matched to anyone. They could only develop the profile as male. So it wasn't, so I think what the defense was alluding to was saying that they were not able to eliminate anyone because the male DNA was not enough to be tested against anyone to conclusively rule anyone out or rule anyone in. And that's what the DNA expert said. Alex Machado says, I've known Nichole for many years. The only people that know her know she has a quick fuse when it comes to anger. She is more than capable. Well, Alex, I understand. Maybe she's more than capable. But here's the problem, Alex. What was the fuse? What lit the fuse? What puts her there with her that night in the apartment? Did you know, and maybe you can answer this question. Maybe you should have been on the stand. Did you know Nichole to carry around folding knives? Do you know if she had a reputation for carrying around folding knives? Because the biggest problem in this case, in my opinion, was the lack of ability to put the folding knife anywhere near her, and the fact that the folding knife matched and was admitted to match a man who's going around committing breaking and entry, committing B&Es and big R's and victimizing women all over that community, and is caught for it. Is not just suspected of it, but caught for it, charged with crimes relating those things. That's just too big of a coincidence for me to say, hey, yeah. I mean, maybe Nichole had a huge temper. Maybe she had a temperament that wasn't great. But guess what? Here's the thing. That doesn't mean that temper is going to lead her to go stab a roommate. That's a pretty big jump. I mean, that's a pretty big jump. Maybe punch her roommate. Maybe we're not talking, if she was being charged with that there was some sort of assault that led to Anita hitting her head or something, that would be that might make sense. But this is a little more than that. Civil Psych says, what is the physical evidence against her? Anything besides bad? That's exactly right. There is none. Kate says, at Alex, when I was younger, I had an awful temper, but not once did I ever harm anyone. Having a temper doesn't mean you have it in you to take someone's life. That's right. That's a far different thing. Well, all it takes is one time, Alex. That is correct. But the point is, there's, we need to see the evidence that she was the one that did this, and there isn't any. Right? One time means when you lose your temper, we have to believe that she's going to have had something left behind there. And again, where's her DNA on the screen? Where's her DNA on the knife? Where's her DNA anywhere on the scene? There's none. Where is it under the nails, which is where this male DNA was found at? Wish fulfilled state says, I'm afraid she's going to. Why are you afraid? Wish fulfilled state. This is what's supposed to happen when the state comes with a bad case. This is why I think it's funny. Everybody gets mad that a defendant walks, and they get mad and they act like the justice system is blamed. No, the justice system worked. This is justice, believe it or not, because justice is the process that reviews a case like this and says it didn't meet the standards, and everyone should cheer it, because what it means is it makes the system get better, right? Try to put this in my boys. When we make a mistake, when we fail, we learn from it, right? Now, when we let the police get away with blaming the justice system or claiming it was a loophole, the system doesn't get better. The system gets better when we look at this case and we realize, how did we get here? Either A person that was guilty walked because something was missed or the case wasn't as airtight as they thought it should be. Let's figure that out. Or B, they went after the wrong person. And how did it lead to that? Who did what? Who missed what? Who ignored what? And how did we get here? And that's what's more important to walk out of this case with as she walks. It's not to say, oh, she got away with it. That's the wrong approach, because the process worked. Now we look at what it tells us. We look at the result and what that tells us. And just like if she gets convicted, we're going to do that, right? There's an appeal process. And I believe there should be that process even in an acquittal. But there should be a review, appellate review of the process, because there's things that are left when you have a not guilty verdict. There are questions, there are things, there are investigations that should be done. The case shouldn't just end there. It should be required to move on. It should be assigned different investigators, and there should be a report that has to be issued by the state attorney's office on exactly where they went wrong, and that should be given to the family. And that is how it should be solved. And it's either this is what we found and we think we had the right person all along, so this case will be closed. It will be closed with a not guilty, but this is why we believe the not guilty occurred. This is what these were the doubts that were raised. This is what we looked into. Or B, we looked into it and we acknowledge, hey, we made a mistake here. And these are how we got here. And these are the things we did to correct these things. And this is what we're going to do to rectify. We're going to go after another person. We're going to go charge this other person. We're going to go do this. That's what should be happening here, not attacking the defense attorney for doing a good job of raising doubt in a case that was riddled with reasonable doubt. And maybe we don't like that guy because of his attitude, but I didn't like the way the prosecutor acted this morning. I didn't like the way he ended his cross-examination of that witness by asking him if he was going to put this, what a self-aggrandizing question. Are you going to put this up? Well, maybe he should, because you know what? I don't think that guy did a terrible investigation in this case. He raised a lot of good things. And, he did a hell of a better job than the lady who was more worried about probably covering up the affair she were having than actually investigating the case, and that actually took the time to read the report and to say, no, I didn't read the report. And you're going to sit here and tell me, oh, sorry, that's why we have two investigators. No, what? You got to be aware of the entire case file and all the evidence. How are you supposed to make conclusions? How are you supposed to figure out your case? You're meeting with that other investigator, I would hope, but you've also got to be aware of everything that's going on, because it's the entirety of that file that drives your investigation. When you're unaware of half of your investigation, that's how we end up in the place that we're at right now. I mean, that was just some insanity talk right there. Sorry, guys, I hit the wrong button. I was trying to click on a comment and I clicked into the courtroom. So nothing going on right now that I can tell from the courtroom perspective. Jury is still deliberating. I think we'll have a verdict today, but I'm not certain. Bridget says, I'm shocked that the defense didn't bring in any witnesses to corroborate her whereabouts during the ever-changing timeline the defendant provided. Well, here's the thing, Bridget. I think the defense, listen, I was a little concerned as well, because I think the defense should have brought in some stuff. I think they should have brought in more. And I think they should have really just, I know there are cases where you say, okay, I'm going to rest on the burden of the prosecution. Problem was, they didn't talk about the burden of the prosecution that much, in my opinion, when you're doing that. They just talked about, this is a garbage case and we're leaving it at that. I feel like they should have done, if they were going to do what they did in the way they went in there and just absolutely say this is a garbage case, it should have never been brought. They should have went forward and they should have called Devon to the stand, and they should have and I thought they were going to call Marty Enell's best friend to the stand, the heavy in the heart. statements. Maybe they didn't. Maybe they didn't need to do that. But I was under the impression they might do that. I think they should have brought witnesses that would have said, "Hey, I've never seen Nichole with a folding knife before. Never saw that she had anything like that on her." I think that would have been good. But you know what? The problem is that all of that invites other stuff to come in. And then it also invites the jury to start seeing that you're trying to prove something. So then the jury loses sight of the fact that the defense has no burden of proof, that it is the state that has to prove everything. So I think the defense looked at it as, we brought in our expert. The expert literally got to have what I thought was kind of somewhat of an unprecedented discussion with the jury, saying, giving them the roadmap to the reasonable doubts in the case, and said, hey, we get to end it right here. And then we're going to end it with this expert. We're going to walk you through the reasonable doubts. We're going to close on it. So we're going to have an expert tell you, and then on the same day, we're going to get to close on that day. So I think they looked at it as like, this is the way we want the case to end, because they didn't leave the prosecution with much to rebut. So I'm not 100% shocked that they did what they did. I feel like it might have been, I was hoping we were going to see more. I'm damn glad they didn't put her on the witness stand. That would have been the stupidest move of all time. So that I'm glad about. But I think the defense did a good job in this case. I mean, besides what I thought was the appearance of being unprepared with a couple of witnesses and unable to find things in what I thought should have been, they should have already had these things. These were not complicated witnesses. These were not like Simontilli witnesses that went on for days. And you see in that, the defense gets up and they're ready. They're hammered. Bam, bam, bam. And this is talking about days of, and some of these witnesses in the Simontilli case have had days of direct or days of cross. And those attorneys are ready to go. I just didn't like it. But again, I cannot say that it wasn't, we can't rule out, just like we can't say beyond a reasonable doubt that this wasn't by design, because there was an inference by the defense attorney that was by design. All right, I'm going to take one more. I've got to step out again. I'm going to try to go through here. Let's just see here. All right, let's pick up here. I haven't got a chance to put Lieutenant Dan up. So Lieutenant Dan says the defense attorney is a scumbag. I'm watching this back, and his attacks on the prosecutor, making fun of a witness's glasses. Who does that? A desperate attorney. Well, Lieutenant Dan, no, I think you have to look at the context of him doing that. Who takes a case to trial with these type of witnesses? Okay. These prosecutors should have never taken this case to trial. And the fact that, and again, remember, every attorney who's in that courtroom has a responsibility to the truth. And they have a responsibility when they know something isn't true, or if a case it shouldn't be brought. There's their responsibility to not go forward with that case, to not go forward and bring a case that shouldn't have been brought. In this case, should never have been brought. So what you saw from him, it's perspectives. Piers, Lieutenant Dan, you're coming from the perspective that you liked the prosecution's case and felt it was a good case. So you're going to take offense to that. Anybody out there who looks at this case, and I'm one of them, I'll admit it, who says this case sucked, this should never have been brought, I understand what he's saying. And then I think the witness he pulled out, I felt kind of the same way. I mean, you bring this woman in, she looked like somebody out of, what was it, in Better Call Saul? Remember the brother who had the light, if some of you might have watched that, who had the light sensitivity, I mean, this lady comes in with her damn hat and her sunglasses and all that stuff. I mean, it looked ridiculous, but I think it was really, and then she's sitting here saying apparently things we couldn't even appreciate how ridiculous they were, which was that allegedly she was made to sleep in the barn of her parents' house and that they made her go clean the crime scene up or whatever, which was, things that the defense attorney obviously had a knowledge about, things that we didn't have. So for him, he's listening to this lady's testimony. He's thinking, this lady she didn't know what the hell was going on. She couldn't even name where they worked. She couldn't tell what year they worked together. She didn't know any of it, but she's claiming to remember all these things crystal clear. And then the things she's remembering are just so absolutely off the wall that it goes along with her ensemble that she comes into the courtroom. Of course, do remember as well how she arrived at the courtroom. She delayed court for nearly 30 minutes because she was lost trying to find the courthouse. And they had to send out the witness coordinator to go get her. So, I mean, I think that was just indicative and just an example of the pure asinineness of the state's case. Their witnesses what they were relying upon. And I think it is absolutely disturbing. And those prosecutors should be ashamed of themselves to put on a case like this, to put a case before the jury, because what they're having to do is twist things. They're having to twist the evidence. They're having to stand up there and they're having to make arguments to the jury that are not in good faith. They're trying to win a case. They're not arguing good evidence. They're not arguing a good case. This is one of those situations where these prosecutors say, man, and I've heard this from prosecutors say to themselves, one of the things that's a sign that they're a good attorney or good prosecutors, if you can convict an innocent person, right? You can take any fact and make it. And some will say, hey, especially if there's plea bargaining discussions going on, where, they might say, well, listen, I take that to a jury. I'll make it sound how it sounds. I'll take an argument. A lot of people don't understand the power of what they're trying to do in the closing arguments. That's why I found it funny when the ASAP Relly, I think it was the ASAP case, there was recently a prosecutor that was just complaining up and down that the defense was, about what the defense was saying in their closing. Yet and then the prosecutor went back and very liberally were taking much liberation with their own facts and what they were telling the jury. And the idea is that, look, what the attorneys are telling the jury is not evidence, and they rely on that. And many judges let prosecutors go way off the rails, and they give them the instruction, the admonishment. What they're saying isn't evidence, and it's like a prosecutor that knows how to use that can run the distance on it. They can, as my dad used to say, not just run through the door, but kick the door and just keep running until the judge stops you. And then when the judge does stop you, the jury's heard all of it, and the judge is just going to say, well, now here's an admonishment that what the attorneys are saying isn't evidence. It's not evidence, but it's certainly telling the jury how to interpret that evidence. And guess what? Because a lot of jurors aren't taking notes, and some courts don't even allow jurors to take notes, how the prosecutor tells them to remember the evidence certainly plays into the memory they're going to have of the evidence and what they believe the evidence to be. So it's very, very powerful tool. And in this case, that is what the prosecutor is hoping to do here, is twist, turn, and tell them something like the deadbolt. Like that. She's hoping that there's going to be a juror back there say, see, that's it. Yeah. Remember, what's her name heard the deadbolt lock. That means that door was deadbolted. That means there was no one, only someone would keep. Well, yeah, somebody had to deadbolt it, which she's saying, oh, that's muscle memory. So who left that door? That had to be her. Boom. And since the window could have only been entered, whoever left had to have already done this. And they had to have keys to the apartment. And they couldn't have deadbolted the door. Well, not necessarily completely true. Okay. Because it's also possible that Anita, right, deadbolted the door because she let someone in, or she brought someone to the house, or someone came in and she didn't know they were there, or someone snuck in and they didn't know they were there, or someone left the door open and then they deadbolt the door before they go do whatever they're going to do. And then Anita has the door open because she went to the bathroom, and then that person's hiding in the bedroom. And then she goes in and she shuts her door, or the door was open, right? Because I think that's what her dad said. So she goes in and comes out of the bathroom, and this guy goes after her, and they get in a struggle, and he tries to hold the knife to her, and she resists, and he stabs her twice. And then he goes, oh my God, I gotta get the hell out of here. Shit, I just killed somebody. And he goes over and he tries to, get the screen. Now they're saying that the screen had to be cut from the outside, right? But you know what? I don't think there's really any way to say for certain how it was cut or what was going on. Unless he was trying to, so I don't know, we don't know, but that's of course the implication. And he goes through and boom, or maybe he tried to cut the screen, or he comes back or whatever. I mean, again, that's the implication. So I think that's going to be, if she gets convicted, and we'll roll back to that. If she gets convicted, I think that there's going to be the acceptance of that. That's what the prosecutor is going to have argued to this jury, is going to say, someone's going to say the door was deadbolted. The screen could have only been cut from the outside. And somebody says, well, he kicked the screen and well, he couldn't have done that. And then they're going to say, well, we don't care where the knife came from. The knife had to come from her. It's not our job to figure out where it came from. It's just our job to say it was there. And that's true, right? They're only deciding who killed her. I mean, it is a potential doubt that can be raised, but the jury can dispel it and say, well, she could have had it. She could have had that. She could have had that because her dad gave it to her. She could have had this. It could have just been a coincidence. But all we know is whoever did this had to have been inside the house. And there you have it. Now, for me, I believe, that this was a scenario to where he kicks the screen out. He's trying to put it up, and he cuts it from the outside because he's trying to get it in, and he's trying to close the window. He can't get it up. He just throws the screen and he leaves. That's a possibility. To me, that makes more sense. That would align with why that screen would have gotten cut, because he was trying to put it back in. So he thought, well, I'll cut the screen and try to get my hand in there to try to get the screen to fit it. And then realizes as he gets the screen up, and this is what I'm thinking, he tries to get the screen up. So he's trying to get his hand in there to close the window, because he doesn't close the window before he puts the screen back up, because he kicks the screen out. So he puts it up and he cuts it. And that's why it was cut in a way that says, well, it doesn't really make sense someone was coming through. So he's cutting the screen to try to get his hand through to bring the window down. Can't do it. And then just ends up throwing the screen on the ground because maybe he sees somebody or hears somebody or says, I just got to get the hell out of here. I can't figure this shit out, and leaves and runs and out he goes. And that's as likely to me as it is, makes a hell of a lot more sense than the idea that she's going to do all of this and think, oh yeah, let me set this up and let me cut this screen and let me do all the, like, what? It makes no sense at all. Makes no damn sense. No sense. So, that's where we stand on this. So hopefully, my prediction is, I hope we'll have a verdict by 7, which would be 6 o'clock their time. Now, maybe, I don't know if this judge is going to let them deliberate late. Maybe they will, maybe they won't. I don't know what their terms are. I know, like, for instance, the, when we were dealing with the Levesque trial, the judge, it was a hard stop at 4. It didn't matter. So perhaps that'll be the case. That'll be the case in this case. But anyways, I've got to jump off here. I will be back, to talk about it if a verdict comes in, or at least I'll try to, depending, especially if it's a guilty verdict, because I want to definitely get my 2 cents in and say exactly how I feel about that guilty verdict, but also talk about if it's not guilty, because I think the system definitely worked here, because this case is not one that deserves a guilty verdict. Absolutely not. There's too much doubt. There's too many problems. There are too many questions. This case needs to be rejected by the jury. It needs to be sent back out, and there needs to be, again, whatever they're doing down there with that police department that was responsible for this investigation. They need to go down there and they need to add this to the list of things that need to be reviewed and needs to be improved. That's my perspective. Anyways, I'm going to send this back to the courtroom, guys. I appreciate everyone that's watching. I appreciate all the members that have showed up in the chat. I appreciate everybody that's shown up from the Simontilli case, even though we're on a break. I'm going to continue. I have a whole slew of things to put out to keep us watching for the Simontilli case. I finally got done with the no break editions, and we're going to be, for the next 2 days, we're going to be getting the backlog of Simontilli testimony back out, so everybody is up to speed on that as we move towards the conclusion of that case. So we'll see. And it's 12:27, 21:27 there. So I guess what is that? 9 o'clock, I guess. Yeah. I think, yeah, 9 o'clock. So yeah, you're if it comes out at 7, then what would that be? That would be about 11 for you. So hopefully it doesn't go much later than that, Kate. But again, they could cut for today, because remember, there's an hour. They are an hour behind where I'm at. So right now it's only 4:28. So I would imagine at about 6, we'll find out whether or not they're going to be going into the evening for deliberations, or if the judge is going to say, look, go home, get some rest. And I am quite certain we'll have a verdict tomorrow. If the judge were to send them home, there's just no way in the world I could think that they wouldn't. But anyways, in the meantime, guys, keep checking back. We will have the verdict when it comes out. And, very much appreciate everyone. And I'll be talking to everybody soon. Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage commentary, and legal analysis. This content is presented under the fair use doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.